We're going to get started. Calling to order this morning's evidentiary hearing for docket number 2020-0142, application for approval of Miko Kahana Solar Power Purchase Agreement. Good morning. Thanks everyone for being here. My name's Jay Griffin. I'm the chair of the Hawaii Public Utilities Commission. And with us today virtually are Commissioner Jennifer Powder, Commissioner Leo Sunsian. This is the hearing for docket number 2020-0142, which involves the Commission's review of an application for approval of a power purchase agreement for renewable dispatchable generation between Maui Electric Company Limited and Kahana Solar LLC. This is not a public hearing. The Commission is here to receive evidence from the parties and participants to this docket and will issue a written decision following the hearing and post-hearing briefing. I would like to briefly introduce some of our Commission staff. Caroline Ishida is here. She's our Chief Counsel. Mark Kayatu is the attorney working on this docket, our supervising attorney. Dave Parsons, our Chief Policy and Research, is running the WebEx with assistance from our Head of IT, David Takashima. Thank you all for your help and support today. In recognition of the emergency proclamations in place related to the COVID-19 pandemic, this hearing is being held virtually through WebEx. The Commission previously provided the parties and participants with an opportunity to test WebEx on September 1st, 2021 at the pre-hearing conference, which is also held through WebEx. The Commission has also provided the parties and participants with procedures for troubleshooting any technical issues that may arise during the hearing, which was reviewed at the pre-hearing conference. We appreciate everyone's cooperation and understanding as we adjust to the virtual nature of this forum. The Commission is recording this hearing, is making it publicly available on YouTube. Following the conclusion of the hearing, the Commission will confirm the availability of the recording on YouTube and notify the parties and participants via letter filed in the docket. As noted in the pre-hearing conference order, the filing of this notice regarding the hearing recording will begin to toll the deadline for filing post-hearing briefing. It is critical for those listening via the live stream as well as for those who listen to the recording to be able to hear clearly what each hearing participant is saying. Please, no disruptions that would interfere with clear recording the hearing. As noted in the Commission's pre-hearing conference order, the provisions set forth in that order shall govern the hearing and post-hearing schedule. Can we please have the appearances for the parties and participants representatives, starting with Maui Electric?
Good morning, Chair, Commissioners, and members of the Commission staff. Brian Piane and Marissa Owens appearing on behalf of Maui Electric.
Thank you. Now the Consumer Advocate.
Good morning, Julia Verbrogi here on behalf of the Division of the Consumer Advocacy, along with the Executive Director, Amy Sheen.
Thank you. Now Kahana Solar.
Good morning, Chair Griffin and Commissioners and Commission staff. Doug Kodaga and Mark Ito on behalf of Kahana Solar LLC.
Thank you. And now West Maui Preservation Association.
Good morning, Chair. Ryan Hurley, along with my co-counsel, Bianca Asaki, on behalf of West Maui Preservation Association.
Great. Thank you, everyone. As noted in the pre-hearing conference order, there'll be no opening statements or direct examination by the parties and participants. Instead, parties and participants will have had the opportunity to file pre-hearing statements of position, which are publicly available on the Commission's document management system. The Commission reiterates its strong preference to not close any portion of the evidentiary hearing from the public, which would require temporary suspension of the live streaming on YouTube. Accordingly, the Commission does not intend to close any portion of the hearing unless pursuant to the case Oahu Publications Inc. versus On, the closure serves a compelling interest. There's a substantial probability that in the absence of closure, this compelling interest would be harmed, and there are no alternatives that would adequately protect the compelling interest. Just a few housekeeping matters before we get started. The Commission tested WebEx with the parties and participants on September 1st at the pre-hearing conference to ensure everyone's familiarity with this platform. In addition, all of you should have received copies of procedures for addressing technical difficulties at the hearing, which provide instructions for addressing any technical problems you may have. Mr. Parsons will be hosting the WebEx hearing and the point person for any problems. In the event you have any during the hearing, please follow the instructions you're given. And you can contact Mr. Parsons by calling the dedicated phone line the commission has set up for this purpose. Mr. Parsons will also be assisted by Mr. Takashima. Similar to facilitate a timely start of the hearing, commission opened the WebEx at 8:30 today. We plan to do so again tomorrow. And we'll be taking breaks during the proceeding at the discretion of the presiding officer. We plan for a 1-hour lunch break, but we'll see how things are going. And we intend to adjourn for the day at 4:30. Again, any lunch breaks or recesses are at the discretion of the presiding officer. A reminder to the witnesses, please speak slowly and clearly, and please respond to the questions verbally so that the recording can capture your response. Please avoid talking over, interrupting the examiner, so all questions and responses can be clearly heard by the commissioners, commission staff, the other parties and participants, and those listening over the live stream. We're going to go over the examination order, and then we'll get started. So first up will be Maui Electric's witnesses. And for each witness, we'll start with cross-examination by the consumer advocate, then followed by Kahana Solar, then West Maui Preservation Association, questions from commission staff, and then questions from the commissioners. Next up will be Kahana Solar. They'll start with cross-examination by Maui Electric, then the consumer advocate, then West Maui Preservation Association, and then similar order for the commission staff and commissioners. Next is the consumer advocates witnesses. They'll be cross-examined by Maui Electric, then Kahana Solar, then West Maui Preservation Association, followed by commission staff and commissioners. And for West Maui Preservation Association, first up will be cross-examination by Maui Electric, then the consumer advocate, then Kahana Solar, and then again, the commission staff and commissioners. As stated at the pre-hearing conference, opportunity for redirect examination and recross examination shall be requested orally during the hearing, subject to the presiding officer's discretion. And further, friendly, cumulative, or repetitive cross-examination is prohibited. And with all that, we're going to start now with Maui Electric's first witness. So could we please have Greg Shimakawa identify yourself here on the WebEx? Good morning. Hi, Greg. How are you doing? Okay.
Good morning, Chair. Good morning, Commissioners.
Yeah, we're gonna. I'll administer the oath. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, great. Thank you. Let us proceed then. The order examining will start with the consumer advocate's examination of Mr. Shimakawa.
Thank you, Chair. Good morning, Mr. Shimakawa.
Morning.
You are the manager of energy procurement in the Renewable Acquisition Division for Hawaiian Electric, right?
Yes.
And in addition to filing direct testimony, you sponsored IR responses in Docket, right?
Yes, that's correct.
Let's look at one of the responses you sponsored, MECO's response to CA RIR1 filed on July 28, 2021. Chair, would it be easier if I share my screen with the witness?
Yes, please go ahead. And just again for the group, I believe we gave instructions on both our pre-hearing conference and the order on sharing the exhibit. So thank you.
Okay. Sorry, I have to minimize some things. Okay, Mr. Shimakawa, thank you. Do you see in front of you CARIR1?
Yes, I can see it.
Great. I'd like to direct your attention to subsection B, please. And I will read the question out loud. Subsection B says, assuming that the company acknowledges that there is room and or need for improvements to better address community concerns, please clarify whether it is the company's position that the commission should accept that sufficient actions have been taken for this project to meet the existing requirements, but that the company will work towards modifying the community outreach and engagement requirements to mitigate community concerns in future projects. Do you see that?
Yes, I can see the question.
Thank you. So I'm going to scroll down to section B to your answer. So let's take a look at your first sentence. In B, you respond, yes, the company believes that sufficient actions have been taken for this project to meet the existing requirements of the commission approved RFP. Do you see that?
Yes.
Thank you. There are still community concerns about this proposed PPA, right?
Yes, that's why we're here.
And is it your view that all the community concerns have been addressed?
It's my view that Kahana Solar has met the requirements set forth in the RFP for this project.
And what is your basis for
And
that view? Oh, sorry. Please go ahead. Sorry.
Based on the requirements set forth in the RFP and as well in the PPA to follow that Kahana Solar has met all of those requirements.
Okay, thank you, Mr. Shimokawa. And let's take a look at your second part, your second sentence in subsection B. I'm going to read it out loud. Starts with further. Further, just as the company incorporated lessons learned from stage 1 into the development of its stage 2 RFP, the company will continue to build on experience gained from prior procurements as it develops future RFPs. Do you see that?
Yes.
So I'd like to ask you, are there any lessons learned from stage 2 thus far as to community outreach?
Yes. So the company is continually learning from experience, and I think a big lesson that was learned and the improvement that's been made for future procurements is the more detailed instructions for community outreach that in the stage 2 RFP were provided later in the process at the priority list, I believe, time. And going forward in future RFPs, that more detailed information is being made available as a part of the RFP package. So that's an example of an improvement that's been made.
Okay, thank you, Mr. Shimokawa. And so I was wondering, what about going forward? Have you learned any lessons from stage 2 or stage 3 going forward as a community outreach?
I'm sorry, that was an example of something that's being implemented going forward. So in stage 2, that information was provided not as a part of the RFP in the beginning, but was provided later in the process, and now it's being provided with the RFP to begin with.
Okay. Okay, thank you. I have no further questions.
Okay, thank you. Now we'll turn to Kahana Solar.
Thank you, Chair. No questions for this witness.
Great, thank you. West Maui Preservation Association.
Yes, thank you. I'll be doing the cross-examination. Mr. Shimokawa, this is there's mostly a series of yes or no questions, and I can put up documents that reference it as we go through if you don't understand the question. My first question, or my first series of questions, is about bid negotiations. So was the list of bidders in the final award group redacted from the final version, or from the public version of the independent observers report for the Maui RFP selection process?
Subject to check. I don't have that IO report in front of me, but I believe that's correct.
Okay. And do you know if because we only saw the redacted version, do you know if the number of unsuccessful negotiations was also redacted?
Yes, again, subject to check, I believe so.
Okay. And could you tell us how many unsuccessful PPA negotiations occurred for Maui?
No, that's confidential. That was one of the reasons why that information was redacted.
But that was not redacted from the Oahu version of the independent observer report. Is that correct?
I would have to check the Oahu report.
Okay. So this is, my next question is about the non-price factors. Can you tell us, or where did Energex fall in the range of non-price factors? Or maybe the question should be, is that information in the record?
I'm sorry, can you clarify what information you're asking?
Oh, is there anything in the record or in that docket 217-0352 that shows where Energex, like how it was rated for each of the non-price factors?
Are you asking if that was filed publicly?
Yes.
No, it was not.
Okay. And my next question is about the guaranteed commercial operations date, or more specifically, the non-appealable PUC approval date. You testified that projects that don't intend to meet storage requirements have until December 31st, 2025 to operate, and those that do intend to meet the storage requirements have until April 30th, 2023, correct?
Yeah.
This means the company negotiated to give more time to projects that intend to do less, correct?
The earlier date in the RFP was timed to coincide with the need for a replacement for Kahului power plant.
But so that means that the people that don't intend to meet the storage requirements have less time.
So the development cycle for a project takes a number of years, and recognizing the need to address the Kahului power plant retirement, the decision was made to set an earlier date, understanding that an earlier date and an accelerated schedule would have its own cost and benefits and price impacts, for example. So an earlier date was set for that, for the projects that were to meet that requirement, as opposed to a more normal development timeline that was set for other projects not intended to meet the storage requirement.
Okay. Will those commercial operations date, will they change depending on the date of the final non-appealable PUC approval?
The commercial operations dates, depending on the provisions in the PPA, which Ms. Deha Matsushima can discuss in more detail in her testimony, there may be provisions to adjust the guaranteed commercial operations date depending on the results of the interconnection requirements study.
I'm sorry, the guaranteed commercial operations date changes depending on the
results of the interconnection requirement study.
Okay, so, okay, got that. And so, okay. Do the guaranteed commercial operation dates, they presume a certain range of timelines for all permits and approvals, correct?
That's correct. The schedule is set by, and the timeline is set by Kahana Solar.
Okay, yeah, and these are, I've tried to make them just yes or no so we can get through them. I have quite a bit more. Under your force majeure clauses in the PPA, your testimony is that MECO and Energex have not discussed if COVID may be a force majeure event, correct?
I believe that's what my testimony says at that time. I'll defer further questions to Ms. Deha Matsushima's testimony.
Okay. Are you aware that HECO and Napua Makani sellers on Oahu claimed COVID as a force majeure event in regard to the Kahuku Wind project?
I'm not familiar with the those negotiations or those.
Okay, my next question. Under this PPA, neither party would be liable for lost bill savings due to a force majeure event, correct?
Again, I will defer PPA related questions, details of the PPA to Mr. Matsushima's testimony.
Okay. And I thought this was part of your testimony, but is it possible that labor disputes qualify to trigger the force majeure clause?
Again, the same response. I would refer that to the other testimony.
Okay. And is MECO aware that Canadian developers in West Maui have been found in violation of work authorization laws related to non-local laborers working for less than prevailing wages?
I don't have any knowledge of that.
Okay. And for reverse auctions, this is something that was suggested by the consumer advocate. Would you agree that utilizing a reverse auction process would likely increase the public's awareness about project sites before projects are selected?
I think it's difficult to say how a reverse auction would play out. I think there's a possibility that a reverse auction could provide more certainty about sites, but that's something that we've considered before and are open to considering in the future.
Have a significant amount of community concerns about utility scale projects been place-based, meaning they're associated with features of the location of the project?
I'm sorry, can you repeat or refine that question?
Have there been, of the community concerns that you've heard expressed about utility scale projects, have those concerns been place-based or related to the location of the project?
Some of the concerns that we've heard have been related to location.
Could addressing concerns during a site selection process assuage community perceptions that outcomes are predetermined?
There are opportunities, I believe, to look at different ways to structure a future procurement. Yes.
And could that assuage community perceptions that outcomes are predetermined?
I don't think I can speculate on
Okay.
community.
So this is on decommissioning, which I know is both in the PPA and in a general plan that we haven't seen. So in your testimony is that MECO has been improving and still has room for improvement in regard to community outreach, correct?
Yes, in general, I don't have that testimony in front of me, but that's the idea.
Should community outreach include addressing concerns raised by nearly everyone interviewed by Interjex's consultant?
I'm not sure what you mean by addressing concerns. I think it's important that interested parties are given the opportunity to have their concerns heard. I don't know if it's realistic for everyone's concerns to necessarily be resolved.
You know, okay, so I'm going to keep this, most of my questions, actually pretty much all of them are yes or no. So you can say yes, no, I don't know, and your counsel can always ask you to expand on redirect. So my next question is, are you aware that Interjex represented that nearly all of those interviewed raised questions about decommissioning of the project and what that entailed, especially for the panels and batteries? Are you aware of that?
No, I would have to check.
Is it correct that the general decommissioning plan is not part of the record?
I'm subject to check. I don't have that in front of me.
Does the decommissioning plan, and you can just say I don't know because maybe you don't, but does the decommissioning plan that MECO has, does it include a specific amount for decommissioning bond requirements?
I don't know.
Okay, and so you just have not read this, the decommissioning plan that MECO has for the project. So I'll stop all my questions on this line.
I'm not familiar with what you're referring to.
Okay, then that is all of my questions. Thank you.
Thank you. Now we'll turn over to Commission Counsel.
Thank you, Chair. Mr. Shimakawa, I just have a few questions. I believe earlier in your cross-examination, you indicated that the guaranteed commercial operations date may change based on the results of the interconnection requirement study. Is that correct?
Yes, and I qualify that with I don't have the PPA in front of me. I'm not referring to the specific term that was negotiated.
Oh, so what were you referring to then?
I'm sorry. In general, that's how the PPAs are structured.
Okay. I know earlier you'd also mentioned that some of the PPA terms itself are going to be the subject of Ms. Deihoff Matsushima's testimony. Would she be better to ask about the specific provisions of the PPA regarding the GCOD?
Yeah.
Okay. Thank you for that clarification. I don't have any further questions for Mr. Shimakawa, Chair.
Thank you, Mr. Kaitsu. Now, questions from the commissioners. Commissioner Sunsian.
Thank you, Chair. I just have one to clarify based on the CA's cross-examination. We talked about, right, improving the process for community outreach. I think you gave an example, Mr. Shimakawa, where it was, if I recall, it was from like phase 1 RFPs and how community outreach was structured in those RFPs and PPAs eventually, and then moving to phase 2, which is where we're at right now, right? We haven't gone through like even a phase 3 yet. So the example you provided, was it from a phase 1 RFP PPA and then moving forward into phase 2, and that's where it was incorporated into the RFPs for phase 2? Or is it a phase 2 that you've learned it and then it's just been implemented as we go through the phase 2 process?
Thank you, Commissioner. I apologize if I was unclear in my previous response. The example that I gave was a process improvement that was made from stage 2 and going forward. And so it's just in the timing of the sharing of that, further detailed information is going to be provided earlier in the process going forward.
Okay. All right. Thank you. That's all I had, Chair.
Thank you, Commissioner Sunsian. Commissioner Potter.
I have no questions for this party. Thank you.
Great, Mr. Shimakawa. I just have a couple follow-ups too, and it's on the same topic Commissioner Sunsian asked about on the community outreach and your response to the consumer advocates questions. And so just to clarify, I thought I heard two different things. You gave the example on process improvements that were incorporated into stage 2 based on stage 1, correct?
No, I'm sorry. I'm not being clear, I guess. The example I gave was something that from stage 2 is going to be improved going forward in future RFPs. CBRE
Okay.
stage 3.
All right, that's helpful. But how about, can you further elaborate on stage 2? Kind of what you saw are the additional requests asked of developers. Let's start there.
Sure. So related to the example that I gave, so that further information was not was not even provided in the stage 1 RFPs. The more detailed information on community outreach, the media contacts to include, examples of how to structure a presentation. Those things were not a part of the stage 1 RFPs, and so the provision to include that information, to have more clarity about what happens from the time of a project is selected until a PPA is in place, those details were clarified and improved between stage 1 and stage 2.
Okay, and those were requirements for every project on each island, correct?
Yes, that's correct. Those PPA requirements were in the models, and the RFP updates between stage 1 and stage 2 were across all islands.
And how would you characterize, because you have responsibility across all the islands and insight into all the projects, correct?
Yeah.
Based on your, how would you characterize the effort, the level of effort here with this project relative to the other projects on Maui, and as well as the other projects throughout the Hawaiian Electric service territories?
I can give a high-level response, and I'll defer to Ms. Martin's testimony later on. But in general, the effort and the outreach that was provided by Interject for this project was very strong.
Thank you, Mr. Shimakawa. I have no further questions. You're excused. You may be subject to recall later. Thank you for your time today.
Thank you.
Next up is my amicus witness number 2, Scott W.C.H. Lee. Please identify yourself here in the WebEx.
Good morning, Commissioner. This is Scott Lee.
Good morning. We're going to administer the oath now. Thank you. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Let's proceed with the cross-examination by the consumer advocate.
Thank you, Chair. I don't have any questions for this witness.
Kahana Solar.
Thank you, Chair. No questions for this witness.
Okay, thank you. West Maui Preservation Association.
Thank you, Chair. We do have a few questions for this witness. Good morning. My name is Ryan Hurley. I'll be asking the questions on behalf of West Maui Preservation Association, Mr. Lee. Is it true that you performed the production simulation modeling for MECO?
Yes, that is true.
And MECO previously testified that, and I quote, "The production simulation modeling is reviewed by other Hawaiian Electric employees before being utilized in the project benefit analysis." Is this correct?
Yes, that is correct.
Now, also, is the project benefit analysis reviewed by anyone after it's performed?
Yes, it is.
Great. And does that review differ than the other review for the production simulation modeling?
It's similar to the other production simulation modeling that we do within our department.
And what does that review consist of?
It consists of reviewing the outputs of the model, double checking everything was running properly. There were no anomalous figures coming out of the model.
So I'm sorry, who does that review though?
In the analytical planning services department that I'm in, there are other planning engineers that also conduct the review, as well as it gets passed up the chain.
So how many people would you say review the project benefit analysis before it was submitted as part of the PPA?
Offhand, I don't know exactly the number of people, but within the department, there are at least 10 people that will take a look at something before we send it out.
Okay, and is that documented in any way?
I would have to check on that. I'm not sure.
So one final question regarding the modeling. Are there any policies and procedures detailing the quality control analysis that MECO performs in relation to the modeling?
Do you mean, are there any publicly available policies or internal policies?
Either or at this point.
Yes, we do have some internal procedures that we follow for reviewing and checking.
But those are not made available to the public?
I do not believe we have external policies for that.
Could they be made available to the commission if they desired?
I'm not sure.
Okay, great. Thank you. I'm going to move on now. I just have a few questions about the net energy production. Can you please verify that the NEP is provided by the developer?
Yes, the NEP was provided by the developer.
And MECO takes the provided NEP on, I quote, face value. Is that correct?
We take the NEP from the developer for our model that they provided, yes.
So, and now the first official check or verification of the NEP is the NEP estimate, which is done prior to the close of construction financing. Is that correct?
I believe that part is outside the scope of my testimony. I may have to refer that to another witness.
Give me 1 second. Let me just verify this before. So this comes from MECO response to WAMPA MECO IR 16. Was that not a question that you sponsored?
Can I take a look at that IR?
Give me 1 second.
IR.
Mr. Hurley, do you want to share it?
1 second, Chair. I'm trying to find it myself, but yes, I will share it if that's easiest. Or if people want to just pull it up themselves, that's fine. I can read it specifically.
Mr. Lee, do you have access to it yourself there?
Yes, so I believe I'm sponsoring part B of the response to WMK MECO IR 16.
Okay, great. So the part A is, just so I know, is that Rebecca?
Yes, Ms. Matsushima.
Great, thank you so much. I will defer that question to her when it comes up again. Let me just, I think that might be it. Let me just. Okay, so just a few follow-up questions. Is it possible to run the production simulation model without the NEP?
No, it is not. That is one of the inputs to say how much energy that the project will be producing within the model.
So it would be correct to say that the NEP is a critical piece of information used in the production simulation model and therefore the project benefit analysis.
Yes. Yeah.
And once again, just reiterating that MECO takes the NEP on face value from the developer initially, correct?
Yes, that is correct.
Thank you. I have no further questions for this witness, Chair.
Great, thank you. Now, Commission Counsel.
Thank you, Chair. Just a few questions, Mr. Lee, and if these are better suited for another witness, please let me know. I believe earlier you, during cross-examination, you indicated that you were responsible for a lot of the modeling and estimates for the benefits of the project. Is that correct?
That is correct.
Okay, and this would include the estimated bill impacts that are expected or estimated to result from the project?
Yes, that is correct.
Are these estimated benefits premised on the assumptions that were used in the modeling, such that if those assumptions did not actually occur, the estimated benefits would shift as well?
Yes, if we change the assumptions for the simulation, then the benefits that will come out will change.
Can you give me an example of certain types of assumptions? An example of certain types of things certain changes in assumptions that could affect those benefits?
I think anytime we change an assumption, the exact number will change. There may be some smaller updates that do not change the directional answer for the analysis, but there may be some larger assumptions that change, such as if we add or subtract one of the main must-run generating units on the island, that would really have a big impact on what the cost savings may be.
Would delays in project development affect was that a key assumption that would affect the benefits?
So a delay in the project may change some of the results of the savings. However, over the course of a 25-year PPA, that delay may be only a small change.
Can you be a little more specific when you mean small?
Because of the PPA term is 25 years, depending on how long of a delay the customer benefit may change.
Okay. Are the estimated benefits from this particular project with Kahana Solar contingent in any way upon any of the other IPP projects currently being developed on Maui?
Can you repeat that again?
Yeah, I guess I'm just wondering. So when you model the benefits for this, are baked into the assumptions, is it assuming that some of the other projects that are currently being developed for Maui Electric, that they will come online according to their respective schedules, such that delays in bringing those online would impact the benefits that are expected to come from this project? Like, does this project stand alone in the benefits it's expected to bring to customers, or is it related or contingent upon, timely development of other projects on Maui Electric system?
For this project benefit analysis that we submitted in Exhibit 3, it does, it is, sorry, it is mainly a standalone analysis. So it had the base case without the project and the alternate case with the Kahana Solar project in it.
Okay, thank you. Aside from the 69 kilovolt transmission line that's expected to be needed to interconnect the project to my electric system, are there any other infrastructure needs or projects that will be needed to interconnect this system safely to the Maui Electric grid?
I believe that's outside the scope of my testimony.
Who would be better to address that to?
For transmission upgrades, I believe I may have to ask one of the attorneys who the appropriate sponsor for that is.
Okay, I guess I'll just keep asking the witnesses, and I'm sure someone will have an answer for me. All right. Those are all the questions I have for this witness at this time, Chair.
Thank you, Mr. Kayatsu. Now turning to the commissioners. Commissioner Sunstein.
I have no questions, Chair.
Commissioner Potter.
Good morning, Chair. I have a few questions for Nico here. Let's see. I was curious on what the reaction of HECO and was to the CA's and recommendation for a reverse auction process, where you do the IRS in advance in order to streamline the process. Has that been taken into consideration yet as among your workforce?
Oh, sorry, the IRS is outside of my area of expertise.
Okay. Let's see. This one probably will be too. Let's see. So I just want to confirm with you that the GHG emissions, there was a reduction in the GHG avoided emissions at 100 to 1,445 million tons of CO2, and so that was a decrease or an increase in avoided GHG, but there was also a reduction in kWh and the energy capacity. So can you just confirm why that is?
So for the results from the GHG analysis, I believe Dr. Abigail Kirchhoffer can answer details for that analysis.
Okay, great. Thank you. That's all the questions I have, Chair. Thank you.
Thank you, Commissioner. Mr. Lee, I just have a couple follow-up questions to Mr. Kayatsu, and this has to do with the impact of delays. Right, so you're responsible for the project benefits analysis.
Yes.
Fundamentally, that's a you do a net present value of the project benefits.
That's correct. We take a differential analysis, differential NPV between a base case and an alternate case to get the analysis.
So due to the way the discounting works, if we add time on it to the end of the term, that's much more highly discounted than the near term years. Is that an accurate representation of the methodology?
Yes, that is correct.
So in effect and the impact of delays are more heavily weighted in the near term versus the out years.
Yes, that would be true.
Okay. And it's not a 1-for-1 trade. A dollar saved next year is the same as 25 years.
Yes, that is correct.
Okay, thank you. No further questions for the witness. Next up is Maui Electric witness number 3, Mr. Lau. Can you please identify yourself in the WebEx?
Good morning, Chair. Good morning, Commissioners.
Good morning, Mr. Lau. I'm going to administer the oath here. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Let's proceed with the cross-examination starting with the consumer advocate.
Thank you, Chair. We have no questions for this witness.
Kahana Solar.
Thank you, Chair. No questions.
Okay. West Maui Preservation Association.
Thank you, Chair. Ryan Hurley here once again. Just one question, I guess, or a short couple questions. Mr. Lau, is it correct to state that MECO used 2 different years, both 2019 and 2020, for the forecasted sales projections in its production simulation modeling for Kahana Solar?
No, that's not correct. 2 different years were used in the RPS analysis that were filed in the application, as well as in my exhibit, MECO 301. But the production simulations used 2019.
Okay, great. Thank you for clarifying that. I appreciate it. So focusing then solely on the RPS analysis, you did use 2 years, both 2019 and 2020 then, correct?
Yes, that's correct.
And why did you not use both 2020 years for that?
So we had used, in the RPS analysis, we had used the 2019 sales forecast to be consistent with the same sales forecasts that were used in the production simulations in the cost-benefit analysis. Because we added Molokai and Lanai sales to calculate the consolidated sales as part of the consolidated RPS impact, we used the latest sales forecast that was available at the time, which is the 2020.
So to be correct, you used the 2020 forecast for Molokai and Lanai, but you used the 2019 forecast for Maui. Is that correct? Is that what you just confirming? Sorry.
Correct.
Would it be correct to say that there's likely a substantial difference in the 2019 forecast than the 2020 forecast for Maui? Due to the COVID-19 pandemic is honestly where I'm getting at with this.
Right. It's difficult to say for sure. We did forecast, the COVID impacts, and the recovery from the COVID impacts was part of both of those forecasts.
But given they are 2 years apart and given the huge events that have happened in that, is it safe to say that they differ significantly?
I don't believe so, especially in the context of, us using the sales forecast, over the term of the PPA. Both forecasts are expected to recover, both sales and both forecasts are expected to recover from COVID.
So I apologize. So the 2019 forecast, that fully incorporated, that had a COVID-19 recovery in it? You forecasted that the COVID-19 recovery in the 2019 forecast then, is that correct?
Subject to check. Yeah, sorry. I guess I'll have to check on that.
Okay, but curiosity, when does the forecast come out?
The 2019 forecast came out in December.
December of 2019 or 2018?
2019.
So, okay, so the 2019 forecast came out at the end of 2019?
Correct.
So the 2019 forecast is for 2020 then, just to be, I'm sorry, I'm just making sure I understand everything right.
The 2019 forecast was from December 2019. The 2020 forecast was filed as part of our IGP inputs in March of.
Okay, so just broadly speaking, could you have rerun the whole simulation, RPS simulation, using all 2020 numbers when you input the Lanai numbers, Lanai and Molokai numbers?
Yes, we could have.
And you
But
chose that.
I'm sorry. I think given that we just needed, for the consolidated sales, we just needed an estimate of Molokai and Lanai. We elected to just add that to the same sales that were used in the cost benefit analysis.
Okay, so I mean, but it is like using apples and oranges at that point, right?
I guess I'm not sure what you mean by that. Could you rephrase
It's okay.
that?
I withdraw the question. But just confirming, you had the opportunity to rerun using all 2020 numbers, and you chose to use both 2019 numbers and 2020 numbers for the final results. Is that correct?
For the RPS analysis, we had chosen to use the 2020 forecast for Molokai and Lanai. That's correct.
Okay, thank you very much. I have no further questions.
Thank you. Mr. Kaitsu, Commission Counsel.
Thank you, Chair. I guess I just have one question for Mr. Lau. I'm not sure if you're watching, but in my question to Mr. Lee, who preceded you, I had a question about any other infrastructure or projects that might be needed aside from the 69 kilovolt line to interconnect the Kahana Solar project to Maui Electric System. Are you a person to ask about this?
No, sorry. I think that's outside of the scope of my testimony.
All right. Okay. Thank you, Mr. Lau. No further questions, Your Honor, or Chair.
Thank you, Mr. Kaitsu. Commissioner Sunstein.
I have no questions for Mr. Lee. Thank you, Chair.
Thank you, Commissioner. Commissioner Potter.
Hi, thank you. I just have, I think, one question for you. There was some concerns about the community benefits funds going to the landlord who happens to be own the large land, up in Lani and Poco. I'm reading from the wrong. I'm sorry. I'm like reading from the wrong. That was not you guys. Sorry about that. I don't have any questions, Chair. Thank you.
Thank you, Commissioner. Mr. Lau, I have no further questions either. Thank you for joining us this morning. MECO witness number 4 is Rebecca Dehoff Matsushima. Ms. Dehoff Matsushima, can you step forward here on the WebEx? Hi.
Good morning, Chair.
Good morning. I'm going to administer the oath here. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Let's proceed with the questioning, again, starting cross-examination by the consumer advocate.
Thank you, Chair. Good morning, Ms. Matsushima. How are you?
Good morning.
You're the director of the Renewable Acquisition Division at Hawaiian Electric, correct?
Correct.
And in addition to submitting direct testimony, You also sponsored several information request responses for Maui Electric, right?
Yes, that's correct.
Okay, I would like to ask you a question about one of your responses. And if it's okay with Chair, I would like to share my screen. It is MECO's response to CA MECO IR 35D. Sorry. Okay. So we're looking at D, subsection D, and I'm going to read. In subsection D, the question is a company open to engaging in informal discussions, mediation, settlement discussions, or alternative dispute resolution processes in a good faith attempt to resolve differences with WMPA? Do you see that, Ms. Matsushima?
I do.
Okay, thank you. I'm going to scroll down to your response. And you state yes. The company is open to engaging in informal discussions, mediation, settlement discussions, or other alternative dispute resolution processes in a good faith attempt to resolve differences with WMPA. Let me stop right there for now. Do you see that, Ms. Matsushima?
I do.
Could you explain why the company is open to engaging in informal discussions, including mediation, to attempt to resolve differences with WMPA?
I'm sorry, could you repeat the first part of that again? It broke up a little.
Sure. Could you explain why is the company open to engaging in informal discussions, including mediation, to attempt to resolve differences with WMPA?
The company is always open to discussing community concerns with members of the community. So, that's always something that we are open to do.
Has Maui Electric engaged yet with WMPA in any informal discussions to address WMPA's concerns?
Not to my knowledge.
Okay, thank you. Even after this hearing is over, would Maui Electric still be open to engaging in discussions or mediation with WMPA?
I think, subject to I'm not sure if there's any rules against that, with the open proceeding, but yes, we would be.
Okay, thank you. Those are all my questions.
Thank you. Next is Kahana Solar.
Chair, we have no questions for this witness. Thank you.
Thank you. West Maui Preservation Association.
Hi, Ms. Matsushima. Ryan Hurley here with West Maui Preservation Association. I have actually a number of questions for you, so I'm just going to get into it. I've tried my best to narrow these down to yes or no questions. So in order to get through these quickly, let's try to do that unless we have to. Absolutely. Would I be correct in saying that the project proposed consists of a 20 megawatt photovoltaic system paired with a lithium battery ion energy storage system? The PV system will consist of approximately 90,000 high efficiency PV panels mounted on a fixed tilt or single access tracker. Is that correct?
Subject to check on the exact numbers, yes.
Absolutely, and just to be clear, I'm in no way trying to slide anything under here. So always, subject to check on specifics of the exact numbers. If I get 1.8 billion kilowatt hours wrong or whatever, is it correct that the NEP represents the theoretical annual energy delivery of the facility's PV system to the point of interconnection, with a probability of exceedance of 95%? Is that a correct statement regarding the NEP?
Yes.
And MECO takes this NEP once again on face value during the commission proceedings. Is that correct?
Yes, because we provided for checks throughout the process.
I'm sorry. So, but do those checks? When does the first check of the NEP occur then?
Prior to the completion of construction financing.
And is it still Maui Electric's understanding that they do not know when construction financing will close?
Yes, I don't have that exact date right now.
So, but generally speaking, when does construction financing on a project like this close?
It depends, but usually, prior to construction.
But you can't really verify that, can you?
Well, Kahana Solar would be best to speak to the timeline, but we work with the seller, and there's, I believe, I have to check, but I believe there is a milestone for financing set forth in the PPA.
So to be clear, though, Kahana Solar has the option to make the PPA null and void at that check. Is that correct?
Yes, they do.
And was this term negotiated by Kahana Solar, or is this included in the standard PPA by Maui Electric?
It's included in the standard PPA.
So, but it's your assertion here today that at the close of construction financing, construction will not have begun on the project.
I can't say that for sure. You'd have to check with Kahana Solar.
So let's assume then, since you can't say for sure, that construction has begun on the project. Will there be a bond provided by Kahana Solar to Miko's? Is Miko aware of a bond that's going to be provided by Kahana Solar that will cover the decommissioning of subject project that is partially constructed at the time that Kahana Solar may or may not choose to void the PPA at this first NEP check?
A bond to its contractors?
Any bond at all. Is Miko aware of any bond at all that will cover the decommissioning? So let me just rephrase the question, I guess, is you're unaware of when construction financing will start, and that is when the first NEP check by Miko is done. My question is let's say, assuming, since you're unaware, that Kahana Solar begins construction prior to that. Say construction financing closes at the end of construction, which happens sometimes, right? Sometimes they close that financing at the end of construction and convert it over to a different type of financing. So let's say that's what we're talking about here. At that point, the project will be significantly completed, and Kahana Solar has the option to void the PPA, correct?
I'm not sure about whether or not the project will be significantly completed, but they do, at the time of the initial NEP check, have the ability to declare the PPA null and void.
So since you're unaware of when construction finance begins, I'm assuming now, just for the commission's sake here, that it happens at the end or that construction has begun. Is there a bond that Miko is aware of that will cover the decommissioning of a partially constructed project if Kahana Solar were to void the PPA at that time?
I'm not aware of the bonds. I'm only aware of the security that Kahana Solar would provide to Maui Electric under the terms of the power purchase agreement.
So will there be a bond, and is that security available for the commission's review here today?
I'm sorry, can you clarify what you're referring to?
You just said that there was a security between Maui Electric and Kahana Solar, and I'm asking if that security you just mentioned previously is available for the commission's review today at this hearing.
So the PPA details the security that's provided from Kahana Solar to Hawaiian Electric, starting with development period security, as well as a letter of credit to secure the interconnection costs. And those requirements are set forth in the power purchase agreement.
But there is no decommissioning security we're discussing then, to be correct?
Correct. Maui Electric is not involved in the construction of the facility. That is between the developer and its contractors.
So if let's say, for example, Kahana Solar and/or Interjex were to become insolvent during the construction process, are you saying that Maui Electric would have no responsibility for cleanup and/or decommissioning of the partially constructed project?
No, that would be the responsibility of Kahana Solar and the landowner, and the requirements that they've agreed to.
Great. So, so in this case, though, that would the responsibility of cleaning up the project would fall to the landowner. Then, is that what you're kind of saying?
I'm saying that the company only deals with the construction of the company-owned interconnection facilities. The construction of the facility is the responsibility of the seller. I'm assuming that the seller and the landlord of the land have requirements for what has to happen at the completion of the project, or if the project were to be terminated early, to restore the land to its proper, prior state. And I'm assuming that those, Kahana Solar has properly prepared for that.
But those are all assumptions. You haven't seen any documentation, just verifying that's correct.
Correct.
Okay, I actually have some more questions on decommissioning, but I'll get back to them. Miko stated that the term project footprint refers to the area that is occupied by PV panels. Does this seem correct to you?
Yes. Yes.
And Miko also stated that the footprint of the project is based on, I quote, the project's net energy potential. Is that correct?
I'm not sure if that was our exact words.
Give me one sec. You know what? I'm just going to keep going. I don't think it's that relevant. Give me one sec to get back here. Miko also stated that, I quote, the footprint of the project will change depending on the type of PV mounting system utilized by the developer. Is this correct?
That's correct.
Miko further testified that, and I quote, generally speaking, for an identical footprint on an identical site, the amount of energy produced by a tracking PV system would be expected to be larger than the produced by a fixed tilt system. Is that correct?
Subject to check, that sounds correct.
Absolutely. So given this, would it be accurate for me to say that, generally speaking, given an identical site, a fixed tilt system that produced the same amount of energy as a single access system would likely have a larger footprint than the single access system?
Yes, I believe that's correct.
Now, has Kahana Solar committed to utilizing a specific type of mounting system for its project at this point?
I can't remember at this time. I believe that they have, but I can't remember.
That is not in the record, Ms. Matsushima. What they have said is that they prefer to use a single access tracking system, but they have not chosen yet. Does that sound more familiar to you? Or can you point to somewhere else in the record that they have committed to using a single access tracking system versus a fixed tilt?
No, that sounds familiar. And I would actually defer this question to Kahana Solar. They would be best to determine, provide the information.
Mr. Hurley, you're asking her to comment on other people's testimony. Your cross-examination's focused on her testimony.
Sorry, this is coming from Miko response to Wampo Miko rebuttal IR2, Chair.
Okay, and is she the sponsoring witness?
I don't. Let me check. Maybe am I incorrect on that, sir?
I can look it up, but they were your questions. The easiest thing here is for you to put it up on the screen so she can review it.
Sure. Let me do that then. We'll just take our time here. Okay, I'm going to move on, and I'll ask those questions again. If this is not the correct witness, I'll just take the same tactic that commission staff is taking, and I'll just ask it till I find the right one. Can MECO confirm that at least some of the studies and calculations, including the glare analysis, visual assessment, NEP, assume the use of a single axis tracker?
The NEP was provided by Interject, so you have to check with them regarding what assumption they used.
So is it your belief that the use of a single axis tracker or a fixed tilt would affect the NEP and that assumptions that Kahana Solar provided MECO?
No, the NEP is what the developer provided that they have to meet in terms of the projected energy output of the facility. So no matter which system that they choose to use, single axis or fixed tilt, they have to build the system in order to meet that NEP.
I understand that. I guess what I'm saying is though that, we have testimony online that MECO doesn't check here today, that MECO doesn't verify the NEP until much later on. And I'm asking you, would it affect the NEP if Kahana Solar assumed a single access tracker or a fixed tilt system? And is that something MECO should be aware of?
It doesn't matter which they choose. They have to meet the NEP at the end of the day. So they have to build the facility that will meet that NEP.
Okay, so the next few questions I have are regarding land rights. Aside from the binding letter of intent presented by Interjects, has MECO taken any other steps to verify Kahana Solar's land rights?
Not to my knowledge.
Has MECO taken any steps to verify that the land the seller proposes to build its project on is adequate and appropriate for building such a project?
Can you clarify what you mean?
What steps has MECO taken to verify that the subject property can actually handle such a project that they're proposing?
I'm not sure. Do you mean, can you clarify? Do you mean like,
I guess I'm saying
handle the weight, handle the
any of it. Has MECO been to the site? Has MECO checked out the site? Has MECO thought like, hey, we've run the numbers. We generally think this site can handle this. Before we take this NEP that is unverified to the commission, did MECO go to the site and say, hey, this site can actually handle, generally speaking, this proposed project?
Due to COVID-19, I have not traveled to the site itself. Myself and my team have reviewed the maps and drawings and other information provided by the seller regarding the project location, including their proposed layout and other materials, many of which are available on the seller's website for the community to review as well.
And so from those reviews, you were able to assess that, hey, generally speaking, this site and location can handle the project they're proposing. We discussed the 20 megawatt PV facility with the battery energy storage system. That was your assessment?
From the information I reviewed, yes.
Great. Has MECO taken any steps to verify that the land seller proposes to build its project on is free and clear of any encumbrances of title that would prevent the project from being built on the site?
No, the power purchase agreement puts that obligation on the seller to confirm and comply with.
So at no point will you confirm that the project is free, the project site is free and clear of encumbrances, or you will at the first NEP check, or when will you verify that? Or you won't verify that?
No, we rely on the seller to verify that information.
Would you verify that information before exercising a buyout option?
If we were to purchase the facility, then yes, as a potential purchaser of the facility, I assume that we would take normal steps that the purchaser of a project would follow, just as we're expecting Kahana Solar to do here as the purchaser.
Are Maui ratepayers not at the same risk in either situation of encumbrances affecting the project and its ability to perform?
No, they are absolutely not at the same risk.
How are they not at the same risk?
If Kahana Solar is unable to perform under the terms of the agreement, then the Maui Electric customers don't pay anything under that agreement. We have no obligation to pay Kahana Solar in the event that they are, not able to perform under the agreement for whatever reason. That may be if it's the result of the seller's action or inaction.
But doesn't that ignore the net present value of savings associated with avoided costs that the chair discussed earlier?
Can you clarify your question?
So if the Kahana Solar project is not built, you're saying there's no risk on the Maui ratepayers, but won't they suffer because we still have planned retirements at the Kahului plant that need to go offline? So won't there be avoided cost increases because of the Kahana Solar not being built?
So I believe that you misinterpreted my statement. I said that there was a complete difference between if Maui Electric were to purchase the property versus if Kahana Solar were. My statement was to differentiate the difference that would be made between Maui Electric purchasing that property and passing the purchase price on to customers for the purchase of the facility from the start versus the obligation to have to pay a PPA payment. If the project were not to move forward, then yes, there's potential that anticipated savings to customers may be lost.
Thank you very much. I'm going to move on now. So regarding the PPA negotiations, is it MECO's conclusion that the PPA negotiations were fair to both parties while also serving to protect Maui Electric and its customers?
Yes. Yes.
Is it also MECO's conclusion that these negotiations were fair to both parties, necessarily inclusive of fairness to the general public and non-ratepayer members of the West Maui community?
Yes. Yes.
Okay, moving on. Will the project need new additional overhead lines in order to interconnect to the Maui electric grid?
Yes, it's connecting to an existing circuit, but it'll need the interconnection line into that circuit.
And what size do you believe these lines will be?
I believe this is interconnecting at the 69 kV.
I believe that's correct. Is it the company's belief that factors that affect the prudence of the PPA and the public interest would not be relevant to the interconnection study requirement and the construction of the overhead lines?
I'm sorry, can you repeat that question?
Is it the company's belief that the factors that affect the prudence of the PPA and the public interest would not be relevant to the IRS requirements and the construction of the overhead line?
I'm not sure I understand your question. When the overhead line will be built, there'll be a separate request for approval, and the requirements for that are set forth by statute, and those requirements have to be met in order to build the overhead line.
Oh, okay. So you agree, though. Did MECO move to bifurcate the overhead line and thus at least part of the interconnection issues from the issue in this part of the present proceeding?
Yes, our application asked to separately review the request for overhead lines.
So I'm going to ask my first question again now. Is the company's belief that the factors that affect the prudence of the PPA and the public interest would not be relevant to the IRS requirements and the construction of the overhead lines?
I'm not sure that I fully understand your question. I think that we have not said that. I think we've said that the, any concerns related to the overhead line and customers' concerns with that, and that should be addressed in a separate proceeding, not that they would be ignored or not addressed.
Do aspects of the overhead line approved that are going to be bifurcated, are they included in the greenhouse gas analysis?
I'm not sure. You'd have to defer. I'd have to defer to our witnesses testifying regarding the analysis. But if they are not, then they, a separate analysis covering that would be provided at the time of seeking that approval, just as we've done in other proceedings.
Let me ask you though, if they are included in this part of the proceeding, should they not be included in the bifurcated part of the proceeding? or do we not need to look at the greenhouse gases for the overhead line?
I don't believe we've ever said that. I believe that it is that in the past we have. I'm also not the best to opine on this. I believe there may be others that could speak to this better than myself.
Okay, I'm going to keep moving on in the interest of time. Is it correct that the PPA will be amended based on the results of the interconnection study and filed with the commission?
Yes, that's correct.
And the amendments will likely include changes to attachment B, facility owned by seller, attachment E, single line drawings and interface block diagram, attachment F, relay list and trip scheme, attachment G, company owned interconnection facilities, attachment K, guarantee project milestones, and attachment K1, seller's conditions precedent and company milestones. Does MECO consider any of the details covered by the above discussed attachments as material terms to the PPA?
The guaranteed commercial operations date that's provided in attachment K is, I believe, a material term, and I do not believe there's anything in the Kahana Solar PPA that allows for the change to that guaranteed commercial operations date based on the results of the IRS amendment.
So there's no way the guaranteed commercial operation date can be moved based on the IRS amendment. Then is that what MECO's testimony is here today?
To the best of my knowledge, with regards to the terms of the Kahana Solar PPA, that is my understanding.
So if there's some huge thing in the IRS, MECO would not be willing to work with Kahana Solar to move the guaranteed commercial operation date to save the project, or it would just die then?
Yeah, just to the extent it calls for speculation.
I cannot say for sure.
Can you
I mean, if there
rephrase the
were,
question?
Sorry. So you're saying that under the terms of the PPA as presently written, there is no way, if the IRS called for some extended time frame and there was no way the guaranteed commercial operation date was to be met, under the current terms of the PPA, there is no way for Maui Electric to negotiate with Kahana Solar and move that guaranteed commercial operation date, and thus the project would die. Is that correct?
no, that's not correct.
So how would you move forward?
The parties to the contract can always negotiate an amendment, which, depending on the term, could potentially go back to the commission for approval if it was considered a material term. And it would also depend on the circumstances. For example, there are provisions in the PPA related to force majeure that could allow for an extension. So if during the IRS amendment there were force majeure provisions, that might result in the change of a guaranteed commercial operations date. That would be something that is allowed under the PPA. And there are other provisions in the PPA not related to the IRS amendment that also would allow for the change to the guaranteed commercial operations date.
Okay, thank you. I have a force majeure question, actually. My colleague attempted to ask it previously, and we were directed that you would probably be better to handle that question. So MECO's testimony and Interject have not discussed if COVID-19 may be a force majeure event. Is that correct?
To my knowledge, that's correct.
Now, are you aware that Hawaiian Electric and the Napuamakani wind farm seller on Oahu have claimed COVID-19 is a force majeure event in regard to the Kahuku Wind Project?
You're referring to the Napuamakani Wind Project?
Yes, I am.
Yes, I'm aware.
So they have claimed force majeure under the COVID-19, correct?
I'm not sure of the exact claim, but I am aware that there were force majeure provisions under that contract. I don't have my recollection to exactly those. They're not the subject of this proceeding.
So under the current PPA then, though, neither party would be liable for lost bill savings due to force majeure events. Is that correct?
That's correct. That's consistent with any contract that has force majeure provisions.
Okay. Sorry, I'm moving down here. Is it possible that labor disputes qualify to trigger a force majeure clause in the present PPA?
The present PPA does have provisions related to work stoppages and strikes that may trigger a force majeure provision. However, there are also exclusions related to strikes and work stoppages if they are attributable to just, I believe that the defined term, a seller attributable party versus a broader labor strike. Without reading the exact provisions, I'd have to go back, but those are spelled out in detail for anyone to review in the PPA.
Right. Is it possible that any of the PPA amendments related to the IRS could reflect design changes and or impacts associated with the project's footprint, glare, native species runoff, or greenhouse gases?
I'm sorry, related to the IRS?
Yes. Will any of the amendments of the IRS, could they affect any of those things? The glare analysis, the project footprint, the native species, the greenhouse gas?
Not to my knowledge.
Will WAMPA and the consumer advocate have an opportunity to cross-examine and or ask questions about PPA amendments related to the IRS under the current procedural schedule in the present proceeding?
I'm not sure the procedural schedule for that half of the proceeding has not been set yet.
So is it MECO's belief that issues associated with interconnection study and related PPA amendments should solely be addressed in the bifurcated portion of the present proceeding?
I'm sorry, can you repeat the question?
Is it MECO's belief that issues associated with the interconnection study and any related PPA amendments should be addressed in the bifurcated portion of the present proceeding?
MECO, the company's position is that the interconnection requirement study is just to finalize the interconnection between the utility and the facility. It is not to change the facility itself or to change the terms of the power purchase agreement. And so the only thing that really is left for subject to commission review in the second half is related to the overhead line approval.
So I'm gonna ask the question again. Is it MECO's belief that the issues associated with the interconnection study and related PPA amendments should be addressed in the bifurcated portion of this hearing? It's a simple yes or no question.
No.
No. Okay. So we should be asking these questions here then.
No, that's not what I said.
So then where should we handle these questions?
As misstated.
So then where should we handle these if not in the bifurcated? We should handle them in the present proceeding then, correct?
No, as MECO has stated and as set forth in our documents, we believe that the IRS amendment is provides non-material modifications to the power purchase agreement, and that are set forth. The process for that is set forth in the PPA. To the extent that we're discussing the process of the IRS amendment, then yes, I think it can be discussed here. But our belief is that the non-material amendments to associate the results of the IRS amendment into the power purchase agreement don't require PUC approval, and that is provided as an informational filing only, with the subject to the second proceeding covering only the overhead line proceeding.
Is MECO confirming that the transmission line will have no impact on factors discussed in this portion of the proceeding, such as native species?
No, I'm not saying that necessarily, but I'm saying that any impacts from the transmission line will be reviewed in the separate proceeding and can be identified and discussed there.
So any evidence of that establishes, like for example, that the transmission line will not impact native birds who traverse the parcel, that will be in the bifurcated proceeding and not in this proceeding. Is that correct?
To the extent that that is required to receive approval under the statute, I'm not here representing the company as an attorney, so I can't say what is required under the statute for approval of the overhead line.
Okay. Let's move on to the July 7th public hearing or public meeting. I apologize. Did Miko attend the July 7th, 2020 public meeting held by Kahana Solar via WebEx?
Yes.
And is Miko aware if registration was required to attend the meeting?
I cannot remember off the top of my head. I believe I did register.
So that was going to be my next question was, did Miko register for the July 7th meeting? And so you've confirmed that you think you registered, correct?
I believe so.
Were non-registered people able to attend the meeting?
I'm not sure. You'd have to ask Kahana Solar.
Okay. Was Miko aware of a call-in / phone option available for the July 7th, 2021 meeting?
I can't remember.
Like, for example, last night at the Lani Apoko hearing public meeting, we had a number of community members use the phone to phone in. So do you not remember any discussion about talking to people on the phone and asking them for their names or information?
I don't remember.
And Mr. Hurley, we're talking about totally different parties here. Not clear the witness here would have been calling in or monitoring last night's meeting.
Chair, I'm just trying to establish
asking your way. You're like,
Chair, I'm just okay.
You're on the same side of the island, but we're talking about totally different things here.
Are you familiar with commission public hearings in general?
Yes, I participated in them.
Great. Was Miko able to view any other attendees at the July 7th, 2020 meeting?
I don't believe so.
And so you probably weren't able to communicate with other attendees, correct?
No.
Okay, I'm moving on. Can you confirm that Miko filed public comments related to the seller's outreach efforts as part of Exhibit A to the application?
I don't remember the exact exhibit number, but yes, I believe we submitted public comments.
And can Miko confirm that the procedural schedule in the present proceeding offered the opportunity to amend or supplement Exhibit A?
The power purchase agreement provides that further public comments were to be submitted by the seller, Kahana Solar, at the time that no later than when they or around the time that they submitted their statement of position in the docket.
Okay, but did they have the opportunity? Could Miko have but Miko could have amended the exhibit, correct?
I'm not sure what the procedures are for amending, what the rules are for amending.
Okay, I'm going to move on to some of the greenhouse gas questions. Can Miko confirm that 1,865,525,000 kilowatts represented the project's total available energy and was calculated by multiplying the NEP?
So just to check, I believe that sounds like the correct number. I don't have it right in front of me. If you can point me to the IR response or document, I can take a look.
That is Miko testimony 4 at 5. And I apologize, Chair. My computer is very, very slow. As you can tell, I don't have the digital background, so that's why I'm not bringing anything up on screen. I'm scared it's going to crash my WebEx and then you'll lose me. So just to be clear, that's why I'm not doing it. Apologies.
Ms. Dehoff Matsushima, do you have access to the response or testimony? Can you restate which exhibit?
My co-counsel can also share if necessary. It's going to be Miko rebuttal testimony 4 at 5, PDF page 22 is what I have. My co-counsel Bianca Saki can share as well.
I'm just pulling it up.
I apologize. I didn't have the nerve to get a new computer beforehand in case it all went south on me.
Page 5.
Ms.,
Okay,
you
I'm
have the
there.
materials that you need? Okay.
Yep. Sorry about that, Chair.
So no, I'm sorry about that. Thank you. So you can confirm that's what represented the total available energy calculated by multiplying the NEP by 25. Is that correct?
That's correct.
Does MECO use this number anywhere else in its analysis for the Kahana Solar project?
The multiplied out number or the NEP?
The multiplied out number.
I'm not sure. You would have to, that would have been a question better posed to Mr. Lee or Mr. Lau.
Okay, maybe we can get that on redirect then, across if we do that. So the project's NEP of 74,621 megawatts represented the annual energy produced by the project over a 10-year period with a probability of exceedance of 95, correct? I apologize, we already stated that, but can you just confirm?
Yes, that's correct.
And can you confirm that while the NEP probability of exceedance was for a 10-year period, the 1.8 billion kilowatts was actually was calculated based on a 25-year period? Is that correct?
That's correct.
Just a quick question about the contractor Ramble in general. Is it your belief, has Ramble performed all the GHG analysis for all the stage 1 and stage 2 projects?
For the projects that GHG analysis were completed for, I believe that is correct, but subject to check. For the ones that had GHG analysis, I believe that is correct.
Were there some that didn't have GHG analysis?
Let me object as going beyond the scope of this proceeding, asking about other projects.
So I think the question was asked and answered.
Thank you. I'll withdraw the question. Let's talk about jobs. Kahana Solar informed MECO that it estimates this project would support 104 construction jobs within the state of Hawaii, and that given prior experience, Solar believes 50 to 60% of the total jobs will be local personnel. Is that correct?
Yes, that's what we were informed of by the seller.
Was MECO provided any evidence or economic analysis related to the 104 jobs?
No.
Has MECO seen any commitments requiring any portion of the project labor and or operations be manned by local and or union labor?
Not to my knowledge.
If MECO were to execute its buyout option and purchase the facility, would MECO be required to use union labor and or local labor for the project operation?
I'm not sure. That falls outside of the scope of my area of knowledge.
Who would I ask that to, if it's not you?
I don't believe we have anyone here today that could speak to that because that's not related to the project or what we contracted for.
Is the buyout option not part of the PPA?
I believe, without going back to PPA, I believe there's a purchase option at the end of term, but again, you know, what would happen if we were to purchase the facility? It would require PUC approval, and the requirements of what the company would and wouldn't be required to do would be up for discussion at the time that we sought PUC approval of such purchase.
Okay. Was MECO, and I know the CA asked these questions, but I'm just going to ask them again. Was MECO aware, because I'm going to ask them slightly differently, was MECO aware of WAMPA's attempts to explore avenues of settlement outside the contested case proceedings?
I'm not personally in full detail. I know that Kahana Solar had reached out to the West Maui Preservation Association, but I was not a party to those discussions.
But MECO was open to engaging in an informal discussion, mediation, settlement discussions, or other alternative dispute resolution processes in a good faith attempt to resolve the differences with WAMPA. Is that correct?
Yes, we said we were subject to Kahana Solar being participant to those discussions.
But to be clear, MECO has not reached out in any way to West Maui Preservation Association. Is that correct?
Not to my knowledge. I
So
have to defer to Ms. Martin.
is that something that we should do to MECO? Should West Maui Preservation Association reach out to MECO to engage in settlement negotiations?
I'd have to, I'm not sure what the process is with regards to once we're in a formal PUC proceeding and there's parties. I'm not sure that how those discussions can be had. I'd have to defer to my legal counsel.
Are you aware that Chapter 91 8.5 specifically provides for a process for parties in a contested case to engage in mediation?
No, I'm not an attorney representing the company, so I'd have to, like I said, defer to my legal counsel.
So is your legal counsel aware of that?
I'm not sure. I'm assuming they are.
If that is true, let's assume that HRS 91-8.5 does allow and provide a process for mediation. Would MECO be willing to suspend the present proceedings so that we could enter that process and negotiate a mediated settlement at this time? Is given the previous testimony to the consumer advocate earlier today?
Yes, I mean, pursuant to IR, we said we were willing to participate in discussions and, trying to reach agreement with West Maui Preservation Association with the understanding that Kahana Solar had to be part of those discussions as they're responsible for the construction of the facility. Though I would note that we would want to ensure that any such discussions didn't unduly delay the proceedings because there are many benefits of this project that we want to ensure our customers and the other residents of Maui are able to receive those benefits as quickly as possible.
So, but you would be open to it, though. We would be open to that as well. If MECO would be willing to suspend the proceedings under that chapter of HRS, we would be more than willing to do that. But I think you need to chat with your counsel about that. Hopefully, you guys can get back to us. So I'm going to go on to decommissioning. The RFP required all proposals to include a decommissioning plan. Is this correct?
Yes.
Yes. And no such decommissioning plan has been provided in the present proceeding. Is that correct?
I am not sure what has and hasn't been provided.
It's our understanding that the decommissioning plan submitted with the RFP was submitted on a confidential basis. Is that your understanding, or do I need to speak with somebody else?
I believe so. I think in general, the seller's proposal was submitted as confidential.
So then West Maui Preservation Association, the Consumer Advocate, or the Commission have no way of viewing the submitted decommissioning plan. Is that correct?
I don't believe that's true. I believe the Commission and the Consumer Advocate have access to that confidential information, and I'm not sure if that was filed restricted confidential or confidential without checking the record to know whether or not WMPA had access to it or not.
So I don't believe that was filed. Was that filed in this docket? Or was that filed in the RFP docket?
I'm not sure. I believe it was for sure filed in the RFP docket. I'm not sure what was filed in this docket.
Because I don't believe it's been filed in this docket, or we would have tried to gain access to it. So maybe that's something we can follow up on. If it is MECO's assertion that it's in the present proceeding, West Maui Preservation would have a very interested in looking at that. So throughout the testimony, they talk about a detailed decommissioning plan. Is it true that Kahana Solar has not yet developed its detailed decommissioning plan and methodology for determining whether the land was successfully restored to its condition prior to construction?
That's my understanding.
When does MECO believe that Kahana Solar will have developed this detailed decommissioning plan?
I'm not sure when they will develop it. I think we've put in our IR responses that it would make sense to better understand what's going to happen at the end of life of the facility before you would develop a full detailed decommissioning plan. We can't say now how this facility will be used 25 years from now, or what pieces might be needed at the end of the term. And so any decommissioning plan would be subject to needing to know the end result of the facility prior to have a complete plan.
So are you saying that West Maui Preservation Association, the Consumer Advocate, and the commission will not be able to view the detailed decommissioning plan until the end of the project's life?
No, I'm not saying that. I said that I don't know when the seller is going to complete their specific detailed decommissioning plan. I think that our IR response noted that.
I got it. So will the commission or West Maui Preservation Association have a chance to review the detailed decommissioning plan before the PPA is approved in the present proceeding?
Not to my knowledge.
But it would be, if it's not developed until the end of term, that it would most likely not be available for review before the PPA was approved. Is that correct?
Correct. That's what I just said.
MECO testified that typically decommissioning of a solar project includes, and I quote, any and all components associated with the project would be removed and the area would be restored to meet natural environmental surroundings. Is this correct?
Subject to check, yes, that sounds correct.
However, as the consumer advocate noted, the GHG analysis, including the application, listed several items as abandoned in place. Is this correct?
Yes, I believe that is correct.
And did MECO have Rambo calculate the associated greenhouse gases for removing such items that were left as abandoned in place?
So just to check, I believe we did go back and complete additional analysis to the differential in the greenhouse gases. Those were decommissioned or left in place.
And was that additional greenhouse gas, was that new information officially put in the final greenhouse gas report? Meaning you already supplemented and amended the greenhouse gas report once. Did you do it a second time to include this information? Or is it just in the IR?
I believe it was filed as part of an IR response on the record.
So I guess what I'm saying is if I was only looking at the final greenhouse gas report, the greenhouse gas emissions for the gravel and other aggregate that was left assumed abandoned in place is not included in the final greenhouse gas report. I'd have to pull it from an IR, correct?
I would have to defer to our greenhouse gas consultant who's testifying later today whether or not it was amended. I do not believe it was, though. And I believe we showed that it was inconsequential, the differences.
So I guess just wrapping up, is it MECO's assumption that this project will have no economic benefits for the community or the West Maui region?
I'm sorry, can you please repeat your question?
So is MECO not presenting this project as it's going to support local jobs and that it's going to have economic benefits for the community in West Maui? Is that not part of the community benefits or at least part of MECO's assumption here?
We've showed that there will be bill impact benefits, which benefit all of the customers of Maui Electric due to the results of the project. We have also stated that it is our understanding that Kahana Solar will be creating jobs during the construction of the project, as stated by Kahana Solar, that will create job benefits during such time to the community.
But you previously testified you can't speak to any labor issues, correct?
I'm sorry, what do you mean by labor issues?
I had asked you about the 104 jobs, and you said you took that on face value, but that would be Kahana Solar's, up to them. So, but MECO's assertion is that there'll be benefits to the community from jobs and such. But my point is there's no, MECO is unaware of any commitments regarding jobs, correct?
Other than the commitments that Kahana Solar has made and published on its website, no, I'm not familiar with other agreements that Kahana Solar may have at this time.
So, but are the agreements on Kahana Solar website, are they binding on anybody?
Not to my knowledge.
So I'm just being clear. So for the purposes of this proceeding, we shouldn't really take into account those agreements if they're not binding, correct?
You have to speak to Kahana Solar to see if they have any agreements in place. typically prior to actually starting construction, I don't think that he would have those agreements necessarily, signed prior to PUC approval of your contract.
Okay, so the agreements typically aren't signed. I don't want to restate your testimony. So, but you're saying typically the agreements aren't signed with entities relating labor until the PUC is approved? Is that what we're, I don't want, sorry, could you restate?
I'm not sure what the developers do. If I were the developers, I would not be entering into contracts to complete construction prior to knowing if the commission had approved the project and obligating, financial obligations prior to approval of the project.
But entering a contract is different than a binding commitment, I guess, is where we're going with this. You see, Kahana Solar could require commitments of their contractors, and we could review that in the present proceeding. At least that's West Maui Preservation's belief, is that Kahana Solar could require commitments in its procurement of its contractors. And those commitments could include the use of union labor, or at least paying a living wage. Is that not something that MECO believes can be negotiated ahead of time and reviewed at the commission level?
That would be between Kahana Solar and its contractors, so I would defer to them on whether or not they've done that.
I don't want to keep going in circles, but our issue here is that we're talking about economic benefits of jobs, right? But yet when we probe any deeper into there about how we can ensure that these jobs are happening, there really is no commitments. I mean, and it's MECO's assertion that those commitments should come at a later point in the development process after the PPA is approved. Is that what? And I apologize, I don't want to restate your testimony. I'm just trying to make sense of the muddied waters here.
To my knowledge, there are no firm commitments, written commitments regarding the labor, but the project will need to be constructed on the island of Maui, so presumably jobs will be created to construct the facility.
You see, but our issue is that Kahana Solar has stated to you folks that up to 40% of their workers typically come from out of state. So how can we account for those typically 40% workers if there's no commitments in place? They don't have to be contracts. We just want a commitment that the PUC can hold folks to the fire about.
Chair, if I may, I apologize for interrupting. Chair, I'd like to make a comment.
Please proceed, Mr. Kotiga.
If I may, just to note that we have some concerns about council characterizing and describing a testimony by Kahana Solar that may not be accurate.
And I think a couple of things here, Mr. Hurley. I believe a lot of these questions, or one, this witness is asked and answered from her perspective, from her testimony. A lot of these are focused on Kahana Solar. So I haven't heard anything new in your last few questions. So.
And we're going to let it go, Chair. Our issue is this is Maui Electric's application, and that we in our information requests and the testimony, there's a lot of back and forth. And so I apologize if I'm. And
I believe the witness here has answered your questions.
That's actually my final question, actually. So thank you very much for your testimony.
Okay, let's go to Commission Counsel, Mr. Kayatsu.
Thank you, Chair. Ms. Matsushima, I just want to like to go back to some of the earlier comments that, or to questions and answers that were made about the guaranteed commercial operations date under the power purchase agreement. Mm-hmm. So, well, first I want to confirm, because I think I heard several different things, so maybe just to level set. Does Maui Electric consider changes to the guaranteed commercial operations date based on the interconnection requirement study amendment to be material changes to the PPA?
It depends on the power purchase agreement. If the power purchase agreement provided for that change, then I would say that's not a material change. If the power purchase agreement did not have a mechanism already in place to provide for that change, then that could be deemed a material change to the power purchase agreement.
Okay, and in your opinion, which is it for this particular power purchase agreement with Kahana Solar?
Subject to reviewing the entire power purchase agreement, again, to my knowledge, I don't believe that this power purchase agreement provided for an ability to change the guaranteed commercial operations date as part of the IRS amendment, solely due to the results of the IRS amendment.
Okay. Are there other circumstances under the power purchase agreement that could allow for the change in the GCOD besides the interconnection requirement study?
Yes, the power purchase agreement provides that if commission approval is not obtained by a certain date, I believe it's 180 days subject to check of the PPA from, I think it's execution of the agreement. I can't remember if it's execution of the agreement or filing, I apologize. But from that, if approval is not received in that time, then there's a day-for-day extension can be granted to the guaranteed commercial operations date.
Okay. And just to reiterate, you said that this is based on the particular nature of the power purchase agreement that Maui Electric has with Kahana Solar.
That's a pretty standard provision. I think that provision related to extension of if the PUC approval is not obtained within a certain time frame. I think that is provided in the model. I have to go back and check.
My apologies. I meant to clarify. Regarding the changes to the GCOD based on the interconnection requirements amendment, you said that is something that is dependent on the specific power purchase agreement at issue?
Yes.
That's different than some of the power purchase agreements that Maui Electric has entered to with other IPPs under the RFP stage 1 and stage 2. Is that correct?
That's correct.
Is there a distinction or a reason why this provision may or may not be incorporated into a power purchase agreement?
I think it just depends on the negotiation and the, you know, in any negotiation, there's give and take of provisions and what is negotiated. And in this case, that provision was not negotiated.
Okay. All right. Thank you. I appreciate that clarification. Let's see. So all right. Sorry, I have to review my questions. Can you please give me a minute? Sorry.
Sure.
Aside from the interconnection requirements amendment, and aside from the other example you cited regarding PUC approval, are there other conditions or circumstances that could result in a delay to the guaranteed commercial operations date?
Off the top of my head, force majeure would be another reason that a guaranteed commercial operations date could be extended or.
Okay.
And then in general.
Sorry, in general?
I was just going to say, in general, other delays, company delays, I believe the sellers provided day-for-day extension if the delay is the result of the company under the power purchase agreement.
Okay. In the event that one of these delays were to occur for force majeure, one of the other ones you indicated are contemplated under the PPA, would this affect the estimated project benefits?
Depending on the delay, it could potentially, yes.
Okay. In the event that this were to occur, does the PPA provide, or does Maui Electric have in place any protections for ratepayers if this should occur?
It depends on the cause of the delay. So, for example, if it was a seller delay, you know, not force majeure or not provided for in the contract, then there are liquidated damages that are paid by the seller under the contract, and those are passed through directly to the customers, Maui Electric's customers. Maui Electric doesn't retain any of those liquidated damages. They'd be provided directly to our customers.
In addition to the provisions explicitly set forth in the power purchase agreement, does Maui Electric have in place, or is Maui Electric working on any sort of provisions or efforts with Kahana Solar to mitigate any potential project delays?
So Maui Electric works with all of our developers on our projects, and I believe with Kahana Solar, I believe we've set up biweekly meetings with the developer to ensure the project stays on track, or if we have not yet, they will be set up upon PUC approval. I'm sorry, I can't remember off the top of my head where we are yet with Kahana Solar, but in general, we do have processes to meet with the developer on a regular basis with their contractors and our engineering teams to review the project schedule, to discuss the where the projects are at, whether they're meeting their milestones. And in addition, for this project, we've also been working with developers monthly to get project updates that we submit to the commission in this docket.
Okay, thank you. As of today, has Kahana Solar identified, or are you, as Maui Electric, aware of any potential project delays that would affect the guaranteed commercial operations date?
I'm not aware of any delays with the project. I will note that I believe we've exceeded the 180-day period for PUC approval under the contract, which could result in a extension of the guaranteed commercial operations date. Okay,
thank you. I just have one other question for you, and it's kind of been punted down the way, so I hope you can help me here. Aside from the 69 kilovolt transmission line to interconnect the Kahana Solar Project Maui Electric system, does Maui Electric anticipate or foresee any additional infrastructure or capital improvements or other type of work necessary to safely and reliably interconnect this Kahana Solar Project Maui Electric system?
To my knowledge, for this project, there are no other separate projects.
Okay. If subsequent to approving this contract, it was discovered or became known that some additional project that was necessary to safely interconnect it, would Maui Electric seek commission approval for cost recovery of that project?
I have to, I guess, speculating on what what that would be. I think if it fell within the rules that required approval for cost recovery, then yes, obviously we would. But because I'm not aware of any project, I can't say for certain, whether or not.
Well, let me give you a specific example. Let me provide some context just as an example. So I know on Oahu for Hawaiian Electric, we've approved a number of power purchase agreements for some of the Waiawa-based developments, and then subsequent to approval, Hawaiian Electric has requested cost approval for an additional infrastructure project to help manage the under-frequency load shed to safely incorporate those systems online. So that is, in essence, it could be perceived as adding an additional cost to the project that wasn't known at the time. So I'm simply wondering if Maui Electric is aware of any similar projects now, and if so, how should that be considered going forward, since it would affect the benefits, the cost and benefit analysis, correct?
So as I mentioned previously, I'm not aware of any of those projects. I do not believe any exist for the Kahana Solar project, anything similar to that request. I believe that specific example that you provided, the company deemed those to be system upgrades that were needed to the system in general to be able to incorporate more renewable energy, and therefore, felt that those were not appropriate for the developer to take on those costs. So I don't know that I would say that they change the cost benefit of a particular project as much as they're the cost of trying to reach our 100% renewable energy goals.
Okay, thank you. I appreciate that clarification. I just have one last question. Is this something that you would consider discussing with Kahana Solar to perhaps potentially amend the power purchase agreement to provide some sort of protections to ratepayers in the event that additional infrastructure was needed to safely incorporate or integrate the project onto the system?
So the PPA already provides that any costs related to that are deemed interconnection costs as part of Rule 19, as well as some costs that we've passed on in addition to what's required under Rule 19 are required to be paid for by the developer. So anything that was to be deemed an interconnection cost, that's already provided for in the PPA to be paid for by Kahana Solar. To the extent that a system upgrade was needed. I think my understanding of Rule 19 is that would not be appropriate to pass on to Kahana Solar or to incorporate into the power purchase agreement.
All right, thank you, Mrs. Matsushima. No further questions of this witness, Chair.
Thank you, Mr. Kaitsu. Commissioner Sunsian.
Thank you, Chair. Just have a couple of questions. Ms. Matsushita, there was questions about whether or not the PPA contains buyout options. You responded, to your knowledge, it's only at end of term through it. And I'll apologize, I haven't reviewed the PPA for some time. But is there any other place that mentions buyout options? Like, I guess what Wampa Council was trying to get to is, right, prior to full construction. And I don't seem to know whether or not that kind of option is there.
Yeah, sure. I apologize. I haven't read the PPA in several months, but such in my memory, there are no purchase options for the utility prior to construction of the facility in the power purchase agreement. If I believe all of the purchase rights are at the end of term, but again, that's subject to check. And I can like cite the articles off of my head where I look in the PPA, but I just don't remember their exact language. But I'm 99% certain there are no purchase options prior to construction of the facility.
Okay. And I just wanted to clarify too, we talked about a public meeting that was held, I believe July 7th, 2020 was the reference date. Was that by Kahana Solar or was that by the PUC?
Kahana Solar held a meeting in July of their community meeting in July. I believe that's the meeting that West Maui Preservation Association was referring to in the question that was asked.
Okay, thank you. Just wanted to clarify which public meeting we were talking about. Thanks, thank you, Chair. That's all I have.
Thank you, Commissioner. Commissioner Potter.
Hi, thank you. Hi, Rebecca. Good to see you. Thanks for being here. I just have a couple of questions. I think the first one has to do with the CA had, in his testimony, had indicated that, third-party administrator for the public, for the benefits or the community benefits. Is that something that resonates with you as well as I'm thinking not only for this RFP, but future RFPs where it could be a component in those RFPs. Is that something that you're that basically is attractive to you from Energex?
You're referring to third-party community benefits administrator?
Yes.
I think it's very project specific. I think each community is different. Community requests for what they might see as appropriate community benefits are different and unique, and whether or not a third-party community benefits administrator would be better at administering those versus the developer or a community group there that's being given benefits directly by the developer, I think is dependent on the project. I think there are some concerns with third-party community benefits administrators. They usually require a fee, is my understanding. So depending on the size of that fee, that could make the benefits less to the community. So again, I think it's just really project specific and dependent, and even dependent on who that administrator might be, on whether or not it would be beneficial or not.
Okay, thank you for that. My second question is about there was a lot of public comments, and then also Wampa had indicated in their testimony repeatedly that there was they wanted access to the data and for the assumptions and basically the calculations for the greenhouse gas analysis. This is something that I think. I'm curious on what your opinion is on that, and if that is something that's doable.
I'm not familiar with all of, I don't complete the greenhouse gas analysis. I think a lot of that information is provided as part of the report. Some of that information, in the detail maybe that might be desired, could hamper competition in future RFPs. And so I think there would be some concern with sharing certain information that might allow for gaming of future PPA proposals and pricing related to how the company calculates dispatch and certain things like that, that we would have concerns with sharing. So I think that a lot of information is shared. I think if, it would depend on the specific information moving forward about, if we would be willing to share any additional information, but there are some concerns with providing too much detail. Even, to the developer, some of that information is not provided.
Yeah. Okay. Thank you. And the last one I have for you is grid forming inverters are pretty nascent, and they're coming up, but they're not quite there. Is this a project where you'll see grid forming inverters, or is that part of their project?
Yes, this project, all the Stage 2 projects are required to provide grid forming. So this project will, we will have grid forming inverters.
Excellent. All right. All right. That's all I have. Thank you, Becca. Thank you, Chair.
Thank you, Commissioner. I just have a few questions. Ms. Dayoff Matsushima, you said earlier, I believe under questions from WMPA's council, that there were 4 checks on the NEP during the process. I think I have that right, and at different times. Can you expand on that?
Sure. I'm sorry if I said 4 checks, I misspoke. But there's 2 official checks. So prior to the completion of construction financing, there's a check, and during that process, an independent evaluator is used to determine the NEP. And if the NEP is at or higher than what was bid by the developer as part of the RFP bid, then the NEP stays the same and the lump sum payment stays the same. If the NEP is lower than what was bid, then the developer does have the option to declare the PPA null and void, or the lump sum payment is reduced. And then I believe for Kahana Solar is negotiated, I think, slightly different in different Ps, but I believe around the 15-month mark after commercial operations, once the facility has had a chance to operate, work out any, initial first year going through the project being in operation, then an additional NEP check is done. And again, if the NEP is, at or above what was bid, then there would be no change, and the lump sum payment would be the same. With the exception if it had been downgraded at the first NEP check, it can be upgraded to the original bid amount of the NEP. It can't ever go above what was bid. And then if it was below, again, the lump sum payment would be adjusted based on the unit price. And I also forgot to mention that if it is lower in that initial NEP check, there's also a one-time liquidated damage that's assessed to the seller for overestimating the NEP.
Thank you.
And then there's future NEP checks. There's future ones that aren't required, but if unless the seller were to change something in the facility that we think would change the NEP, such as installing a new step-up transformer, something to that impact, then the utility has the right to request an additional NEP. If the seller makes other changes to their facility that they think might improve their NEP, then they also have the right to request an NEP check at that time.
Thank you for that. And that's a similar structure. Is that more or less been consistent in all the PPAs, or change here?
That's pretty consistent between all of the PPAs. The only date that might be different is that 15-month check that might differ. I can't say for sure without reviewing each of the 20 plus PPAs I think we have now for Stage 1 and Stage 2, but that would be I think the one place that there might have been negotiated changes.
And is it the company's position that that provides some assurances and protections for customers by doing those multiple checks and then the adjustments in both directions potentially?
Absolutely. That's the reason that we incorporated those checks into the process. We were concerned that just having the developer bid the NEP, and even if we were to check it ourselves, during the RFP process, that may not be what's actually built. So the intent of those provisions was to provide some assurances under the PPA that the developer was incentivized to provide the correct NEP when they're bidding.
Okay, thank you. Different topic. It came up a few times. I just want to clarify. This is again on the topic of force majeure. And I just want to clarify what, if any, discussions have happened with Energex related to this project yet, if any.
Related to force majeure, to my knowledge, we have not had any conversations with Energex on the Kahana Solar project related to force majeure.
Okay, have you asked?
Chair, I'm not aware. I have not personally asked. I don't believe we have asked.
Okay, and I'll ask later.
We asked them for monthly updates.
Just to give context, we've had, right, those provisions invoked or requested to be invoked with other phase 1, phase 2 projects, broadly related to global supply chain conditions that could affect this developer as well. But at this point, you haven't asked whether that may be on the horizon here.
I don't believe that that's recently, and I'm trying to search my memory. I do believe maybe at the shortly after selection, at the maybe the more broader beginning of COVID-19, all of the developers were asked related to any anticipated impact. In general, I mean, we meet with the developer regularly and ask them to provide us updates, and we would expect that if they were facing a force majeure provision, or potential for force majeure, this is something that they would come to us with immediately. But no, Chair, I don't believe in the recent, in the last month or so, I don't believe that we have asked if they face similar issues.
Okay, and I'm going to be careful of this, but I believe this project, as well as others on Maui, are being dependent on for retirement of the Kahului plant. Is that correct?
I believe that, not the 100% best person to answer this question, but I believe that we are relying on, having projects, including this project, as part of the mix of generation to retire the Kahului plant. I think that would be a benefit of this project if it were to be selected or approved.
But to be able to do that, we need fairly firm understanding of the timeline, the high likelihood of when the project would be online, correct?
Correct.
Okay, and you haven't been asking this developer whether they anticipate supply chain delays yet?
Well, we have, been asking them if they're anticipating issues. We've been working with them on the project schedule as part of the facility study, and to my knowledge, they have not indicated any need to change their GCOD at this point.
If they did, would you have communicated that to the commission?
Yes.
Okay, those are all my questions for now. Thank you. We're going to take a 10-minute break after this witness, and then continue with Mahina Martin. That, depending on the timing, that may eat into the noon hour, but we'll plan to take lunch after the next witness, depending on how things go. But realize we've all been here for a while, so 10-minute break. According to my watch, we'll reconvene at 11:30 sharp, and that hearing's under recess. Okay, we're at 11:29 by my watch. If we can have people start filtering in, and perhaps our next witness can be teed up, Ms. Mahina Martin. Okay, it's 11:30. We're going to call the hearing back to order. Next, I'd like to call MECO witness number 5, Ms. Mahina Martin. I see you're here. Do we administer the oath? Okay.
Sure.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Let's proceed with cross-examination by the consumer advocate.
Thank you, Chair. Good morning, Ms. Martin. You're the Director of the Government and Community Affairs Division at Maui Electric, correct?
Yes, correct.
Thank you. In addition to your direct testimony, you also sponsored several information request responses in this docket, correct?
Yes, that's correct.
Okay, if it's okay with the Chair, I would like permission to share my screen about your response to WMPA MECO RIR 8. So please.
Yes, please go ahead. Thank you.
Thank you. Okay. Ms. Martin, can you see, you should see in front of you WMPA MECO rebuttal IR 8. Do you see that?
Yes, I do.
Okay, and if you don't mind, just for context, I will just read this beginning paragraph.
Sure.
Regarding, okay, thank you, sorry. Regarding WMPA's views on community benefits, Ms. Martin states, Mr. Collins' assertion that the seller's commitments of supporting the community is inappropriate does not meet the WMPA's expectation of adequate community benefits and requires the establishment of a third-party community benefits organization for administration purposes. Does not take into consideration that direct funding to the Friends of Kukui watershed and the Coral Reef Alliance will likely result in greater benefits without a third-party administrative organization. Funding and administering organization would be less financial support for community organizations. Do you see that, Ms. Martin?
I do.
Thank you. And then I'm going to direct your, let's look at subsection C. So I will read this subsection out. Please acknowledge that Kahana Solar has yet to provide any tangible numbers and or information regarding its proposed community benefits package, including amounts and terms of proposed benefits. Do you see that subsection, Ms. Martin?
Yes.
Thank you. So I'm going to scroll down to your response. In subsection C, you respond, Kahana Solar has stated in its responses to WMPA Kahana IR 27 and 30 that it will formalize agreements with nonprofit organizations it intends to support their funding. That agreement, the level of funding and terms identified, is expected to remain between the seller and benefiting nonprofit community organizations. Do you see that, Ms. Martin?
I do.
Thank you. So I just had a question about that response, if you don't mind. Does subsection C, does this response mean that Maui Electric will not know the terms such as the amount of any funding between seller and the nonprofit organization?
Yes, that is my understanding. It would remain between the seller and the benefiting organization that they select.
And why is that?
I think generally the expectation from the company is that they do provide community benefits. We give them the opportunity to learn from the community where they best feel they can make a difference and support. It is their investment, their own investment into the community by way of their commitment to support the well-being or the future wellness of the community that they do business in. It's the company's expectation that they be good stewards. And so we allow for that relationship to develop directly between them.
Okay, thank you. Will Maui Electric ever know the amount of any funding?
I don't expect that we would.
Thank you. And I have a question about another part of this RIR, section H. So let me go to the question first. Section H asks, has MECO and or the companies been made aware of any issues associated with community benefits packages for renewable energy projects about in the last 10 years? Do you see that?
I do.
Thank you. So I'm going to scroll down to your response, H. And you state yes. Do you see that?
Yes.
Okay. Sorry, I'm going to scroll back to the question. Could you please explain further, elaborate as to what these issues were?
Sure. I wouldn't.
Yeah.
Sure, I wouldn't be able to provide details. They're not top of mind for me, but to the question that if we've been made aware, yes, we have. A couple that come to mind are, of course, the Pai'ahu project here recently on Maui and on another island on Oahu with the Puamakani project.
Okay. Sorry, just because it's opened the door in this IR, I just wanted to know what were some of the issues that came up with the community benefits packages, if you're aware, with the Puamakani?
To my understanding, from the very little I know, it being on another island, that one community's preferred or desired that the benefits be more direct to them in terms of location versus a nearby community.
Okay, thank you. And then for Pai'ahu, which is your island, sorry, can you briefly kind of explain what issues you're aware of with the community benefits packages for that one?
Sure. I don't know the details off the top of my mind. Those things could probably also be addressed by the seller since it is the same developer, Interjects. But as the project was being developed and brought out to the community, there were a number of issues that were raised, all pretty public. And those have to do with construction or access to the area and whether or not there could be benefits that were specific to the Maui Meadows neighborhood, which was the closest to the location of that project.
Okay. Thank you, Ms. Martin. I have no further questions.
Sure, thank you.
Thank you. Now Kahana Solar.
We have no questions for this witness, Chair. Thank you.
Thank you. West Maui Preservation Association.
Yes, thank you, Chair. I'll be cross-examining Ms. Martin. I'm Beyonce Saki with West Maui Preservation Association. And I just want to thank you, Ms. Martin, for all of your years of service to the community and your different roles in Maui. So I'm glad that you're here.
Thank you.
So starting actually first, picking up with that that last question that the consumer advocate asked. So you just testified that in the Napua Makani project, one community preferred the benefits be more direct to them as opposed to another nearby community. Is that correct?
That is correct.
And was the one community that wanted the benefits to be more direct to them, that was Kahuku, where the project would be sited, and the nearby community was not Kahuku, it was outside of Kahuku. Is that correct?
I believe so, correct.
So is it possible that the community benefits distribution can be material to how, to community outreach and engagement?
Could you clarify or expand on that?
Yeah, I should. Thank you. In this example, or I'm asking you to think of, to respond to whether the distribution of community benefits, can that be material to whether it's really benefiting the host community, the community in which the project is sited?
It could, every project, every community is different and unique. The dialogue, the discussions, the experiences that a community comes to the forefront with at that particular time. A community today, it can be experiencing a whole, different needs basis compared to 5 years ago, even 5 years from now. So it's hard to kind of just blanket say it could or could not. Definitely, we would want it to be reached through an agreement between a developer and the neighborhood or the community that it is intending to be in.
Okay, and this is also sort of a follow-up to the consumer advocate's question, and I can refer to the rebuttal testimony at page 6 if it's needed. But is MECO's position that it disagrees with WMPA's, the West Maui Preservation Association, I'll just say WMPA, our proposal to establish an independent entity to distribute community benefits because direct funding would be reduced by administrative overhead. Is that correct?
I believe that was my testimony, correct. Yes.
Okay. And is MECO informed of Interjex's budget for its community benefits program?
Are we aware of their community benefits project? I am not.
And is MECO assuming that their budget? Yes, I was asking about their budget.
No, I am not aware of their budget as it relates to that.
And is MECO assuming that Interjex would not be paying employees or contractors to develop, budget, and administer community benefit funds?
I don't know the details of how they're going to administer community benefits. I do know that they've been in discussions with a variety of benefiting organizations. I am aware of West Maui Preservation Association's preference for a third-party administrator. The details of all of that, I'm unaware.
Okay, but MECO is not assuming that it's going to run all of this on volunteers, all of its community benefits distribution.
I believe so, yes. And that question could best be asked to the seller.
Okay, I will. So is it possible to determine the relative expense of funding Interjex's distribution efforts as compared to a community-based organization, the independent entity, without the information about what is about the budget for a community benefits distribution effort?
I'm sorry, are you asking if there's a difference between the fee that the third party would insert to the benefits package? Or could you clarify?
Yes, that's actually a better way of asking it. Is it possible to determine the fee or the administrative overhead fee if we don't know, or if MECO does not know what Interjex has budgeted for its community benefits distribution effort?
Sure. With a third-party administering agency, sometimes called a fiscal sponsor for a nonprofit. I myself am a former nonprofit director and fairly involved with a number of organizations. So I do know that there has been a range of 5 to 10%, regardless of the amount, and that can make a difference for smaller organizations or larger ones. Sometimes organizations will utilize that if it benefits their function or operations or capacity. Often they do not, though, and the funds will go directly to them to have more direct financial support.
But we don't, actually, I'll move on from this question. This is moving on to community outreach questions. And I believe that Ms. Dejas Matsushima said this is better directed to you. Has MECO made any attempts to reach out to WMPA and begin communications regarding mediation, reasonable steps to address WMPA's concerns to obtain their support for the project?
To my knowledge, no.
No. Okay. And this is kind of related to Commissioner Potter's question. WMPA specifically asked for NEP calculations. Is this something that MECO could provide to WMPA?
That would be beyond my scope for NEP calculations.
Okay. So are you aware that Energex represented that nearly all of those interviewed raised questions about decommissioning of the project and what that entailed, especially for panels and batteries?
I do know that issue came up. I took a look at their consultant's report of the interactions and engagement they had with the community. I think that was the April report dated. And I have seen decommissioning come up among many other issues. Whether or not it was all engagement discussions that it came up at, I don't know.
Okay, and based on prior testimony, it seems like the decommissioning plan is entirely in the discretion of the seller, of Energex. Is that correct?
Yes.
Okay, so MECO won't have any input or oversight over the decommissioning plan, to clarify.
I think that is beyond my my scope of knowledge with regards to the projects.
Would MECO being able, well, let me ask this a different way. Would MECO have concerns about representations about decommissioning, given that, as you said in the Kahana Solar exhibit, community members continually raised decommissioning of the project?
I think we would have an interest in seeing how that would be addressed. It comes up in the issues tracking log. It's come up in their interview notes, in the consultant's report, along with a lot of other issues. And depending on the source of the concern, you know, they're all important for different reasons. And we would certainly keep an eye on it. It's a topic we would monitor and want to know how it is being addressed.
And MECO would have no decision-making power or approval power on that, though?
Not to my knowledge, but that would not be something that I would know anyway, in terms of the PPA or contract.
Okay. So moving on to another question about, you testified that Energex made adjustments to the project in response to community input and referred to a 100-foot setback for non-temporary items from the gulches. Is that correct?
Yes, correct.
And MECO's understanding is that this 100-foot setback would be implemented notwithstanding implementation of other low-impact design runoff measures.
Correct, yes.
Okay. And let's see. This is from your direct testimony. You testify the company is interested in both quantitative and qualitative implementation of community benefits, correct?
Yes.
And you testified Energex, quote, has taken notable steps in conducting meaningful engagement as demonstrated with its funding commitment to the Pu'ukukui watershed and a project partnership with Coral Reef Alliance, correct?
Yes.
MECO has not reviewed any document or contract detailing the Coral Reef Alliance partnership. Is that correct?
Yes, correct.
And MECO does not know the amount of funding commitments to the Pu'ukukui watershed, correct?
Yes, correct. Yes.
Okay. And moving on to labor questions. So does MECO consider impacts on local employment as a non-price factor or any factor in assessing whether the project is prudent and in the public interest?
Well, my scope was in the community outreach plans that any developer would submit in their proposal with labor, in terms of how it affects local economy and supporting the local economy. The company certainly has an interest in observing that and a commitment. I would want to know the developer's commitment to hiring here locally, and I see that Interjects in their proposal has expressed that intent.
But have you seen any agreements to use a certain percentage of local construction workers?
No, I have not.
Okay, and no agreements with MECO about payment of prevailing wages?
I have not. It may exist, but it is not something in my purview.
Okay. And has MECO required any assessments of the feasibility or impacts of importing maybe half of the construction workers to work in West Maui?
I don't know the answer to that.
Okay, you have not seen that though?
I have not, no.
Okay. And this is about the reverse auction. You testified the seller has made, I'll skip that question and just go straight to some other ones. Well, regarding the process and outcome, which you said are equally critical to gathering community concerns. Actually, did you say that?
Yes.
Okay, thank you. Regarding process, was the project location and contribution to Pu'ukukui, well, I'll start with project location. Was that already decided before community members were consulted on the project?
I believe so. They went out to the community to introduce the project. So that to me would have been the logical process.
Do you know if the contribution to Pu'ukukui watershed was that decided before consulting the community?
I'm not aware of that. No.
Okay. So is your understanding of the reverse auction proposal that it's meant to pre-address or address early in the process place-based community concerns about project siting before PPAs are executed?
I think it's a component. So my understanding is that it would predetermine a site, how that site got determined. I don't know to what degree that component is in there.
Has MECO innovated any other means of pre-addressing place-based community concerns about projects before the PPA gets executed?
No, I'm not aware. No.
Okay. And my last question is MECO, do you have the final vegetation management plan?
No, there are a number of technical reports that are on the seller's website. I did not see a vegetation plan, but that question does be answered by the seller, but I have not seen it.
Oh, I guess maybe an easier question instead of going through all of them. Is MECO in receipt of any finalized studies that have not already been disclosed in these proceedings?
I'm not aware of any.
Okay, thank you. That's all my questions then.
Okay, thank you. Commission Counsel.
I have no questions for this witness, Your Honor, or Chair.
Thank you, Mr. Kaitsu. Commissioner Asuncion.
I do not have any questions for Ms. Martin. Thank you, Chair.
Commissioner Potter.
I do not have any questions for this witness, Chair. Thank you.
Okay, thank you. I just have a couple. Ms. Martin, it came up, prior witness talked about, it was in the testimony that MECO would be willing to, I think, open for settlement discussions with WMPA. Would you be involved or the lead on that as the MECO representative?
I don't know that I would be the lead. I could be involved. I'm familiar with WMPA and its principles as well.
What was your job title again?
Director of Government and Community Affairs.
Okay, but well, you said there have been no discussions with this community group yet.
Correct. Not from Maui Electric.
Why?
As far as I know, we've been observing that the seller and WMPA have engaged in discussions, as well as, directly, and they've made their concerns pretty open. I don't think we've been adverse to it, but they have been trying to have some direct communication together or with each other.
I guess what I observe here is it's not a very proactive approach from the utility here in trying to resolve these differences. And so, I guess that's my observation, I'll say. And I guess my question again is why stand back and leave this up to everyone else?
There are other occasions where we have seen a developer work directly with a group that has some concerns and known oppositions, and we want to encourage that and have the relationships there. I don't know that, I'm not saying that we would not here at this stage. WMPA has asked to work directly with Kahana Solar. Kahana Solar has also made it clear that they wanted to work with them.
When you say at this stage, do you view this as a early preliminary stage, or are we pretty far along?
I've taken a look at some of WMPA's concerns, with regards to the outreach, and taking a close look at that, because, I can understand that we ourselves, we do have the outreach. So, I was curious and interested in how that was playing out. But for me, I was watching how the developer was working with the organizations with WMPA. I'm not saying that we would absolutely be willing to. WMPA, to my knowledge, has not come to me. I have not received correspondence that requested, to meet, and neither has the seller asked for it. So I don't view that as standing by, but more wanting that direct relationship to pan out. So if the question is, have they not reached that? We're here today because WMPA had wanted to elevate their concerns more and find resolution. And my assumption is that they can't find it with their direct communications with Kahana Solar.
Okay, what you said is that the companies will, I guess I view that, or my question is, I would characterize that as a reactive approach. You're waiting until one of these organizations comes to you and makes a request. And so that's, would you agree with that?
In this situation, yes.
Have you recommended to your management to take a different approach?
I have not, no.
Do you view the contested case process as a preferred way to try and resolve these matters and differences?
Sorry, no, it is not ideal.
Would it possibly help to have a more proactive approach by one of the key entities here?
I agree.
Okay, thank you. Those are all my questions. We will take recess for lunch. We're gonna give just over an hour. We'll reconvene here at 1 o'clock. Thanks everyone for a successfully beginning to our hearing here. Appreciate your time and effort. We're gonna take recess and we'll see you back at 1 o'clock. We're in recess. Hi, everyone. We're going to get started at 1 o'clock sharp. I have 12:56 on my watch. Thank you. Thank you, everyone. We can file back in the room and we'll get started in a moment. I believe the next witness is Abigail Kirchhoffer from Maui Electric. Okay, calling our hearing back to order. We'll now have witness number 6 from Maui Electric. Will Abigail Kirchhoffer please stand and identify?
Yes, hello.
Virtually. Hi. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Let's proceed with cross-examination, starting with the consumer advocate.
Thank you, Chair. I have no
Great,
questions.
thank you. Okay, Kahana Solar.
Good afternoon, Chair. We have no questions for this witness. Thank you.
Okay, West Maui Preservation Association.
Good afternoon, Chair. Dr. Kirchhoffer, Ryan Hurley here with West Maui Preservation Association. I have a few questions for you. How many of the stage 1 and stage 2 projects has Ramble been responsible for in relation to the greenhouse gas analysis?
I believe Ramble has completed 14 life cycle greenhouse gas analyses, primarily for the stage 2 projects, but we did complete 2 for stage 1 projects.
And prior to the stage 1 and 2 projects, how many solar projects did you yourself perform greenhouse gas analysis emission studies for?
Prior to the initial life cycle greenhouse gas analysis performed for a Hawaiian Electric project, I had not performed any analyses that were sort of similar in this scope. I had completed life cycle solar evaluations in my position as a consultant for Chevron, but not for projects that were similar to the stage 1 or stage 2 projects in terms of for decision making by the commission.
Okay, great. So it's fair to say these 14 are the first ones you've really done the full scope on, then, correct?
Correct.
And I apologize. Have there been the Paiahu one? Was there a full greenhouse gas analysis done for that stage 1 project?
Yes, there was a similar greenhouse gas analysis done for that, although the methodology has evolved as we've developed more information about the projects.
Okay. In its analysis, Ramble provided for the Kahana Solar project, Ramble included, and I quote, projected greenhouse gas emissions directly attributable to the project, as well as indirect greenhouse gas emissions from upstream and downstream activities. Is that correct?
Yes, that is correct.
And this analysis was also modified to the project and its location. Is that correct, Say?
Yes. Yes.
This methodology that you utilized, I quote, was intended to capture both the project's direct greenhouse gas emissions as well as the reasonably foreseeable indirect greenhouse gas emissions. Is that correct?
Yes. Yes.
Now, Ramble also concluded that, I quote, further inclusion of indirect greenhouse gas emissions from the fossil fuel sources was unnecessary. Is that correct?
That is correct.
So this conclusion was made by Ramble because this conclusion was made, if I'm reading the testimony correctly, because the greenhouse gas emissions of the avoided fuel was so much greater than the project itself. Is that correct?
Yes, the greenhouse gas emissions of the avoided fuel, even excluding the upstream or the indirect avoided life cycle emissions, was so much greater than the project.
Okay, and so Ramble on its own decided not to include those indirect greenhouse gas for the avoided fuel. Is that correct, or did you get approval from NEPA?
No, that's incorrect. Ramble worked with Maui Electric and also confirmed the sort of methodology as well as the project inputs and the results with the developer. And Maui Electric and Ramble sort of early on worked together to determine what an appropriate methodology would be. And as we stated earlier, inclusion of, for instance, avoided upstream or indirect impacts would not change the result or the outcome of the analysis that demonstrates that the net life cycle reduction of the project is significant. It would only serve to increase the net life cycle reduction of the project.
So if, for example, there was an error in Ramble's greenhouse gas analysis and the proposed project emissions were in fact much higher than anticipated, would that make Ramble and Miko or Kahana Solar would that make them include those other indirect emissions for the avoided cost at that point?
At that point, Ramble and Maui Electric and likely the developer would sort of review available information and determine whether additional inclusion of avoided life cycle impacts were warranted or would improve the commission's ability to take into consideration the project's life cycle greenhouse gas impacts.
So did you folks come up with a threshold like 50%, 75% greater than avoided or less than avoided then you stop including, or was it just kind of a gut feeling?
We didn't determine a quantitative threshold.
So then what did you make the determination on?
With that question, are you referring to the sort of significance?
I'm talking the determination to not include upstream or downstream greenhouse gases for avoided fuels.
That determination was made because it was clear that inclusion of the additional avoided emissions would not have changed the outcome of the analysis, and it would only serve to make the project look more beneficial from a life cycle greenhouse gas emission standpoint.
Now, are the upstream and downstream greenhouse gas emissions of the avoided fossil fuel, would you consider those, and I quote, to be reasonably foreseeable indirect greenhouse gas emissions?
Those, I might not use reasonably foreseeable, but yes, we could estimate the indirect avoided emissions, and doing so, excluding them meant the analysis was more conservative than including them. And so as we state in the report, and also I believe in many IR responses, the analysis was designed to be reasonable and conservative.
But the point is these upstream and downstream greenhouse gas emissions were in fact reasonably foreseeable by Ramble and Kahana Solar, correct?
Correct.
In performing the necessary greenhouse gas analysis, Ramble, and I quote, estimated upstream construction operations and downstream GHG emissions that would result from the project. Is this correct?
Correct.
And Ramble, I quote, adjusted these emissions estimates to reasonably account for project technology and site-specific factors. Is this correct?
Yes, I just want to clarify that not all inputs were adjusted.
Oh, okay. For example, then, Ramble did not include potential air travel of out-of-state workers when adjusting for site-specific factors. Is that correct?
Not necessarily. So we didn't include air travel because based on the information provided by Maui Electric and the developer, air travel was not expected. We did adjust travel for construction and operations, as well as transportation of material and equipment to and from the site for site-specific locations, including additional travel to the island.
Thank you. So did you just testify that both Maui Electric and Kahana Solar informed you that air travel was not necessary in this instance, or was not expected?
What I meant to testify is that the information that was provided to us by a combination of Maui Electric and the developer at the time the greenhouse gas analysis was done did not include air travel for construction workers, to my recollection.
If the developer had previously testified that a certain amount of previous projects had been made up of out-of-state employees, would those employees' travel to the project site be reasonably foreseeable?
Chair, if I may.
I believe that's oh, go ahead, sorry.
I apologize to everyone for interrupting. We just want to make sure that The questioning does not improperly characterize any testimony. There was reference to testimony of Kahana Solar. We would just ask that there be, respectfully ask that there be some clarification.
Chair, I'm happy to bring up the language where where Miko referenced, and I can ask my co-counsel to do it, where Miko referenced the 104 jobs that apparently Kahana Solar told them to, and also referenced the percentage of workforce that has come from out of state. Is that okay if my co-counsel brings that up for us to all see?
That's okay, but also let's also be, is that in this witness's testimony?
I had asked her previously if she had heard the testimony. So I believe that testimony was when you asked me to stop to questioning that previously.
Let's see the citation.
Yeah, give me one sec. It's Miko response, CA Miko IR 28 at 1.
And who's?
I believe that's
Hurley,
outside of my scope.
Who's the sponsoring witness here?
Chair, I was just asking if she had heard discussed it or had read the testimony. So if she hasn't, I'm fine. But
so
I can.
According to this, that's Ms. Dehoff Matsushima's.
And I believe you told me not to question her about that when I brought it up earlier.
I believe I told you that we had been asked and answered at that point because we had a multitude of questions related to it.
Okay, so are you saying I can't reference this testimony?
Please, let's hear the question.
So my question is, if we were to assume that at least some of these were out of state based on the developer's testimony that Miko cited in its testimony, is that not a reasonable foreseeable greenhouse gas emission that should be undertaken and reviewed in this greenhouse gas analysis?
So I believe a question about whether it's reasonably foreseeable to expect there to be air travel for workers, for instance, it's within the scope of the developer who sort of played the role of providing kind of the project inputs and assumptions, including equipment, activities, and so forth that we relied upon to develop the greenhouse gas analysis.
So I guess I'm saying, did the developer never give you the information that it provided to Kahana Solar about possibly using a percentage of out of state workforce? Was that not given to you, and was that not made part of your greenhouse gas analysis?
At the time of the analysis, no, that information was not given to us. And as detailed in the report and the analysis calculations, you can see the assumptions that were made in terms of the number of workers and commute trips and so forth.
So go ahead.
I'm trying to recall, I believe it's my rebuttal testimony, RT6, where we did speak at a high level towards this. And I think the key point here is that inclusion of potential air travel for construction workers is not anticipated to materially impact the analysis results.
So how did you determine that?
Based on a combination of training and experience.
So you didn't put any calculation in to see how much greenhouse gases it would take to travel from the continental United States to Hawaii?
I don't, my recollection is that we did not do that for this project, again, because we were not instructed that air travel would be necessary as part of the scope of this project. However, for similar other analyses, we have estimated air travel emissions, and in general, they are not significant relative to other emissions that drive project results.
Were those other analyses any of the stage 1 or stage 2 RFPs?
I don't believe so.
Okay, great. So did Ramble also did Ramble assume the use of a single axis tracker in its greenhouse gas analysis?
I would need to refer to the project-specific inputs and assumptions for the solar portion of the project to determine to what extent that was specified. We relied on information from the developer in terms of the solar as well as other technology, material, equipment inputs. And I don't recall whether that was specified.
Okay, it's can you just do an off the cuff determination if the use of a fixed tilt versus a single access tracking would have an impact on the greenhouse gas analysis?
Off the cuff, I would say no. We've assessed a variety of different solar project technology of life cycle greenhouse gas emissions for utility scale solar projects at this point. And across the board, we see similar results that we see for this project, where the project's life cycle greenhouse gas emissions, even when calculated conservatively and potentially double counting certain sources, are much smaller than the estimated avoided greenhouse gas emissions, even when excluding the full life cycle avoided emissions. And so we do not expect that a change in the solar technology to impact the outcome of the results.
Now, from my understanding, when I read the greenhouse gas analysis, it's pretty clear that you guys assumed a fixed tilt system. And it's pretty clear that was provided by Kahana Solar. Would you like me to bring the greenhouse gas analysis report up, have my co-counsel bring that up so we can chat about that?
No, that's fine. Are you referring to the updated or the original? And I don't believe that assumption was changed, but I can pull it up here.
I don't believe the assumption was changed. I'm going off the original, but it's pretty, and if you could just verify that you guys assumed a fixed tilt system, because I do have a few more questions on that.
Do you mind telling me whether that was specified in table 4, or sorry, maybe it was table 5, the inputs and assumptions, or whether you're referring to the written report?
I'm referring to the written report, but I also have a number of questions about table, I believe, 4, which my co-counsel can bring up as well. But honestly, where I'm going is it doesn't appear that there's any information relating to the tracking system, including the motors or the additional hardware associated with the tracking system that was accounted for in the greenhouse gas analysis. Can you verify that without digging too deep?
Yes, the balance of plant equipment should be incorporated based on sort of in 2 different ways. So first of all, the raw materials extraction and manufacturing emission factor for the solar panels accounts for, to my recollection, accounts for sort of balance of plant and tracking material and equipment required for the solar technology. It actually also accounts for other life cycle stage impacts, including decommissioning disposal, all wrapped up in the emission factor that we use to estimate the raw materials and extraction and, or RMEM emissions associated with the solar panel. I'm just trying to remember which calculation table that's specified on, but if it's okay that I don't refer to that table by number, that should be accounted for in that emission factor for the panels. It should also be accounted for in the fact that the developer was requested to provide all material and equipment that was necessary for this project. And so our understanding is that the scope of the analysis and all the equipment that's accounted for in a combination of the solar, the transmission and distribution, and the storage portions of the project that are included in the greenhouse gas analysis should cover the equipment. And it should be based basically on the design that Kahana Solar could better speak to than I could.
I don't want to go too far off track here, but that was, I think, one of the main reasons I was asking if you could confirm that a single access tracking system was not considered. Because when I look at the in-row harmonization study that you guys utilized for the life cycle greenhouse gas analysis for the panels, it says clearly a fixed tilt system was assumed. So that's kind of why I was going there, because I don't know how we can assume that the equipment for utilizing a single access tracker, the motors, the rare earth magnets, all the other stuff that's involved with a different foundational system or tracking system, I don't know how we can assume that it's going to be factored into a fixed tilt system. So I actually have some very specific questions on that, which we'll get to
Can we
later.
get to that? Because I haven't heard a question yet.
Sorry, Chair, I'm trying to build a record here to ask the appropriate questions. So should we just, I'll get there, Chair. To estimate the greenhouse gas emissions for raw materials, Ramboll, and I quote, determine the amount of a given material or equipment used by the project, and then multiply that amount based on a corresponding emissions factor. Is this correct?
Yes.
Now, analysis for the PV panel raw materials utilize kilowatt hours as an amount of a given material or equipment used by the project. Is this correct?
Yes, this is correct.
Would it also be correct to say that the greenhouse gas calculations for the PV panels is not in fact based on, I quote, the amount of a given material or equipment used, but rather an amount of energy produced?
Not quite. So I'm trying to recall the IR where we explained the sort of general emission factor approach, but it's standard practice in that approach to multiply an emission factor by an amount that's not necessarily a weight or a number. And so it could be an amount that's given based on a capacity or an energy value. It could be an emission factor per a number, for instance, per a given unit of a type of equipment, or it could be an emission factor based on weight. And there's a number of different, different approaches that are commonly accepted in greenhouse gas inventories and life cycle analysis.
But your greenhouse gas emissions report stated that the amount of a given material or equipment used is then multiplied by the factor. And I'm just clarifying that kilowatt hours is not either of those. Is that correct?
And not trying to be confusing here, but where we were describing amount, we weren't intending, I don't believe, to limit ourselves to amount defined by a weight or a number. So,
did you use kilowatt hours anywhere else in part of your greenhouse gas calculations, or was everything else assumed to be weight or amount?
To my knowledge, the calculation for the upstream portion of the solar panels was based on kilowatt hours, and for other equipment and materials, that wasn't the appropriate sort of unit or amount to use to scale the emission factors. And this was based on available information and emission factors. Actually scaling the solar panel emissions based on weight would have introduced another layer of uncertainty. And based on the available data and the emission factors provided in units of kilowatt hours, that's why we chose that approach for estimating the upstream emissions associated with the solar panels.
But is it also the downstream emissions as well? Does that include decommissioning?
The emission factor that we used for upstream included more than just the upstream, so it was included in that RMEM emission factor. And then for downstream for solar panels, I would have to look to determine whether the decommissioning and disposal emission factor was scaled based on capacity or kilowatt hours, or whether it was scaled based on weight. For the other life cycle stages, we relied on the weight because emissions, for instance, tied to transportation of equipment and material directly depend on the weight of the material, for instance, the panels that's being transported. And so that's why there's a difference between the raw materials sort of upstream emissions approach as well as that and this inventory-based approach for, say, the transportation calculations.
So the raw material greenhouse gas emissions takes into account equipment lifetime efficiency and performance ratios. Is this correct?
Yes. Our calculations did not explicitly take that into consideration, but our understanding is that the design of the facility takes that into consideration, as well as the solar panel emission factor has that sort of baked into it.
So all of the information for your greenhouse gas analysis came from Kahana Solar, is that correct?
No.
No, what else am I missing? What else came from Maui Electric, or who else did information come from? I'm sorry, let me rephrase that. All the project-specific information relating to the project came from Kahana Solar. Is that correct, or is that incorrect?
Not quite correct. All of the project-specific information in terms of sort of the design of the project, equipment, materials required, construction operations information was either provided by Kahana Solar or in certain cases might have been confirmed by Kahana Solar if there were data gaps. And we worked with Kahana Solar or Maui Electric to fill data gaps. The key project-specific information is the amount of avoided fuel that would be consumed if this project were not approved and constructed. And that piece of information was provided by Maui Electric.
So that's the only piece of information that was provided by Maui Electric?
Not necessarily. As I just stated there, and this is, to the best of my recollection, that's the primary information provided by Maui Electric. There may have been cases, as I said a minute ago, where there were data gaps, and it's possible that Maui Electric helped us identify reasonable assumptions for sort of minor pieces of the project.
Totally. Okay. Let's move on. So I just want to verify, though, the equipment lifetime you utilize in your greenhouse gas emissions report, that might not necessarily be the equipment lifetime needed to meet the NEP, the provided NEP by Kahana Solar. Is that correct?
I don't know. Our understanding is that the equipment lifetime is represents the expected lifetime of a given piece of equipment. And that, again, was provided by a combination of Kahana Solar and Maui Electric. And our understanding is that the design of the facility was designed to meet, whatever is required per the PPA, but that was not something that Ramble was involved in assessing.
Okay, let's move on. So would it be correct to say that the initial greenhouse gas analysis submitted with the application used an inflated NEP number provided by Kahana Solar?
I don't know if it's fair to say inflated in terms of that. It is correct to say that the initial greenhouse gas analysis that was filed used an NEP that was approximately 10% higher than that used in the updated greenhouse gas analysis.
And this NEP was provided by Kahana Solar, correct?
I can just directly speak to the NEP was provided to us by Maui Electric, and my understanding is that it's from Kahana Solar directly, but I don't have firsthand knowledge of that.
And Ramble, as well as MECO, reviewed and approved the greenhouse gas analysis that relied on this inaccurate NEP number. Is that correct?
It's correct that Ramble and Maui Electric reviewed and approved the greenhouse gas analysis, yes.
Was Ramble aware of the NEP error in its greenhouse gas analysis prior to West Maui Preservation Association pointing it out as in its initial information request?
No.
Has Ramble had to amend or supplement any other greenhouse gas analysis it's provided for the companies for other stage 1 or stage 2 projects?
Yes. I don't remember which specific projects we've done this for, but we have updated or amended greenhouse gas analyses typically when the scope of the project changes or new information becomes available.
Okay. So is it correct to say that the only change that was done to the greenhouse gas analysis performed by Ramble in the May 12th supplemental response involved replacing the incorrect NEP with the correct NEP?
Yes, to my knowledge, that was the only input that we changed.
And this smaller NEP resulted in a decrease in expected renewable energy production from the project. Is this correct?
Yes, as it's included in the greenhouse gas analysis. I'm hesitating because the change in NEP did not impact the avoided fuel and resulting avoided life cycle greenhouse gas emissions, which can be confusing. So I just wanted to highlight that.
Great. The number of panels expected to be utilized in the project was not adjusted or reduced in the May 12th supplemental project. Is that correct?
That is correct.
So even though the total amount of clean energy generation from the project went down and the number of panels utilized stayed the same, the projected greenhouse gases for the associated project went down. Is that correct?
Yes, the projected greenhouse gases went down.
And this is based on the emissions for material extraction of the PV solar panels being scaled based on the kilowatt hours, correct?
Yes, the single change in the project results in terms of the estimated emissions was because of the upstream emissions for the solar panel being tied to the capacity. And I'm just trying to make sure I don't misstate anything. That should be the only emission that changed for the project. And then that has, the other main change was that the denominator used to normalize the project avoided and net life cycle reduction changed as well.
Great. So say, for example, that the NEP calculation assumed a tracking system with a 0.6% degradation rate, but Ramble assumed a fixed tilt system with a 0.5% degradation rate. Would this difference have an impact on the greenhouse gas analysis?
The difference wouldn't impact the outcome of the analysis in the sense that the project life cycle greenhouse gas emissions would still be far outweighed by the avoided life cycle greenhouse gas emissions, and the project would still show a significant net life cycle greenhouse gas reduction. I would expect that changing assumptions tied to the solar panel technology or efficiency could, move the project results up or down. But as we've seen with this range of other solar projects that we've assessed with slightly different assumptions for solar panel technology or efficiency or sort of capacity for a given amount of panels, it doesn't change the overall outcome that the project's life cycle greenhouse gas emissions are far outweighed by the avoided life cycle greenhouse gas emissions.
So is there anything that could change the outcome of the greenhouse gas analysis? Or is that just the assumption that give or take any of these little Manini things, nothing can change this?
I don't think it's fair to say that nothing could change it. For instance, if the solar project were displacing only other solar projects, then you wouldn't have such a great difference between the project and the avoided emissions. But I do think it's fair to say that based on sort of my experience and what we've seen so far for the range of projects we've assessed, changes in specific design features or changing a specific technology, from sort of one panel technology to another, you could see, increases or decreases in the results, but we wouldn't expect them to be material in terms of changing the outcome of the result that shows that the solar project is projected to have a net life cycle emissions reduction because it's displacing higher carbon intensity electricity generation sources.
I think this is where I was going earlier when and as I was explaining, I was trying to set these questions up, is that we have a lot of tiny little incremental changes and a lot of like, well, that won't affect the outcome. That won't affect the outcome. Well, air travel, that won't affect the outcome, or PV tracking, that won't affect the outcome, or, degradation rate, that won't affect the outcome. Is it possible that when we layer all these little incremental changes on top of each other that we could affect the outcome?
Trying to figure out the the right way to explain this without being not flippant's not the right word, but so it's possible to imagine designing a solar project that would have a much higher life cycle greenhouse gas emissions impact than the project characterized here. For instance, if you said that every day, every single construction worker has to be flown across the world and back to build the project, would that have a significant impact on the emissions if construction takes, say, a year or longer? I have not run the numbers, but yes, I would expect something that extreme could impact and sort of make a significant difference in the project results. The reason I confidently state that, no, I don't believe any of the potential changes would be material or would change the outcome is because based on our understanding of these projects and past experience estimating life cycle emissions tied to construction and so forth, that would not be reasonable.
That was actually a very good explanation. So kind of going off of that, you mentioned workers flying in every day from around the world. In Hawaii, typically on the outer islands, especially when you're dealing with high skilled labor, right, a very specialized labor, oftentimes that labor is located on Oahu and will fly outer island on a regular basis or daily. Is that something that you guys looked at into the in the greenhouse gas analysis? If you had specialized workers for this project that would be flying over?
No, we did not. And just to avoid confusion, I believe I stated this, but I might not have. My example was for much longer distances, but I do think that what you can see overall for these projects is that in general, the transportation emissions are relatively small relative to the raw materials manufacturing emissions. But even with that, the total project's life cycle emissions are just so much smaller than the avoided life cycle emissions of the fossil fuel that would otherwise be consumed if the project were not built and approved, that it's just hard to imagine potential changes and assumptions tied to where workers are coming from would materially impact the results.
So, kind of in related question, something that we've dealt with is some Maui developers in the past have actually been charged and are in the middle of settling lawsuits regarding the use of unauthorized foreign labor. If that were to happen, would that increase? If we were to use unauthorized foreign labor from perhaps another country, would that dramatically increase the greenhouse gas analysis?
I don't have a basis for answering that.
Okay. I'm going to just a few more questions regarding the table. So I'm going to have my co-counsel, if she can bring up she can share her screen for the greenhouse gas tables. I believe it's table 5. for the project inputs and assumptions from the greenhouse gas report, Ramble, Table 5. Perfect. Thank you so much. So first of all, I'm going to start with the number of panels. The number of panels, 98,888. This was provided by the developer.
Yeah, yeah.
And do you know if that includes degradation as necessary to meet the NEP requirements, not the lifetime, but the NEP requirements?
Our understanding is that it does. That number of panels is meant to include the total number of panels that would be required over the project lifetime. And the scope of this greenhouse gas analysis is intended to reflect sort of the project that the commission is considering approving the PPA for.
Would the number of panels differ if it was a fixed tilt or a single access system?
I don't know.
You don't know. Okay. So the next one I want to talk about is the module efficiency at 17%. Do you see that module efficiency at 17%?
Yeah. Yeah.
So you use this in your calculations?
No, I believe, as we stated in the report, to the extent that a project-specific input, such as a higher module efficiency, would decrease the estimated emissions, then we didn't adjust the emission factor. So that's one of the ways that the analysis was designed to be conservative. If the module efficiency were lower than that of what was assumed in the sort of literature results that we used for the solar panel emission factor, then we would have adjusted it to account for a lower efficiency.
So does the module efficiency depend on the tracking system or not?
I can't speak to that. I would refer to Kahana Solar in terms of any sort of specific design questions about the solar technology or the number of equipment and to what extent you know, it's what is needed to meet the NEP.
Okay, great. Next, I want to look very quickly at Appendix Table A2, the raw material extraction and manufacturing for solar greenhouse gas emissions calculations. Let's give my co-counsel a second to pull this up. Thank you for your patience.
Sorry, what PDF page number is that?
I'm at 136.
47. Oh, sorry. I'm probably looking at the updated version of it. And in case this helps speed things up, I have it in front of me. I don't know if everyone else needs to see it or not, but.
I guess I just wanted to verify that on this you have. I'll wait till my co-counsel brings it up, I think, if possible.
I'm sorry, I didn't hear. What page is it on? That's in the rebuttal testimony?
I'm going off.
Great. Sorry, you said appendix table A7?
A2, appendix A2. Do you have it in front of you, Dr. Kirchhoffer?
Yes, I have A2 in front of me. for the updated analysis, but I know what's different between this and the original analysis as well.
So I just wanted to go through this a few things. So this 98,000 panels in this Appendix A2, that was not used in the calculation. Is that correct?
Yes, that's correct. In this case, it was just a fact of multiplying the electricity generation in kilowatt hours by the life cycle greenhouse gas emissions factor and then converting it to metric tons of CO2.
Okay, and so now I'm reading the GHG emissions factor. I'm reading footnote 2, where it says blah, 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 interval harmonization study. It says to a performance of 0.08 module efficiency at 10.9% solar radiation and a lifetime of 30 years. So what's the lifetime included in here? So, you know, we know that the developer has given us a higher number based on the degradation rate, but then this has a lifetime in here as well. How do we correspond that we have like different lifetimes and different inputs here?
So in this case, we reported that the lifetime was 30 years, even though the project lifetime is assumed to be 25 years. And I don't recall offhand which testimony or IR we explained this in, but essentially if we were to tweak this emission factor and have it only represent the first 25 years of the solar panel's lifetime, we would expect that emission factor to go down per given capacity, because as you're familiar with, sort of over time, the solar panels become slightly less efficient or they degrade. So the first 25 years, they would have a lower life cycle emission factor than if you included the full 30 years on average. We didn't attempt to make that sort of adjustment. One, because we didn't think we had enough information to do it accurately. Two, because it would only serve to decrease the emission factor for the solar panels and make the project look more favorable. I think those are the main two reasons that we didn't make that adjustment.
So, I mean, and just so you can hear where I'm coming from. So when you calculated the total production of the project, you took the NEP and you multiplied it by 25. Is that correct?
We were provided that as an input, I believe, but yes.
And then and at the same time, the developer provided you the total amount of panels, but he didn't give you the calculation on how many panels are going to be replacement panels, how often they're going to be replaced, things like that. You just assumed total number of panels for the whole project, no life with a 25 or 30-year lifetime. Is that correct?
No, that's not correct. In general, and I believe Kahana Solar would be able to speak to this, as we were going through the information gathering for the project, we tried to ensure that the number of panels reflected not just what's installed, say at the start of the project, but actually what's required for the term of the PPA to meet the capacity. So it should account for degradation or any potential replacements that might be needed. And this, again, was information that we relied on project developers to provide us, but we worked with them through the data gathering process to confirm that the number accurately reflected the number of panels required to meet the NEP.
So since you work with them through that whole process, can you tell me about what will the initial number of panels be installed for this project, and how many panels will be needed throughout the life of the project?
No, I don't have that information available, and I don't know if for this project that's specified or if it was just a matter of the developer confirming that we have the correct and appropriate total number of panels.
Oh, and I guess that's where I'm going at, is that we're relying on so in essence, for the total number of panels, we're relying on the developer's assumptions, correct?
Yeah.
And okay, perfect. Thank you. I have no further questions.
Can I just correct? I don't know if it's fair to say the developer's assumptions, but the developer's information and sort of design of the project.
Okay, thank you very much. I have no further questions.
Sure, thank you.
Okay, thank you. We're going to go to Commission Counsel now.
Thank you, Chair. Good afternoon, Ms. Kirchhofer. I just wanted to ask a few questions about some of the testimony that was just occurred back and forth. So I guess I'm trying to get a better sense of the orders of magnitude of these potential changes we are discussing. So it looks like, according to your updated greenhouse gas analysis, you calculated a number of greenhouse gas emissions associated with the project and then compared them to the amount of greenhouse gas emissions that you estimated would be avoided by the project. Is that correct?
Yes, that's
And
correct.
I believe these are presented in, well, it looks like it's figure 1 in your rebuttal testimony, but perhaps figure 2 in the actual updated greenhouse gas analyses, but it looks like it's the same chart.
Yes, it should be the same chart.
Okay, so I guess I'm trying to understand. So when we talk about these potential adjustments or things that you did not factor in, and I think you indicated that you didn't factor in because you concluded it would not have a material impact. So just kind of considering these orders of magnitude, like what kind of impact would it have had? So if we did include the air travel for workers flying from the mainland or things like that, like how many greenhouse gas emissions are we talking about?
So in terms of potential travel emissions, to put an actual number on it, we would need to know the number and the distance and so forth. For any time where we've included air travel for other projects, it wouldn't significantly impact the project emissions. And if you're looking at the figure, the project is sort of the small black bar. You know, the voided is much greater, and then the net is just the difference between the two. For any of the potential changes, for instance, by including decommissioning disposal of some of the equipment that was assumed to be left in place at the end of the project lifetime, as we've demonstrated in, I believe it was Consumer Advocate MECO IR 48, any potential change would be very insignificant. I believe less than 1% of the net emissions life cycle reduction of the project, although I'd want to refer to that to make sure I'm not misspeaking. The other sort of exclusion that we spoke about earlier in my recent testimony was that of the avoided upstream or sort of indirect emissions. And that's really the one potential thing we could add that would make the numbers look a lot different. But as we've explained, it would only serve to make the project look better from a net reduction perspective. And what you would see there is that that tallest avoided bar would increase by, say, about, I don't know if it'd be 25 or 30%. And so it would just get that much bigger than the project, and you would have a commensurate increase in the net reduction of life cycle greenhouse gas emissions due to the project.
Okay. So just maybe to kind of put it back into sort of layman's terms, so my understanding is just that your back of the envelope estimate is when you say not material, it sounds like you ballparked it about a 1% change or something like that. Is that fair to say?
Oh, in terms of a quantitative threshold? Working with Maui Electric, we did not determine a quantitative threshold for what would be considered material or not. I guess in simple terms, you sort of know it when you see it. So far, any of the potential changes that we had considered were all sort of obviously immaterial. And yes, they often tended to be, very minor relative to the total project emissions and to the net project reduction. But we didn't attempt to assign a quantitative threshold because that didn't seem necessary. And so we left it at that.
Okay, so just for illustrative purposes, it's not like it would double the black line or anything like that.
Right. No, it would not.
Okay. Thank you. I have no further questions, Chair.
Thank you.
Thank you, Mr. Kayetu. Commissioner Sunstein.
I have no questions for this witness, Chair.
Okay, Commissioner Potter.
I have just one question for you. Thank you for being here today. I was curious on why, or actually, I'll ask you, was the Kahana grid charging for the battery included, which is going to be effective after 5 years? Would that be included in your analysis? Did you look at the potential, because that would be fossil fuels that would be charging the battery on this system in 5 years, in the event of, that there's not enough electricity, and so we're not utilizing the battery. So was that considered?
No, our analysis did not consider that, in the sense that we understand under routine operations, the battery will not be charging off of the grid. And so the analysis was designed to consider sort of routine and foreseeable expected operations.
Excellent, great. And then one other question for you is the CA's testimony on page 38. They talked about the possibility of looking at the whole portfolio of projects, including stage 1 and stage 2, and doing a greenhouse gas analysis on that entire portfolio. Is that, or just phase 2, for example, or any type of mix? But I think phase 2 would probably be more applicable. Did you consider looking at the whole portfolio of renewable projects, and if not, what would be the benefit of doing that?
So in this analysis, we did not consider the sort of full portfolio, although I would defer you to Maui Electric in terms of to what extent that was considered or not considered with the avoided fuel results that we relied upon in our analysis. I'm just looking for, I believe part of it's my rebuttal testimony, RT6, includes the sort of high-level portfolio assessment that does show the net operations emissions reduction for the projects, if you consider the project as a portfolio as opposed to sort of standalone. But in terms of why or whether that should be considered, we relied on Maui Electric's direction for that.
Well, thank you very much. I have no further questions, Chair.
Thank you, Commissioner Potter. I'm going to ask a favor here, Ms. Kirchhofer, and the answer can be no, but do you have your testimony that you could put up on the share screen, and particularly rebuttal testimony, the figure Mr. Kayetu was talking about? It's figure 1 from your rebuttal, and I think it's that or figure 2 in the actual updated analysis.
Yes, I'm happy to pull it up. I unfortunately have it open in front of me, but not in the file. Is it okay if someone from Maui Electric points me to the right book so that I can open it? Otherwise, it just might take me a moment to find it.
Or do we have someone on the Maui Electric team that can put it up on the share screen?
Yeah, Tyler,
I
are you able to
apologize,
pull it
I
up,
didn't have it.
or Becca?
Great, thank you.
Yes, that's the one. Okay, so just qualitatively, the avoided column here, the tall one.
Yeah.
These are the avoided emissions over the term of the project. And I think from all of the discussion here, this is almost entirely based on the avoided emissions from the displaced fuel over the lifetime. Is that correct?
Yes, I would just add one more detail, which is it's the avoided direct combustion emissions from the displaced fuel.
Exactly. It's not including all of the other upstream embedded emissions in bringing diesel fuel from wherever it is in the world to Hawaii, to Maui, to the power plants. Correct. So that bar would be taller. And I think what you said to Mr. Kaitsu would maybe be, and this was your ballpark, 25%
Right.
or so higher, but still much higher than the first bar.
Exactly.
Okay. And if I look at, I think it was table or attachment 5 and exhibit 3 in the application, that was Maui Electric's estimate of the avoided fuel. And so this analysis is based on the avoided fuel in that table, which I think I said, what I believe said it was about 1.8 million barrels of diesel fuel avoided over the life of the project.
So subject to check, but yes, the avoided emissions are directly dependent on the avoided fuel estimates provided to us by Maui Electric. And I could quickly pull up the actual calculations if that would be helpful, but otherwise that number sounds right. I just don't remember it offhand.
There was a little bit of ultra low sulfur fuel oil, or sorry, ultra low sulfur diesel, and then some biodiesel, but by and large it was based on avoided diesel emissions.
Yes, by and large it was based on avoided diesel. And then I would say, you know, the biodiesel I think is about 1/10 of that, but because the biogenic CO2 emissions from biodiesel are not accounted for, you know, the biodiesel contributes negligibly to the avoided emissions. And that's another way that this is conservative.
Okay, and then the first column are all of your estimates of all of the embedded emissions in the raw materials for the solar plant, the battery, transportation of those materials to the project construction. But so everything, I mean, it is an estimate, so it's subject to lots of assumptions and uncertainty. But you know, based on the information you're provided, that first bar is kind of the total lifetime emissions associated with the project.
Yes, accounting for all life cycle stages and the best and reasonable information available to us at the time of the analysis.
Okay.
You know, provided and confirmed by the developer. Yep.
The numbers up above this chart show that the avoided emissions are more than 10 times the project emissions.
Yes, even with the analysis designed to be conservative in the ways that we've discussed, the avoided emissions are more than 10 times greater than the project life cycle emissions.
Okay, and that number will go higher again, as you said, if we factored in all the life cycle emissions with the fuel.
Yes.
Okay, but you did also talk about, and I think this is important for maybe the follow-up analysis that Commissioner Potter is talking about, if this was all based on an assumption that this project will basically displace diesel over the lifetime. And so if we look at possibly a different scenario with all the projects together, where there's far more one renewable displacing another renewable, that's going to cut down on the middle bar. Is that correct?
Generally, yes. If this project displaced more renewable energy than is currently assumed, then yes, we would expect the avoided to decrease.
Low emissions renewable, so other solar or wind, basically, not necessarily the biodiesel like the analysis assumed.
Yes, and I would say that Maui Electric can, you know, definitely speak in more detail to the assumptions behind the avoided emissions shown here and how that would change if you accounted for sort of the portfolio of projects. But yes, as my rebuttal testimony included, you still see a significant avoided benefit for the project, but it would decrease if you assumed relatively less fossil fuel were displaced.
Okay, thank you. Those are all the questions related to that. I just had one other area. Can you explain to us the reasons needed, why the update was required?
Yes, so the update was required because or Maui Electric requested we update the analysis because of a changed input. I think referred to in the PPA and numerous testimonies as the NEP value, but what we refer to as the capacity, which impacted our analysis both in terms of the emissions tied to the upstream emissions for the solar panels, as well as change the denominator that we use for the projects avoided and net reduction life cycle intensity results.
Okay, and it changed for what reason?
My understanding is that it changed because some combination of Maui Electric and Kahana Solar realized that the value that the initial analysis was based on was incorrect.
Okay, and do you know what, if any, actions are being taken to avoid that from happening again?
I can't speak to what's happening sort of internally for Kahana Solar or between Maui Electric and developers, but in terms of sort of how Ramble's working with Maui Electric, anytime that we complete the project, as well as any time that something like this happens where an input changes, we try to understand whether there's an opportunity for us to do additional checks and potentially avoid this in the future. And so I think I should let Maui Electric speak to that more specifically, because this input was provided to us by Maui Electric, I believe from Kahana Solar. But on our end, what we do for key inputs such as this is sort of sense check them to the extent that we can. Now, unfortunately, when we did that in this case, the 10% difference between the P50 and the P95 NEP value didn't show up. But what we did is sort of check that, does this capacity sort of make sense in general, given the information we have about the solar technology and so forth. So, you know, on our end, we'll continue to do checks like that, which would catch errors that might significantly impact the project results. The other thing that we will do is just add more detailed instructions during data gathering to be more specific about what that capacity number that we're requesting should represent, and to make sure that it matches what's in the PPA.
Okay, thank you. Those are all my questions. Thank you very much.
Thank you.
Our next we're going to move to the next witness from Maui Electric, is Lisa Dangelmeyer. We have Ms. Dangelmeyer step forward on the WebEx, please.
Chair, if I could, our next two witnesses did not submit direct testimony because they are testifying here today just to sponsor witnesses. So if there are going to be questions of these witnesses, may I ask for leave to just do a very brief direct examination to establish their background and so forth?
Okay. We'll allow the director. How quick are we talking about here?
Just like 2 or 3 minutes.
Okay, we'll allow it.
Chair, I'm going to have to object at this point. I thought we didn't have this opportunity with any of our witnesses.
We've heard the council's request. We're going to grant it. Objections noted.
Thank you.
Thank you, Chair. Perhaps Ms. Dangelmeyer, if she can be sworn in, Chair.
Yeah, you cut me off right before I was about to.
I'm sorry.
Okay. Ms. Dangelmeyer, do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you.
Okay.
Please proceed.
Ms. Dangelmeyer, can you please spell your name for the record?
Lisa, L-I-S-A, Dangelmeyer, D-A-N-G-E-L-M-A-I-E-R.
And who is your current employer?
Hawaiian Electric.
And what is your position at Hawaiian Electric?
I am the Director of System Operations for Hawaii and Maui County.
And how long have you held that position?
Subject to chat, about 2.5 years, I believe.
Okay. And what are your general duties and responsibilities as part of that position?
I'm responsible for the personnel and policies regarding grid operations for Maui Island, Hawaii Island, Lanai, and Molokai.
Okay. And are you here today as a sponsor for IR responses on behalf of Maui Electric?
Yes.
And are you the secondary sponsor for the responses to CAIRs 21 and 27?
Yes.
Okay. And can you just briefly explain what does it mean that you're a secondary responses or a secondary sponsor for these two IRs?
Can I explain that?
Yes.
Probably not as well as I should be able to, but I'm here to support the primary sponsor of the testimony in those specific areas identified in those IRs that you just mentioned.
Okay. Okay. And thank you, Chair. That's all I have on direct.
Okay, thank you. We'll go to cross-examination by the consumer advocate.
Thank you, Chair. We have no questions for this witness.
Kahana Solar.
No questions, Chair.
Thank you. West Maui Preservation Association.
Chair, we originally had a few questions, but I think most of it's been covered in the existing testimony, so we're good not to ask any questions of this witness. Apologies for having her be sworn in.
Okay, thank you, Mr. Hurley. Commission Counsel.
No questions for this witness, Chair.
Commissioner Sunsian.
I have no questions for Ms. Dangelmeyer. Thank you, Chair.
Commissioner Potter.
Thank you, Chair. I have no questions for this witness. Thank you.
Okay, same goes for me. No questions. Thank you for joining us, Ms. Dangelmeyer. But easy day. Thank you again. So we're going to go. We'll go directly to next MECO witness, Mina Tandy. I'm going to swear in. I'm assuming, Mr. Hayani, you want to do direct examination, very brief again?
Yes, please.
Okay. Tandy,
Chair, just to be on record, I'm going to have to object once again to the direct examination of this witness.
Okay, understood, and granting for the same reasons. Ms. Tandy, do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Thank you, Chair. Ms. Tandy, can you please spell your name for the record?
My first name is Myrna, M-Y-R-N-A, and my last name is Tandy, T-A-N-D-I.
Okay, and who is your current employer?
I'm currently employed by Hawaiian Electric Environmental Division.
Okay. And what is your position at Hawaiian Electric?
My current position is Senior Environmental Scientist.
Okay, and how long have you held that position?
I've been in Senior Environmental Scientist for over 4 years.
Okay. And what are your general duties and responsibilities as the environmental scientist?
My responsibility include air permitting, air compliance, calculating emissions reporting, and greenhouse gas related tasks.
Okay. And are you here today as the sponsor for certain IR responses on behalf of Maui Electric?
Yes.
Okay, and then rather than go through each and every one of the IRs, is it your understanding that Maui Electric has submitted a list of IRs and filed that with the commission in terms of the specific IRs that you are sponsor of?
Yes.
Okay, thank you, Chair. Nothing further.
Okay, thank you. We'll go with the cross-examination by the consumer advocate.
Thank you, Chair. We have no questions for this witness.
Okay, thank you. Kahana Solar.
No questions, Chair.
Thank you. West Maui Preservation Association.
Yes, Chair, we do have just two simple questions, I hope. Miko previously testified that savings, and I'm quoting here, depicted in the greenhouse gas analysis submitted in docket 2020-0142 depend on a number of factors, including but not limited to the amount of kilowatt hours accepted directly from the PV system directly into the grid. Is that correct?
To my recollection, yes.
However, is it correct to say that the greenhouse gas analysis was not dependent on energy that was delivered to the grid?
I believe that is that is one of the factors. The dispatch energy is a factor to calculate the avoided fossil fuel emission that would have been displaced by the generation of the facility.
Okay. And that comes from Maui Electric, correct?
That comes from Maui Electric, yes.
So then only the avoided costs assume dispatch to the grid. Is that a correct statement?
By cost, you mean avoided fuel consumption?
Yes, apologies. Thank you for the correction.
Yes, avoided emission is based on how much fossil fuel is being replaced by the facility.
Perfect. So, and then my last question is, the greenhouse gas analysis for the Kahana Solar project was performed by Ramble on behalf of Maui Electric. Is that correct?
That's correct.
And the greenhouse gas analysis was based on assumptions provided and confirmed by Interjex or Kahana Solar. Is that correct?
We provided an opportunity for Kahana Solar to confirm the inputs, yes.
But you received at least some or some of the project-specific inputs from Kahana Solar. Is that correct?
Yes.
Okay. And Maui Electric is paying for the analysis. Is that correct?
To my knowledge, Kahana Solar is paying for the analysis.
So Kahana Solar is paying for the analysis, but it's reviewed by Miko. I'm sorry. Is it so? It's on behalf of Miko, or is it on behalf of Kahana Solar then?
Maui Electric is the one who's managing the analysis and contracted Ramble to conduct the analysis.
Okay. Is Miko ultimately responsible for the accuracy and the data utilized in the greenhouse gas report?
I don't know. We use the inputs provided to us for the GHG analysis to who is responsible for the accuracy of the analysis is outside the scope of my testimony.
Okay, I don't have any further questions. Thank you very much for your testimony.
Thank you.
Thank you. Mr. Kayatsu, Commission Counsel.
I don't have any questions of this witness, Chair.
Okay, thanks. Commissioner Sunsian.
No questions for this witness, Chair.
Okay, thank you. Commissioner Potter.
I have no questions for this witness. Thank you, Chair.
Great. Just a couple follow-up. Can you further discuss or elaborate on the quality control process that Miko uses for receiving information, conducting the analysis? And I mean, I'll be honest, when you ask, you don't know who's responsible. At the end of the day, this information is submitted to the commission, so we become responsible for what is done here. It's probably why I'm concerned to make sure that this gets addressed and doesn't happen again. So can you further explain what the process is for quality control?
For the inputs that were supplied by the developer, we provided the list of inputs back to the developers to confirm and review. And then this is prior to the analysis being completed. Upon the completion of the analysis, we also we also provided the draft to Kahana Solar to review and comment. For the emission factors, methodologies, and assumptions, we work closely with Rambo to develop the methodology and assumptions. For the transportation distances, we cross-check with online resources such as C distances and Google Map. And we also compare the analysis with prior analysis for prior projects to confirm that the assumptions and methodologies are consistent.
So can you, where was the breakdown in this circumstance?
I'm sorry, I don't, could you?
Well, the analysis had to be resubmitted after there was errors found. So where was the breakdown?
Upon being aware of the error inconsistency, we requested Rambo to update the NEP and submitted the update to the commission.
And are you aware, because Ms. Kirchhoffer said that maybe someone from Maui Electric can answer. Do you know what is being done to fix this in the future?
Yes, we are trying to implement a dialogue during the data collection process. Having a meeting with the developer to explain the main inputs that we're requesting and the definition to be clear what we're asking, so there is no gap in between what we're expecting to receive and what they think we're asking. So we're trying to implement a discussion prior to sending them the data request input, and then after receiving the data from the developer. Also, we will continue to review the analysis, review the data received prior to the draft, and review the draft after it's being completed.
Okay, thank you, Ms. Tandy. I don't have any further questions. Thank you for your time today.
Thank you.
Okay, that completes the first phase here. Next phase, we'll go into Kahana Solar's witnesses. We're gonna take 15-minute break. Give everyone a breather, let Kahana Solar get their witnesses ready. And so we'll start at 2:40, 16 minutes. You guys got extra minute. So thank you, everyone. We'll see you back here then. Please maybe come about a couple minutes beforehand, get everyone in the room, virtual room, and ready to go. Thank you all. Thank you to all Maui Electric's witnesses. Appreciate your time and participation today. Hi, everyone. Can we have folks start filing back in? Particularly, we have Jamie Horner as our next witness from Kahana Solar.
Hi, this is Jamie Horner.
Hi, just a second. Let us ensure that we have live stream and the recording continuing. Okay. You ready to go, Mr. Parsons? Okay. Yep, we have everything up and running. So calling the hearing back to order. We're going to enter the second phase of the evidentiary hearing with examination of Kahana Solar's witnesses, starting with Jamie Horner. Mr. Horner, do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, let's proceed with cross-examination, starting with Maui Electric. So, Mr. Hyani, were you speaking? I think you're on mute.
I'm sorry. No questions for this witness, Chair.
Okay, thank you. Consumer Advocate.
Thank you, Chair. I have no questions either.
Great, thank you. West Maui Preservation Association.
Thank you, Chair. Ryan Hurley here. Mr. Horner, I'm going to ask you a few questions on behalf of West Maui Preservation Association, if you would mind. Kahana Solar testified that, and I quote, "The current design of the project assumes a single access tracker." Is that correct?
That's correct. That's correct.
And did Kahana Solar also testify, and I quote, "The project may have utilized fixed tilt mounting systems if geotechnical conditions prove unsuitable for single access trackers." Is that correct?
Yeah, that's correct. When we design a project like this, the geotechnical investigations generally come later in the process. And so we have obviously to make sure that the design is appropriate. We've designed this project to utilize single axis trackers, but we have a contingency should the ground conditions prove unsuitable and we need to revert to a fixed tilt.
You testified that panels for the project will cover 65 acres. Is that based on calculations that assume the use of a single access tracking system?
The 65 acres is the combined area of the solar panels alone. However, they will be installed on approximately 220 acres of the project site.
But the question was, did that assume the use of a single access tracker, that 65 acres number that you testified about?
The solar panels combined area is 65 acres.
Mr. Horner, you testified that it'll cover 65 acres. I'm asking you, the assumption you used for that, was that assumption based on using a single access tracker or a fixed tilt solar panels? Or do you not know?
That was based on a single axis tracker.
And is it correct that utilizing fixed tilt foundation would result in a larger footprint with similar project with equivalent output of single access tracking foundations?
Typically, a fixed tilt would require a higher ground coverage ratio, which would mean the spacing between the rows would be smaller, but the panels would fit into generally the same area. However, depending on the conditions.
So is it yes or no? Would it require, sorry, I'm trying to be brief here. Would it require a larger area if you assumed a fixed tilt then?
It depends on the design, but in this case, it may require a slightly larger area, yes.
Okay. In your testimony, now I'm going to talk about some jobs here. In your testimony, you mentioned meeting with the University of Hawaii Maui campus chancellor and his staff. Is this correct?
That would be best asked for my colleague, Ms. Mancinelli. However, yes, I'm aware that we met with him, our team met with him.
Give me 1 second. Let me just verify that. Sorry, I'm reading this from Kahana Solar T1, testimony 1. Is that your testimony?
That's correct.
And on page 8 of T1, you state the construction operations phase of the project will create benefits in terms of new employment opportunities as well as the use of local suppliers. Preference will be given to retaining local personnel, consultants, businesses, and contractors through the development of the project. Kahana Solar has met with University of Hawaii Maui campus chancellor and his staff to discuss their programs from training, solar installers, electricians, etc. So I'm going to ask you once again, did you folks meet with Maui, UH Maui?
Yes, we did, to inquire about their programs and what the possibility was for training within Maui. However, it wasn't specifically about a specific job.
So would it be safe to say that no agreements with UH regarding workforce training and or actual employment for current students or recent graduates was agreed to or exists?
That's correct.
Has Kahana Solar met with any Hawaii or Maui-based IBEW representatives?
What's that acronym, sorry?
The International Brotherhood of Electrical Workers?
I don't believe so.
So it's safe to say that no such agreement exists with them as well?
So Kahana Solar is, by the requirements of the PPA, not a contractor, and we will not be employing directly for this project. So we do not intend to have an agreement with a union such as that.
So then it would be correct to also say that Kahana Solar has made no tangible or identifiable commitments regarding the employment of Hawaii workers that are included in the PPA or any agreement before the commission today. Is that correct?
Kahana Solar has engaged with contractors to determine their ability to build the projects and their ability to supply workforce to build the project. However, we have not engaged into any agreements at this time. It's premature for this project.
Can you confirm that Kahana Solar is incorporated in Delaware and is a wholly owned subsidiary of Energex USA, which is also incorporated in Delaware?
That's correct.
Would you thus agree that Kahana Solar is not a local business?
Kahana Solar is a special purpose vehicle that has been incorporated to build and construct and own this project.
So, but would you consider it a local Hawaii business?
We will be licensed and apply with all the laws of operating in Hawaii, but we are incorporated in Delaware.
Will Energex USA or the Canadian parent company take responsibility if the wholly owned Delaware company created to develop the Kahana Solar project becomes insolvent?
The parent companies of the project operate the project at arm's length, specifically to construct the project. However, there are management arrangements between the parent company and the Kahana Solar LLC.
So are you? I don't want to testify for you. So will Energex take responsibility if the Kahana Solar goes insolvent?
Chair, I think the witness answered that. I think that's asked and answered.
Is it no? Is the answer no?
I think we'll allow that question.
So Energex is responsible for the entity that it created, and it does fund the entity in order to build and construct the project. However, during the course of the project's development, the entity will also attract project financing and become solvent in its own right.
But so I'm sorry, it was a yes or no question. So I'm honestly just trying to say, if this project becomes insolvent during construction, who's going to take responsibility for that at that time?
It's a wholly owned subsidiary of the parents that you mentioned, so it would be their responsibility.
Okay, great. Thank you very much. Is Interjex or Kahana Solar putting up any type of performance bond in relation to project construction?
We have a bond, performance bond for the execution of the PPA with MECO. Other than that, we do not have any other performance bonds.
So will that performance bond cover decommissioning of the associated project?
It's not intended to be a decommissioning bond.
And would it, if for some unknown reason the project was the PPA was made null and void prior to the construction being completed, would that performance bond cover the decommissioning and or the removal of any equipment that was placed on site at that point?
As I said, that was not intended to be a decommissioning bond. It's a performance of the PPA.
Thank you. So just to be clear, there is no decommissioning bond before the commission today or in this present proceeding?
Not that I'm aware of.
Great. So Kahana Solar intends to engage a contractor for the construction of this project. Is that correct?
That's correct.
And it is that contractor, and I apologize, I think you've stated this before, but I just want to get my question out there. The contractor will determine the type and number of positions required, local positions required for the construction. Is that correct?
That's correct.
And Kahana Solar also intends to contract out the work related to the operations of the project to a qualified contractor. Is that also correct?
That's also correct.
And that contractor, the operations contractor, who will determine the number of local full-time employees required to provide the operational service level. Is that a correct statement?
That's correct. But I would have to say that for all contractors that we engage, they will typically find efficiencies in their economics by utilizing local labor. And that's what we expect when we select contractors such as this.
So is that built into your procurement that they use local labor?
It's a selection process we go through, and it's obviously a very important criteria for us to consider when we select contractors.
Will that selection process be made available to the commission for review?
No, that's an internal process for Kahana Solar.
So once again, there's nothing before the commission that would allow us to understand what the commitments are regarding the employment of employees for the Kahana Solar project, either construction or operations.
Chair, I think that misstates the testimony. Clearly, there's something that is available for review by the commission. So we asked that the question be rephrased.
Mr. Hurley, can you further explain your basis?
So Mr. Horner is explaining that the use of local employment will be made part of their procurement process, and that's an internal review process. Once again, one of West Maui Preservation Association's big concerns here is the use of labor and possibly the use of outside labor. So I'm just trying to once again clarify that even though they have an internal process, that internal process nor any commitments related are available for the commission's review in this proceeding.
To which he said he confirmed, correct? So
is he confirming that? I thought there was an objection.
I thought he stated that before that. We'll allow the question, Mr. Horner, please answer.
So Kahana Solar has engaged with contractors, local contractors in Hawaii, in order to assess their ability to construct the project. We expect to use a licensed Hawaii contractor to build the projects, and we do not intend to interfere with their hiring practices. That's up to them in order to do that. And many different contractors have different strategies for how they provide labor to their projects. Some contract it to other entities. Some use a large workforce on their own. Again, those are the criteria that we will assess when we are looking at contractors.
So I'm just verifying that's a negative to the question. That's a no?
Again, that is all premature for this project at this time. These agreements, and we have not selected a contractor this time. We have not entered into a construction agreement at this time. So those what you asked for does not exist at this time.
So you're saying the Kahana Solar will contract out both the construction and operations of the project. Is that correct?
That is correct.
And Kahana Solar has no requirements on employees. Sorry, this is my questions, but you just said there's no requirements for the employment for local. How many full-time employee positions does Kahana Solar intend to maintain during the operational life of the PPA?
Kahana Solar won't employ people directly. That will be up to the contractors that we engage for that task.
So 0 employees is what Kahana Solar will employ for the life of the PPA.
There will be support staff that will be supplied by the parent for any accounting and other actions like that. However, for any of the operational aspects of the project during the operational period, that will be provided by a contractor.
Will Kahana Solar maintain a Hawaii office for the duration of the PPA?
That is something that's still to be decided.
If you had a Hawaii office, would you have Hawaii employees?
I would expect we do. We will. We also have employed local Hawaii employees at this time with Energex in order to pursue the development of these projects. However, they're not directly employed by Kahana Solar at this time.
So Energex will have an office here then. Is that what I'm hearing you say? That Kahana Solar won't have employees, but Energex will?
Energex may, because it has more than one project under development in Hawaii. So that may be a possibility. But again, it's not, that hasn't been committed to or decided at this time.
Kahana Solar has testified about using, and I quote, local supplies and services. Is that correct?
That's correct.
Has Kahana Solar provided any analysis regarding the economic impact of the use of local supplies and services?
No.
So once again, Kahana Solar is making no specific or tangible commitments regarding the employment and or general economic benefits of the construction for the Kahana Solar project. Is that correct?
There is no commitments at this time. However, as I said, there is an economic advantage for us to employ local firms and companies, and that's exactly what we intend to do. However, it's premature at this point in time to say that we will not, because we haven't got to that stage yet.
So,
We
Mr.
have, however, employed a lot of consultants during the development of these projects, and so they are also local employees. Sorry, they're local vendors and suppliers.
Mr. Horner, when will the appropriate time be to determine these things? I'm just we're kind of at the end of this, right? I mean, the contested case hearing is today and tomorrow, and then we have our final position statements and such for the commission. When is the appropriate time to do this?
The construction of the project is not due for many months yet, and so a lot of these items would not be resolved until prior to construction.
So then it's fair to say that the commission will have no say or input on these items, nor will any of the participants in the present proceeding?
This is very typical of projects, and I would suggest that many other developers would operate on a very similar timeframe to this in Hawaii.
But the truth is that this scale and amount of projects that we're trying to incorporate right now is not precedent. We've never done this before. Is that correct?
That is true. There's a lot of projects under development at one time.
And are you aware that guaranteed commercial operation dates are being shifted back for several projects?
I'm not aware of any of the other projects, sorry.
And so has Kahana Solar developed any other projects in Hawaii that have been completed?
No, we don't have any completed projects in Hawaii at this time.
So you can't really comment onto the final length of time it takes for Kahana Solar to develop a project in Hawaii. Is that correct?
We're still in the development phase. We have other projects that are already being developed and are ahead in their construction timeline. So those ones we have more information on.
So my final question about this topic is Kahana Solar stating that it does not consider the use of local workforce to be a quantified community benefit?
No, that's not correct. We defined local employment opportunities as within our response to the utility for this project, and we expect that will be an opportunity going forward. However, at this point in time, it's premature to assess that for the project because those contracts are not being entered into. And so if we don't have those construction contracts complete, we are unable to say which contractor we're using, and therefore we can't specifically say where those employees will be coming from or where they'll be based.
Mr. Horner, it's my belief that in response to Kahana Solar's response to CA Kahana IR6, you stated, and I'm happy to have my my co-counsel put the information request response on the screen, but I'll read it to you. Solar does not consider the use of local workforce to be a quantified community benefit, although it is expected that local workforce will benefit both the project and the community. Would you like me to have my co-counsel put that forward?
No, that's fine. I agree with that.
So once again, I'm going to ask you: would Kahana Solar say that local labor is not a quantifiable community benefit at this point?
At this point, it's not quantifiable. However, before construction begins, we will have construction contracts in place that will make it a quantifiable number.
That's great. Will those construction contracts be made available to the Commission and West Maui Preservation Association for review?
No, that's not an industry standard practice.
If the Commission were to approve the PPA condition precedent on that, would you be okay with that?
Again, it's not an industry standard practice. However, we would obviously respect the Commission's decision.
Okay. Sorry. So is that a Hawaii industry standard or a national industry standard or a Canadian industry standard?
It's not an industry standard. I think if you survey the number of developers that are currently developing in Hawaii for HECO and ask them how many of their construction contracts are available to the Commission and to third parties, I would suspect that there would be not many.
Are you sure of that? I mean, have you done the analysis yourself?
No, that is assumption on my part.
So that's just speculation then to be.
That is speculation.
Great, thank you. Kahana Solar's contract determined, and I quote, "No native birds are anticipated to be harmed by the potential heat island effect." Is this correct?
That is correct.
Where in any of the studies Kahana Solar had performed is this information provided?
Sorry, you broke up there. Can you repeat the question?
Where in any of the studies that have been made part of the present proceeding is the information provided regarding that? And that no native birds will be impacted.
All right, I believe we lost our connection to Mr. Horner.
Yeah, I think, sorry.
Mr. Kotiga, can you contact him? Otherwise, if we don't.
Maybe he'll come back on.
Yeah, we'll give a little bit. Mr. Kotiga, can we? Oh,
there he is.
Okay, sorry, I don't know what you heard. Can we start with the question again?
Absolutely, sorry about that. So Kahana Solar stated that, and I quote, "Native birds are anticipated to be harmed by the potential heat island effects." Where in any of the studies it performed and submitted to the Commission is this information presented?
I believe you misspoke. You indicated that native birds and fauna would be harmed. They will not.
No native birds. No native birds and fauna. And I was just talking about the birds.
Right. So that is Tetra Tech performed a heat island memo for the project, and that was included in my testimony.
And did they specifically analyze the impacts on birds?
They indicated that any heat island effect would be not significant with regards to the upward and downward slope movement of the air, and that any of the birds tended to congregate in the gulches and or the water bodies near, and so would be far enough away that any heat island effect, even if it were to exist, would not provide any impact.
And was that verified by a peer-reviewed study?
That was a study that was done for us by Tetra Tech, who are a globally acknowledged expert and consultant, and brought their experts to bear for this one.
And do you know if any biologists were involved in that study?
The heat island effect was based on the location and the solar array. The birds' locations are known to be in the gulches, and so therefore it wasn't part of the heat island impact.
So were any biologists involved in the Tetra Tech heat island study to such that we could confirm that no native birds would be harmed from the heat island effect?
I can look for the study if you like, but I don't know that at the moment.
I'll move on. Has Energex recorded, documented, or been made aware of any bird strikes and or deaths of bird birds at any of its other projects and/or related transmission lines?
For a solar project similar to
I just said any projects.
Oh, I don't have that information. Sorry.
So you have no information. So you have no information on any bird strikes that have happened at any Kahana Solar sites or any Interject sites. Apologies.
Interject has a lot of sites around the world, and there's a lot of information regarding those, but I do not have that information for you today.
Okay, thank you. Regarding lines and trenching, at least 5 sets of AC collector lines will cross gulches in the subject property. Is this correct?
It's subject to final design, but yes, that is correct.
And will Kahana Solar likely be trenching in the gulches to cross them with the AC collector lines?
Kahana Solar anticipates trenching in the roads that are that currently cross the gulches. There will be no new access paths created to cross the gulches with the AC collector lines, and the AC collector lines would be buried in the existing right-of-ways.
So just verifying, there will be trenching in the gulches then, correct?
There will be trenching in the existing access roads that cross the gulches, yes.
And were those gulches fully analyzed as part of the AIS or CIA, the Archaeological Inventory Study or the Cultural Impact Assessment?
That would be a question better answered by my colleague, Ms. Mancinelli. However, the gulches were, and the access roads that cross the gulches were part of the project study area.
If they were not anticipated in the AIS or the CIA, would Kahana Solar be okay with Commission precedenting the approval of the PPA on those documents being updated to ensure the protections of environmental and culturally significant artifacts and/or species?
Well, as I said, the project study area included the roads that cross the gulches.
But I was unable to find in the archaeological inventory survey or the cultural impact study that the gulches were fully analyzed. It appeared that they looked outside of the gulches.
As I said, we're not intending to go into the gulches. The trenching will be in the roads, existing roads that cross the gulches. For further information around the study that was done in the gulches themselves, you'll have to discuss that with my colleague, Ms. Mancinelli. Now,
Did Kahana Solar state that they won't be bringing anything within 100 feet of the gulches?
Kahana Solar, is this in regard to EMF?
No, I'm just, there was, and I apologize, I don't want to cross the line here, but previously it had been testified that through the community outreach, Kahana Solar had agreed that it would not bring anything with 100 feet of the gulches, of the gulches as part of its, as one of the adjustments it made pursuant to community benefit, community input. So is that not something you've been made aware of?
The project has committed to having a 100-foot setback between the top of gulches and the project area, the project infrastructure. However, for anything further on that, you should discuss that with my colleague, Ms. Mancinelli.
So, but it would be correct to say that as designed, that setback would not include AC collector lines that travel through the gulches, correct?
The gulches, the existing roads that pass through the gulches are included in the study area.
But they might not be included in the archaeological inventory study and the cultural impact study. That's what I'm getting at. There could be some very sensitive things in those roads that we want to protect.
I believe that's all included, but you should confirm that with my colleague, Ms. Mancinelli.
Thank you. I'm sure we will. Okay, I'm going to move on to just several more questions for you, and then we're done. Kahana Solar stated a single access tracker racking system was assumed in the analysis for the Kahana Solar's visual assessment. Is that correct?
That's correct.
And Kahana Solar has not committed to utilizing a tracking system for the project at this point. Is that correct?
As I said, and as we've said in the testimony, our preference is for a single access tracker.
But you have not committed to using a single. I'm apologies. I'm looking for solid commitments here. So have you committed or not to using a single access tracker?
The project will use a single axis tracker, providing the geotechnical conditions allow. When the final design is complete, then we were able to commit to the type of technology to be used. But say that we need to make a commitment now is premature for the project because the final design has not been completed, and that would include the addition of geotechnical data.
So the answer is no?
The answer is our preference is to use a single axis tracker.
But yet there's no, so when will the geotechnical studies be done?
Geotechnical studies were done prior to the final design being complete, which is shortly before construction.
And so will the commission and Consumer Advocate and West Maui Preservation Association, will we have an opportunity to view any studies or updated information once that is done?
I don't believe that's anticipated.
The assumption of a fixed tilt foundation system would likely impact the visual assessment. Is this correct?
It would be a different project. However, as I said, the preference is for a single axis tracker. I would also say that a fixed tilt system is typically lower to the ground than a single axis tracker. So the impacts would be, if anything, less.
But it might be larger too, right?
No, that's not typical.
So it's not typical for switching to a fixed, well, that's irregardless of the point. The point is that the analysis would change if you used a different foundation or tracking system. Is that correct?
The visual analysis considered the entire use of the site, which is larger than the area that we expect to be able to build on. It also included other things that make it the sort of worst case condition that we can imagine in order to do this study. And so the worst case condition was to use a single axis tracker because of the height of the units.
So it's a simple yes or no question, Mr. Horner. If we switch from a fixed tilt access, from a single access to a fixed tilt foundation, would the analysis change? It's a yes or no question. And I apologize to be so direct here, but it's a yes or no question. Would the analysis change?
Yes, it would change. However, the effects would likely be less.
But we don't know because we don't see it, right? So moving on, would it be possible to model both the fixed tilt and a single axis tracker?
Of course, but as I said, we designed the study so that it would take the worst case into account, including all the different areas that we do not intend to use for the project but could be used, but may be used in the final design. So we have a more expansive area, and we are using the tallest equipment that we have on site in order to make the study conservative in the way that it assesses the visual components.
But the analysis would change. So I'm not going to beat a dead horse here. But sorry, the fixed tilt will take larger space, though, right?
As I said, the terms of the study were to use all the available space that would be required, and were in excess of what would be required by the current design, as well as using the tallest equipment that we would expect, which was a single axis tracker. So we've designed the study to take into account the worst case conditions so that it would be valid for all the different design parameters that we have proposed.
Is that stated in the study?
I'd have to check. But I do know that we have used all the additional land that we don't expect to use, so that is included in the study.
So to be clear, all of the land, you're telling me in the visual assessment you took all of the land, and how many acres did you cover with solar panels? Was it 67 like we talked about?
As I said before, the 67 acres is the land area of the panels themselves. So it does not include any of the setbacks. It does not include any of the PCS pads. It does not include the spacing between the rows. So 67 acres is not the correct number. It's 220 acres is the correct number for the total project area.
Moving on. A single access tracking system was used in the analysis for the Kahana Solar glare analysis. Is this correct?
That's correct.
And Kahana Solar, once again, has not committed to utilizing a tracking system for the Kahana Solar project. Is that correct?
We are, as I said before.
Mr. Horner, you keep dragging this on. It's a yes or no question. Has Kahana Solar committed to using a single access tracker at this point?
Chair, I'm going to have to object as argumentative and asked and answered.
Mr. Hurley, he has given the same answer every time.
That's fine. I'll move on. Is the assumption of a fixed tilt foundation system, would that likely impact the glare analysis?
It would impact the glare analysis, and that would have to be reperformed for that specific scenario.
But you could have performed both a fixed tilt and a single tracker analysis at the same time, correct?
We are very confident of our ability to use a single axis tracker.
Mr. Horner, it's a yes or no question. Could you have done,
Not a yes
could
or
you
no
have,
question. I'm answering your question.
so you could have done both studies at the same time then, correct?
A single axis tracker is our preference and a strong likelihood for the project. We have not performed a glare analysis on a fixed tilt because
Mr. Kodaga can redirect if he wants. My question is yes or no.
Mr. Hurley, let him answer the question.
It's a yes or no question.
You cut him off. Let him answer.
He's not answering, Chair.
He is answering.
Okay, continue.
Can you restate your question, please?
Would it not have been possible for Kahana Solar project to analyze the glare analysis using both a fixed tilt and a single axis tracker?
Yes, it would have. Yes.
And would that not have given you the most conservative estimate about what the glare analysis would be?
Again, it's a binary issue where you're using one type of facility or a single axis tracker, so fixed tilt or single axis tracker. Our preferences and our expectation is to use a single axis tracker, and that's the glare study that we have performed.
So if you do use a fixed tilt system, you will have to do the analysis for this system. Is that correct?
That is a likelihood, yes.
And will that analysis come before the commission at any point?
No, that is due to the final design of the project. And again, the glare analysis would be for a fixed axis, tilt system would actually be not as variable as a single axis tracker because it doesn't track the sun. So the solution for glare is actually a lot easier.
But we don't know that because we haven't seen the fixed axis analysis. That statement you just made was speculation. Is that correct?
No, it's not speculation because we have developed these projects before, and so we understand the ability of the glare plane within a particular design. So we have proceeded with a single axis tracker, knowing that that is the worst case for glare for this particular project area.
I'm sorry, was there not testimony that described that the backtracking or the single axis tracker actually makes it easier to get FAA requirements for the glare at the airport? Is that not true?
No, that's mischaracterized and incorrect.
Okay, so what was it? Can you testify to that?
So backtracking is a function that's used on a single axis tracker. So you can install a single axis tracker with a backtracking function or without. The glare study showed that without backtracking, there was no glare issues at any of the receptors. For the backtracking option, it showed that there would be some levels of green glare, less than 1% at some of the receptors, but it was likely still acceptable for an FAA clearance.
And but we don't know about a fixed tilt for FAA at this point. Is that correct?
That's correct. That's correct.
And that would be something we would probably have to analyze if we went to a fixed tilt.
That's correct.
Okay, moving on. I'm going to discuss decommissioning and greenhouse gases. Kahana Solar's decommissioning plan provided with its RFP response is confidential and it has not made public or for commission. I'll say not been made public or available to West Maui Preservation Association. Is that correct?
That's correct.
And this confidential decommissioning plan filed with Kahana Solar's RFP response was not used in the greenhouse gas analysis performed by Ramble. Is that correct?
We were not requested to provide that specific information for the greenhouse gas analysis.
Is it true Kahana Solar has yet to develop an end-of-life management plan for the project?
Similar to other developers in Hawaii, we've committed to providing a full decommissioning plan within 5 years of approval of the PPA.
So I'm going to ask the question one more time. Is it true Kahana Solar has yet to develop an end-of-life management plan for Kahana Solar project?
We have provided a preliminary plan with our RFP response to the utility. And again, we've committed to creating a decommissioning plan for the project within 5 years of the approval of the PPA. However, we've also discussed the decommissioning parameters and the goals for the decommissioning with all our open houses and with our community outreach. And they include a reuse, because at the end of the project term, the battery capacity as per the PPA will still be at 100%. So its ability to reuse it will be extremely high and it won't be necessarily recycled. The same with other solar panels and other equipment. The amount of solar being generated in the world, or the projects being generated in the world currently, mean that the recycling ability and technology for these
Mr. Horner,
projects
I'm just gonna I'm gonna cut you off. That's it was a yes or no question. You know,
will actually be
just repeating your direct testimony at this point. So, but there are no
Mr. Hurley,
commitments
you asked
regarding.
him the question. Let him finish. He's explaining what their plan is.
So the plan is designed and it will be designed to take into account the latest innovations in recycling technology, the latest opportunities for reuse, and that's why it will be properly incorporated over the next 5 years.
Are you done, Mr. Horner?
I'm finished.
Thank you. So, but there are no concrete commitments regarding decommissioning, recycling, transportation, or anything like that that the commission will be able to review before it approves the PPA. Is that correct?
That's correct. That's correct.
And Kahana Solar at this point is not putting up a decommissioning bond. Is that correct?
To whom would this bond be with?
Do we not think that we can find it? So I'm sorry. Kahana Solar will not be putting up a decommissioning bond. Is that correct?
I'm not aware of who it would be with. Can you describe what this bond would be and who it would be with? And
Mr. Horner, I'm just asking, does Kahana Solar have any plans to put up a bond that will pay for the decommissioning should Kahana Solar become insolvent?
there is no bond for decommissioning, as I've explained before.
I'm sorry, I'm just confirming because you said there was a lot of commitments regarding recycling and such. Kahana Solar anticipates small amounts of battery panels batteries and panels may need to be replaced during the term of the PPA. Is this correct?
That's a fair assumption.
And did you provide this information in terms of how many panels and batteries will need to be replaced to Bramble for the greenhouse gas analysis?
I don't believe that was requested.
So the 98,000 panels that Bramble used for its greenhouse gas analysis, did you provide that number?
We did. However, I would say that the number of panels that would be expected to be changed over the lifetime of a project such as this would number in the hundreds, not in the thousands.
But so were those panels included in that 98,000 panel number you gave to Kahana Solar?
No, I don't believe so. However, it's not expected that any of these panels will willingly be changed. They will be changed if they're damaged or if they're no longer, providing energy. So in this case, we don't expect to have to change panels. None of the panels in there in that number are slated for replacement in any way. It's more, if they're required to be replaced because they're damaged or broken or no longer functioning.
And what about the batteries? How did you figure out how many batteries would need to be replaced?
We didn't expect batteries will be replaced. However, what is included in our assessment is the number of batteries that will be augmented with the system over its 25 years. As you know, with batteries, there is a degradation rate that is far higher than with solar panels. And so as a result, we have to augment the batteries to keep with the PPA conditions to maintain 100% capacity. So we have included in the battery weights the additional batteries required.
Okay, so this is kind of new information to me, Mr. Horner. So how many batteries are you anticipating starting out with? 28, is that correct?
There is 28 units expected to be installed on site.
And how many additional batteries do you plan to add to the project over the life of the project?
So let me back up a bit. The megapack units that we will use for this site have an augmentation unit that attaches to that. So we don't actually replace any batteries, we just add to it. And it's fully designed in from the start, and those batteries will be added as time progresses.
So how many additional batteries do you anticipate adding to the system through the life of the project?
I believe there is, at the moment with the current technology, there is 3 additional units per megapack.
And will they require additional inverters?
No.
So are you the person that I should speak to about the batteries? Are you the subject matter expert, I guess, is the question?
I am the responsible person within Energix for the batteries. However, we engage with vendors that provide their expertise for us as well.
And your anticipation is to use the Tesla Megapack, is that correct?
That's correct.
Are you aware of any significant fires that have happened in relation to Tesla Megapacks in the last few months?
Yes, I am. There was one that happened in Australia during commissioning where a megapack went into thermal runaway and caught fire. However, it was actually interesting in that the fire response plans that were provided by Tesla to the local fire department, as well as the fire testing that had occurred on the megapacks, were very accurate in their assessment of the plans required and the outcomes that they would get from a fire event.
So it sounds like that you've had a chance to look at that incident pretty well. Was that a correct assessment?
We have had basic information provided to us on that incident, but we don't have any detail.
Did it appear at any time that flames actually left the containment unit of the Tesla Megapack?
Again, I don't have that information.
Do you think that this fire would lead credence to the fact that additional fires could happen at the Kahana Solar project?
Again, this incident with the Tesla Megapack occurred during commissioning, and they have not had any related impacts during operation of their projects or equipment. So we don't actually know the cause for this. So to speculate on if that would increase any fire risk is beyond my expertise.
Is the Tesla Megapack a commonly used, widely distributed and widely used in the utility industry at this point?
You're talking about batteries, which are obviously on an increasing trajectory as far as deployments. So as far as what has been deployed in the industry so far, Tesla Megapack is widely used.
So in the degradation rate for the NEP, did Kahana Solar use 0.6%? Is that what you used for the degradation rate?
That's correct.
And is this different than the degradation rate used in the greenhouse gas analysis?
I can't speak to the greenhouse gas analysis.
Did you review the greenhouse gas analysis?
As far as the inputs for it, yes, I reviewed the inputs for it.
Did you review the final analysis?
I noted the conclusions, yes.
And did you happen to look at the inaccurate NEP at that time, or did you miss that?
Again, we provided the inputs for as requested by Mamiko and Rambo. And, our project team did not recognize that was required to be NEP. It wasn't specifically defined as that. So we provided a P50 average annual capacity, which is more generic for the industry. The NEP is actually very specific to the Hawaii projects and is only used there.
You previously testified that Kahana Solar was not provided the formula used to calculate the value provided in the May 12 supplemental response. Is that correct?
Sorry, I'm not sure what you're referring to.
You previously discussed a maximum build-out scenario. So does that maximum build-out scenario include single access trackers or a fixed tilt system?
What's the maximum build-out in relation to? Sorry.
To the visual assessment.
So there is a amount of buildable area that we have assessed for the project, and we expect to be less than that area once the project is built. But obviously there is a contingency amount for trackers or solar panels to be installed should we need that based on our final design.
I think that's all my questions. Thank you, Mr. Horner.
Thank you.
Thank you, Mr. Horner. How are you doing? Do you need a break?
No, I'm good.
Sure.
Yeah, just fine, thanks.
Okay. Then we'll go through and then we'll take a break after we finish with this witness. So that moves us to our commission counsel.
Thank you, Chair. Afternoon, Mr. Horner. I just have a few questions for you. I understand some of the tests and project designs are split between you and your colleague, Ms. Mancinelli, but I understand that you are the sponsor and witness for some of the view plane concerns and the studies or permits that are associated with them. Is that correct?
That's correct.
And just for the record, I'm looking at WMPA Kahana IR 12, or Kahana Solar's response to that. So it looks like here in response to this prompt about view plan concerns, it cites Kahana Solar's previous statements about those being addressed through other permits and approvals. And it looks like here Kahana Solar explicitly references the county special use permit and the state special permit. Is that correct?
I believe that's correct. It's actually it would be better to address those questions to my colleague Ms. Mancinelli, but I believe that's correct.
Okay. I apologize. It has used the sponsor witness for this IR. I can ask Ms. Mancinelli, but up to you, however you'd like to proceed.
No, I appreciate you asking. I am the sponsoring witness for this, and I can confirm that that is correct. However, as far as the details on specific permits and those mechanisms, you might get a better answer from Ms. Mancinelli.
Okay, well, I'll just proceed through the questions if you don't mind. Then, if to the extent you want to defer to her, I'll just ask those questions to her as well. Then.
Thank you.
So I guess what I'm getting at is, so it sounds like you've got these other processes amongst a variety of other government processes ongoing besides before the commission, correct? I think in one of the exhibits to Ms. Mancinelli's testimony, there's a chart of the various other approvals you have ongoing. Is that correct?
That's correct, yeah.
So I guess pertaining specifically to these two proceedings for the county use permit and the state special permit, those proceedings have been initiated. Is that correct?
Again, I would have to defer to Ms. Mancinelli for that one as to the specific timing on those.
Okay. Well, you might not know the answer to this then. My question is just, if they have been initiated, are you aware, or is Kahana Solar aware if there have been opportunities in those proceedings for community groups or interested members of the public to participate or intervene in those proceedings in any way?
Again, I'm not sure of that answer, so I'll defer that one to Ms. Mancinelli, please.
All right, no, that's fine. Thank you. And based on that, I think the other questions I had, I will save for Ms. Mancinelli. So I have nothing further from this witness, Chair.
Thank you, Mr. Kayatu. Commissioner Sunstein.
I just have one question, Mr. Horner, just so it's straight in my mind. So the 67 acres that you talked about is the panels itself, right? It's if we were to line up all the panels next to each other, right, with no space in between.
That is correct. That is the solar panel area, but it's not the project area.
And the project area is the 220 plus acres.
That's correct, because it adds all the inter-row spacing and the other project areas as well.
Okay, so in your different studies that were done, you can defer to Ms. Mancinelli as well. What acre number was used?
So the project area is expected to be 220 acres. However, the project study area was over 400 acres as part of the what was studied for the project.
Okay, so that would include like the roads and the gulches and, or is,
I'm
not sure how big the parcel itself is.
The parcel itself is, the TMK is over 1,300.
Yeah, okay. All right, thank you. Just wanted to make sure I'm straight with all the numbers and how it's being used. Thank you.
No problem. Thanks for your questions.
Thank you, Mr. Chair.
Thank you, Commissioner. Commissioner Potter.
Sorry about that. I couldn't unmute. Thank you, Chair. So I have just a couple of questions for you. I'm going to be around community engagement, which is, I know, a big concern for several organizations here in Maui. We've read a lot of the comments that have come in, and they've indicated that there's a challenge with they felt that they weren't being heard, and they also wanted to have more input on the project. And they I'm curious on, and I know you've had like 70 meetings, and I know that you've done your due diligence to really attempt to listen to the community, but they're very interested in basically a couple of things, right? They would like to see the benefits, the community benefits that you're working with, these other organizations, and they want to get their own third party to do that. So I'd just like to ask you to expand on your efforts with customer engagement.
So that area is very specifically should be directed to my colleague, Ms. Manson-Lani. She'll be able to add a lot more detail to this. However, I believe we've done a very good job of community outreach. And in general, the feedback that we've had from that outreach from the majority of the people that we've been engaged with has actually been very good, and they've been very, accepting of our efforts to inform them about the project. I believe the conditions that you're referring to come from a much smaller group of respondents, and specifically West Maui Preservation Association. We've had a extended effort to do community outreach with West Maui Preservation Association, to the extent of having lots of dialogue with them. And again, Ms. Manson-Lani can go into a lot more detail as to those specifics.
Okay, just one last question on that. I'm curious, I understand that as a result of that engagement with the community, that you moved the project back 100 feet from the gulches. Is that correct?
So the initial design and layout for the project was for a lesser amount than 100 feet. And in engagement with the community members, there was comments about the sensitivity around the gulches, as well as upcoming adoption of some setbacks by the county for that 100-foot limit. And so those were taken into account with the project design early on, as early as we could. And that's resulted in the layout that you see today.
Very good, thank you. So now I'm going to switch gears really quick, and I'm going to ask about grid forming inverters, and how I understand that everyone's going to be in the same boat, but this can be a very challenging asset that that hasn't matured fully, and so do you anticipate it's kind of a learning curve? Are you putting enough buffer around your commercial operation date, and using a new technology, which is not something that has been introduced really into it's just a nascent, right? So I'm curious if you can explain how you're going to manage your system with a grid forming inverter, and then and if you have added a buffer to your commercial operation state.
Well, thanks for your question. It's a very good question. Grid forming is definitely a very growing topic, and certainly we've had a lot of extensive effort in the modelling efforts that we've done as part of the PPA process with MECO to understand the grid forming potential that that our inverters have, and what they're able to support the MECO grid on. Those results were just made available recently through the electronics study that was completed, and I'm very pleased to say that the Kahana project was part of that study, and the results that came out of that study for the Kahana equipment, it operated well, even though it was actually taking a lion's share of the impact from the West Maui side because of the rooftop inverters that were not able to stay online for significant contingencies. I would say, as far as the commissioning of the project goes, we have a grid forming inverter and a grid following inverter are essentially the same piece of hardware, but they're controlled very differently. And so our inverters designed by Tesla are able to do both modes. Now, for the control system acceptance test, which is the last stage of the commissioning process with MECO, it will only be operating in grid following mode, and that's a lot more well understood. That equipment is already operating in other projects around the world, and will be operating ahead of our project in Hawaii as well. For the grid forming specifically, that's still an ongoing subject as to how to qualify those that resource with MECO, and even MECO are working closely with us to understand what tests we could do and how we could validate some of those that functionality.
That's an excellent answer. Thank you very much. I have no further questions. Thank you, Chair.
Thank you, Commissioner. Mr. Horner, I just have a quick follow-up. I don't know if you were online for my questions to the MECO witness, Ms. Dayoff Matsushima, about global supply chain scarcity, potential impacts, delays on projects. And so just can you comment on how your Energex is tracking that now, any potential impacts on this project? And bottom line, to what you understand now, are you aware of any potential impacts on the guaranteed commercial operations date that's stated in the PPA today?
Thanks for your question. We have discussed, in the past with MECO, and especially at the start of the pandemic, were there any concerns around availability of equipment, supply chains? We haven't had those discussions more recently, but at the same time, we have not highlighted to MECO that we're aware of any concerns at this point in our procurement. It is a very changing world at the moment, and so we're not going to say that it's not going to happen. But at the same time, at this point in time, we are not aware of any supply chain issues that would impact our GCOD at this time.
Can you restate that? So what I just heard, under your current understanding of supply chain, including securing enough supply from Tesla, which I know has been a challenge for other projects, global logistics, sourcing panels, getting them to the site, the whole list of things that we're hearing from other projects, other developers. You're telling us here that to your knowledge right now, you're not aware of any of those would delay the current GCOD.
That's correct. We have a strong relationship with Tesla, and we have our batteries assigned for this project, and we did that a long time ago, so we're effectively prepared for that. There are other pieces of equipment that are obviously still required for the project, and we continue to work hard to make sure that they're not delayed, and we don't expect them to be. However, there is time to go yet. So we continue to work hard on it, and we don't have any anticipation at this point that will be delayed.
Has Energex had any discussions internally about invoking the force majeure clause?
Not for this project. We don't expect that. We have no knowledge at this point of any force majeure event that we would bring forward to discuss with MECO.
Would you inform the commission as soon as that changed?
Absolutely, and we have a monthly update with MECO on our project statuses, and anything that we learn as far as any force majeure event would be reported through that as well.
Okay, thank you. Those are all my questions. We're going to take a 5-minute break, and then we'll move to the next witness, Ms. Manzanelli. And given our timing, I expect that, well, we'll see how it goes, but she'll probably be our last witness for today. But we'll see how things go. So thanks, everyone. Let's be back online 3:47. Thank you. Thank you. Can we have folks start filtering back in, particularly our next witness? Ms. Mancinelli, you ready to go?
I'm ready, Chair.
Thank you. Okay, we'll call the hearing back to order. Proceed next with Kahana Solar second witness. Ms. Mancinelli, do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Let's go forward with Maui Electric is first for cross-examination.
Thank you, Chair. Maui Electric has no questions for this witness.
Thank you. Consumer Advocate.
Thank you, Chair. Good afternoon, Ms. Mancinelli. Just a few questions for you. You're the Director of Environment for Interjects, correct?
Correct.
And you submitted direct testimony in this proceeding, right?
Correct.
In your written testimony, you indicate that Kahana Solar does not support the use of a third-party administrator, correct?
That is correct.
Are you aware that WMPA has said that one measure that could alleviate many of WMPA's concerns related to community benefits would be using a third party to manage community benefits?
That is correct. I'm aware.
Okay, so if using a third-party administrator would resolve many of WMPA's concerns related to community benefits, would Kahana Solar be open to reconsidering using a third-party administrator?
So as stated in our testimony and my IR responses, Kahana Solar has been engaging with the community often and throughout since the start of this process. And part of our goal is, again, to be long-term members of the community. We are a long-term owner, operator of renewable energy projects and have been doing so now for over 31 years. Part of this whole community engagement process was to listen and solicit feedback from the community. And one key aspect was the community benefits program. And so we proposed a community benefits program at the start of it. And over the last year, have been consulting with the community and making adjustments based on the feedback and advice from the community. At the end of the day, we want all of the benefits to go directly to the organizations that are being put forward and not having administrative and legal fees be taken away from those direct benefits going to the recipients.
Okay, thank you, Ms. Mancinelli. So, oh, sorry. Are you finished with your response?
I am.
So, thank you. So, I understand what you're saying about the concerns about the costs that may come from having a third-party administrator. Just another question for you. Since a community group, WMPA, is requesting the use of a third-party administrator, even if the net community benefits would be reduced by the cost, by the potential costs, would Kahana Solar be open to reconsidering using a third-party administrator?
Again, wanting to be long-term operators and community members, our intent and with our corporate vision and values is to be engaged throughout the process and have whatever community benefit agreement is put forward to the community align with our corporate vision and strategic plan. And so it is a combination of both what the project will put forward and our company as a whole. And again, continuing to engage and get that feedback from the community will help us allow to make minor adjustments throughout the process. So for example, over this last year, when we originally proposed the community benefits package, it included the Pu'ukikui Watershed Preserve. It included a grant for energy efficiency and cultural programs. And so with the feedback and engagement over the last year, we've made some tweaks to that based on the community feedback. One of the main ones was associated with the grant for that we proposed for energy efficiency, but there was overwhelming support from the community through our engagement process, which included over 100
meetings, including open houses, one-on-ones, small group meetings. And the overwhelming sense was that West Maui community really endorses education. And so we've made that change to that based on the community's feedback.
Okay, so let me ask you, if a third-party administrator could be found who would not charge a fee, then would Kahana Solar be open to reassessing using a third-party administrator?
Potentially, but again, being a long-term owner and operator for projects and wanting to be embedded within the community and making sure that the community benefits do also align with our corporate vision and strategic plan, and being responsive to the community is the combination of the two.
Okay, thank you. So I'm gonna, if it's okay with the chair, I would like to share my screen. You were the sponsor for the response to WMPA Kahana IR 27, filed on June 23rd, 2021, correct?
Subject to check, but yes, I'll take your word.
I'll share my screen with you, please.
Just go ahead.
One second, thank you, Chair.
Ms. Manzanelli, just let us confirm that you can see everything okay
Will do.
once it's up. Okay, thank you.
Yeah, sorry for delay, thanks for your patience. Some technical issues here, very much. Okay. So minimize this box so you can see what I'm going to. So Ms. Mancinelli, sorry. So you should see in front of you WMP Kahana IR 27. You see that?
That is correct.
Okay, great. And just to provide context, I'm going to read the beginning part of this IR. Regarding community benefits, Kahana is proposing dedicated funding to the Pu'ukui Watershed Reserve, noting that support to Pu'ukui aligns with the community's vision of environmental stewardship that was shared in the interview process, and with Interject's principle of protection of the environment and the responsible development of natural resources. Do you see that?
I do.
Okay, great. And then I would like to talk to you about subsection A. I will read this question out loud. What is the amount of funding or resources that Interjects plans to contribute to MLP's Pu'ukui Watershed Preserve? Do you see that?
I do.
Okay, I'm going to scroll down to the response. So in A, you say, seller is committed to long-term funding annually for the term of the PPA to the Friends of Pu'ukui Watershed Preserve through its fiscal sponsor, Living Pono Project, but has not finalized the amount at this time. Do you see that?
I do.
Thank you. So I was wondering, as of today, has seller finalized the funding amount?
No, the funding amount has not been finalized at this time. Our community contribution agreements would be finalized prior to starting commercial operations.
Sorry, sorry, do you mind repeating that? I had a little bit of a glitch. I couldn't hear you.
Yeah, no worries. Yeah, so I said at this time, no, an agreement is not finalized. Our agreements would be finalized prior to starting commercial operations, at which time that is when the benefits would be realized to the community and the organizations.
Okay, thank you. And so once seller finalizes the funding amount, does seller plan to inform the community as to the funding amount?
We can do so if that is the wish of the commission.
So if the commission doesn't require it, then seller would not provide that information to the community?
We can. So as one of my responses to the IRs is Interjects over the last year and a bit have started sustainability reporting. And part of that metrics is discussing our community contributions. And so it would be incorporated in some form or another in our sustainability reporting.
Okay. And so that information could be provided on the website or a press release?
Correct.
Is that correct? And that kind of dovetails nicely to my question about the rest of the community benefits package. Other than the Pu'ukui watershed, which we just talked about, has seller finalized the community benefits package?
No, similarly, again, what we've been doing and where we're at is over the last year, we proposed a benefits package. We've been going out to the community and engaging. And now we're at the point where now that we've narrowed down the beneficiaries of that package, we will be starting the more detailed discussions about which specific programs or initiatives, as well as setting up the potential grant program. And then that would all be finalized prior to starting operations.
Thank you. So Kahana Solar envisions just getting feedback from the community and engaging in an iterative process as they finalize the package. Is that correct?
That's correct.
And once this package is finalized, does seller plan on sharing the details of the package with the community?
Again, similar to the Pu'ukikui watershed response, it would be the same. So it would be, if the chair or the commission would like it to be more publicized, we can. But again, it would also be part of our sustainability reporting.
And earlier you mentioned that, and please correct me if I'm misstating what you said. Earlier you stated that Kahana Solar made some changes to education as part of the community benefits package. Could you please elaborate on that?
Yeah, so again, when we were on the final award list, we came up with the community outreach and engagement plan, as well as various presentation material, which detailed our proposed community benefits package, including one of the ones was for a grant for energy efficiency. So through our community outreach and engagement process over this last year and a half, we received feedback that the community would prefer that the grant be for education and training. And so we have made that transition from grant for sustainable energy efficiency to environment or education and training based on that community feedback.
Okay, great, thank you. So Kahana Solar has met with WMPA to discuss WMPA's concerns, correct?
That is correct.
Would seller be open to continuing to meet with WMPA after the hearing to engage in discussions or even mediation?
Kahana Solar is open and always fully engaged on community outreach and engagement, including with WAMPA. We will be continuing to have those engagements and would welcome any specific information and terms that we can consider as we move forward.
Great, thank you. I have no more questions for this witness.
Thank you.
Thank you. West Maui Preservation Association.
Yeah, thank you.
Thank you.
Ms. Mascarnelli, my name is Bianca Isaki. I'm with West Maui Preservation Association, and I'll be cross-examining you. And I'm going to try to not be duplicative of questions. And so you were here listening to Mr. Horner's testimony, is that correct?
That is correct.
And is there anything in his testimony that you believe was incorrect?
I don't believe so, but if there's something specific that you'd like to call out, please do, and I can clarify.
Okay, I just don't want to ask you the same question, so I'll skip over those so that we can get a little go a little faster here. I'm going to share my screen and show you Kahana Solar Exhibit 202. And this was referenced in your testimony. It's the community interviews report.
Yep.
Okay, there's a whiteboard. Okay, anyway. So one of the findings was nearly all of those interviews raised questions about decommissioning of the project and what that entailed, especially for the panels and batteries. It is widely understood that Maui is filling its landfill sooner than projected. Additionally, the panels and the batteries are perceived to have components with toxic materials that could or would be harmful to the environment if dumped in the landfill. Scott Rasmussen indicated that the Kahana Solar project is required to put up a decommissioning/restoration bond and plans to reuse, recycle, and remove the equipment from the island at the end of life. This information tended to allay the concerns expressed. Is that a correct representation of your Kahana Solar 202?
That is correct.
Okay. And do you agree that MECO and the Commission are not presently requiring a decommissioning bond?
That is correct. It is the landowner that would require a decommissioning bond 5 years prior to the end of the project PPA.
And has the landowner required, is that part of your lease that you are required to put up a decommissioning bond?
Yes, 5 years prior to decommissioning or at the end of the PPA term.
And this, but the lease is not part of the record?
The letter of intent or whatever was provided as part of my colleague's testimony was included.
The letter of intent, but not the lease. Okay, got it. And did you, so will you commit to including the lease so that we can see the term?
Again, we have provided what has been asked of us to date.
Will you include the lease?
If the commission requests that the unexecuted lease be provided, we have not optioned our lease at this time because we have not received a power purchase agreement approval and proceeded to construction.
Okay, and so there's nothing in the record presently that establishes the sufficiency of the decommissioning bond.
It was how it's currently done is between the landowner and ourselves. That is correct.
Okay. And so will Interjex make a commitment to put up a commission-approved decommissioning bond and plan that will cover the entire cost of the project, dismantling, recycling, and site restoration to pre-project condition?
So as my colleague, Mr. Horner stated, in accordance with other PPA dockets, we would be committing to putting forward a decommissioning plan 5 years after the power purchase agreement, should it be approved by the commission.
And you're so I'm sorry, and there's no lease at the moment, though. Is that correct?
There is no executed lease, just an option agreement right now.
Okay, so okay, got it. So, but the bond requirement is in the lease that has not been executed.
That is correct.
Will you commit to filing the option then?
That was included in our response to an IR. Both MECO provided it and ourselves.
Sorry, so the letter of intent is the option. That's the same thing.
Yes.
Okay, I understand that. Is it correct that the PPA terms, what is actually before the commission, only address removal and land restoration for company or seller interconnection facilities?
I am not as proficient with all those types of terms. Decommissioning was under my colleague's testimony.
This is, okay. Is it correct that is it correct that Interjex will decommission the project and restore the surface of the site to its original condition to the extent reasonably practicable?
And in accordance with any final wishes of the landowner.
And so it's Interjex and the landowner that will determine what is reasonable and practical in this context, correct?
Correct. They may wish to have certain infrastructure remain. For example, if there are certain roads that are improved, they may wish to keep them in full use to support other activities on the land, or they may wish to have them removed.
Okay. And this detailed decommissioning plan is not developed yet.
Again, as stated by my colleague, Mr. Horner, it would be provided within 5 years of an approval of the PPA. That being said, again, our community outreach materials do speak to reuse, recycling, and disposal, and have been topics at our public classes on December 2020 and March of this year.
And so when you say submitted, it will be submitted as an amendment to the PPA, submitted to the commission, the Public Utilities Commission.
I don't believe it would be done so as a PPA amendment. It would just be filing as a document. But again, I defer to however the commission would like to receive that information.
Is it correct under the PPA currently that MECO could excuse Interjex from paying the costs and expenses of removing the interconnection facilities for the project?
I can't speak to that. Again, that would have been better addressed by my colleague, Mr. Warner, who was responsible for decommissioning.
Okay. Is it Interjex's position that the only community concern not fully resolved or mitigated is the location of the project on this TMK?
Sorry, could you rephrase that?
Is it correct that Interjex believes the only community concern not fully resolved or mitigated is the location of the project on this TMK?
That would be one of the main ones that we're not able to resolve. That would be correct.
Okay. So moving on more to, this is also about community. Is community defined, community quote unquote, defined by the company in any of its agreements with Interjex?
I would have to consult the PPA. I don't have the glossary of terminology in front of me.
Were you also the director for Interjex's project, the Kahana Solar project in Kihei, Maui?
I am.
Were you involved in the community outreach for that project?
I was.
And you testified that Interjex is fully committed to further community engagement and communication throughout the life of the Kahana project, right?
The Kahana project?
Yeah, I'm asking about the Kahana project now.
Yes, that is correct.
And is Interjex aware that community opposition to a project may delay project construction?
It has the potential to do that, yes.
And is it correct that Interjex opposed a neighborhood association and another community association's intervention in proceedings on the county special use permit for the Paiahu project?
I am aware of those.
And are you aware that the neighborhood associations appealed that county permit to the Second Circuit Court?
I am aware.
Okay. For community benefits, you affirm the project's community benefits are, and I think you said, the contributions to Pu'ukukui, annual support to West Maui cultural organizations, partnering with Coral, and an annual grant to support education and training under a grant program. Is that correct?
That's correct.
Okay, and you already testified that you have not determined an amount of funding or a range of funding for any of these ventures.
That is correct.
Okay. Do you have a contractual agreement for contributions or any processes to with the Living Pono project?
Sorry, could you repeat that?
Does Interjex have a contractual agreement for a schedule of contributions or anything having to do with the contributions with the Living Pono project?
No, not at this time. As I mentioned earlier, those agreements will be finalized prior to starting operations.
Okay. Do you have a partnership agreement with the Coral Reef Alliance?
Again, similarly, as I mentioned earlier, all of the community benefits agreements would be finalized prior to starting operations.
And Interjex is proposing to be the entity administering the annual granting program for education and training.
That is correct.
Does Interjex pay the employees, agents, or contractors that administer the grant distribution program?
That is all internal staff time and is accounted for by Interjex.
Is that also the case for any Interjex contractor, employee, or agent conducting planned outreach?
For the issuance of grants during operations, that would be done through the Interjex team.
Okay. And does Interjex have an internal budget for community benefits distribution over the 25 years of the project?
We haven't fully defined the budget, but if, for example, you look in the public record for one of our other projects on Oahu, it is typically around about 1% of gross annual revenue. We would anticipate something similar for this project.
Okay. And that that's the benefit distribution. Do you also have a budget for the labor cost of administering the community benefits distribution program?
Again, that is done by Interjex. It's already incorporated into how we operate our business.
So Interjex has an internal budget for that.
Our staff time, yes.
Okay, and
but
those
that would
budgets
not come. That would not be taken out of the community benefits dollar amount at the end of the day.
Okay, and those budgets for granting, those budgets internally, they're not part of anything in the record?
No, again, it wouldn't be affecting the overall contribution to the community at the end of the day.
Okay, did Interjex approach Maui Land and Pine to obtain the long-term lease, or did MLP approach Interjex with the lease proposal?
I can't say for sure. That was done many years ago in a court and with another project manager at the time.
Did Interjex at any time discuss a contribution or proposal about contributing to Pu'ukukui watershed or Living Pono project with MLP employees, agents, or contractors?
Yes, over the years, we have had discussions with MLP about the Pu'ukukui Watershed Preserve. It is a private preserve that they contribute funds to, and they're very proud of the initiatives that the Pu'ukukui Watershed Preserve oversees. It's the main water source for West Maui and various other parts of Maui. It has fabulous conservation efforts for some of the most rare endangered plants and fauna in the place. They incorporate Native Hawaiian knowledge and wisdom and cultural aspects. They have training, research, programs. All of this aligns very, very much with Interjex's corporate values and strategic plan with regards to educational, sustainability, education training. And so
I have to object that this is non-responsive
great
to my
alignment for
question.
us to want to be a partner with the
Please let me make my objection on the record. Yeah, just,
Okay, go ahead with the objection.
my objection is that the answer is non-responsive. I asked a yes or no question about this.
Chair, she was clearly responding to the question in detail, explaining exactly how the preserve is in line with the corporate values of Interjex, so they're directly responsive to the question.
I think we've heard the response. Can we continue on?
Yes, okay, I would like to continue on. How many years ago, just a number, if you know, how many years ago did you discuss the contribution to Pu'ukukui watershed with MLP?
We didn't discuss a contribution. We discussed what the Pu'ukukui watershed was and what their mandate was, and that we were looking into whether or not that would be something we would want to contribute to. It's something that we also put forward to the community to provide feedback and comment on. But when we originally started engaging with Maui Land and Pineapple, as well as the Pu'ukukui Watershed Preserve, was in about 2018 as part of the original Phase 1 RFP.
Did the discussion about Pu'ukukui watershed contributions take place before or after any proposal of leasing land from MLP was discussed?
They're different, totally subject matters. One is with MLP solely for the rental of the land for the solar project. Any discussions about contribution with preserve and any funding amount will be occurring with the Living Pono Institute and the Friends of Pu'ukukui Watershed.
Maybe I misunderstood your testimony. You said originally in 2018, you discussed contributions to the Pu'ukukui watershed project with MLP? No, is that not right?
So in 2018, we started to have land lease discussions for potential projects on MLP lands. At that time, they also mentioned to us the great work that is being done by the preserve. And we at that time took the initiative to go and meet with the Pu'ukukui Watershed Preserve representatives to start to understand what those initiatives are. We were very pleased to see all the great efforts that they were done, and it was something that we wanted to consider as part of a community benefits program, as it has a larger reaching value across the community. And again, a lot of those initiatives align very much with our corporate vision and strategic plan.
So you learned about Pu'ukukui watershed projects from MLP in about 2018?
Correct.
Got it. Okay. Was the location of the project on agricultural land determined prior to your first iteration of community outreach?
I'm sorry, could you rephrase that question? I'm not too sure what you're asking.
Did you decide on the location of the project before you asked community members about their feelings on the project, on your project?
We put forward a project on the proposed lands that we put into a bid with Maui Electric, which they selected, and we've been now engaging with the community on.
Okay, so before, correct?
In selecting the project site?
Yes.
Yes, we did select the project site before putting it into the RFP bid.
Was Interjex aware that the site sits atop 3 gulches on agricultural land before it selected the site?
Sorry, I didn't quite hear that.
Was Interjex aware that the site sits atop 3 gulches on agricultural land before it selected this site?
When the location was proposed, we were aware that the project has different areas. On the figures, they're denoted as area 1, 2, 3, and 4, and that gulches do transect them.
Okay. And so the first iteration of community outreach was conducted before the agreement to fund Pu'ukukui, or before you reached out to Pu'ukukui Watershed about funding.
I'm sorry, could you say that again?
Was the first time, was community outreach conducted before or after the agreement to fund, or your discussion, you said, in around 2018 with Pu'ukukui Watershed? Was that before or after you conducted community outreach publicly?
So we, again, proposed the Pu'ukukui Watershed Preserve as part of our RFP package. And then we presented that information along with the other community benefits that we've put forward for community feedback and on that. And what we received the feedback was that Pu'ukukui Watershed was something that also aligned with the community's vision and is documented in the Skog Rasmussen report.
So you proposed Pu'ukukui Watershed as part of your RFP, and then you did the community consultation. I just want to get that clear.
That is correct.
Okay. So is it Interjex's position that it is better situated to determine the distribution of benefits to West Maui communities than a third-party entity comprised of West Maui community members?
Again, we are looking to be long-term members of the community, and we have been engaging early, often, and throughout, and appreciate everyone's time and commitment to our community engagement process, which included feedback and comment on our community benefits program.
Where are you testifying from, your geographic location?
I am currently located in Vancouver, British Columbia.
And so in your response to my question about who is best situated to determine the distribution of benefits to West Maui communities, your response is that your corporate vision is important of
Sure,
being embedded in the community.
We allow we would object that this has been asked and answered multiple times.
Well, the question now is whether she said that corporate vision is what guides her decision that Interjex should be determining the benefits. But so I'm asking, like, if about the relative value.
I think her testimony speaks. I'm sorry.
I do think we did hear questions in response to this earlier, so I'm not sure what is new here. Can you restate the question?
Okay. What is more important, whether an independent entity comprised of West Maui community members determines the benefits that come from the project, where they should be distributed, or your corporate vision?
It's a combination of both. And that is why, again, we've been engaging with the community often and throughout, and will continue throughout the process. It needs to be a combination of our corporate vision and strategic plan and the feedback that we receive from the community. So if there are feedback that West Maui Preservation Association would love to provide to a specific organization or program that we have not identified, that would be appreciated.
So is it Interjex's position that WMPA is not representative of West Maui community members?
I never said.
I didn't hear you, sorry.
I didn't say that.
So that's not your position, okay. Did you testify that Interjex has a custom and practice of not publicizing names of individuals participating in outreach activities?
In certain aspects, that is correct.
Is Interjex's community outreach consultant filing public comments with the commission that include people's names as authors of those comments?
That is correct.
Are you aware of the meaning of selection bias as it informs community outreach information gathering?
I'm not too sure. I don't know if that's a legal terminology. That would not be within my realm of knowledge.
I'm referring to, and this is Interjex's response to the Consumer Advocate IRR 34 on June 23rd, 2021, in which, and I can just pull it up if that's easier.
Yes, please.
Okay. Okay. Wait. Oh, here it is. Okay, sorry, let me share this. Okay, this is, I'm scrolling here. Kahana, this is your response, the Consumer Advocate number 34.
Mm-hmm.
Okay, and you responded, this is on to A1, so please include in the discussion how selection bias is addressed and accounted for in the study, referring to the Skog-Rasmussen study. Is that correct?
That's what the question reads, yeah.
Great. Okay, and did you respond that if there is a bias, it would be towards selecting West Maui residents as stated above?
That is correct. That's what's written there.
Thank you. So Interjex is not aware of other kinds of selection bias that may have influenced the community interview study.
Not that I'm aware of, just as what was detailed in our IR response.
Okay. And this is also in response to the Consumer Advocate's inquiry. This is into the Consumer Advocate inquired into committed project changes and consequent to community outreach, and you cited a 100-foot setback for permanent structures from identified gulches, quote unquote, unless low impact design strategies are implemented to prevent stormwater runoff. Do you want me to pull that one up?
No, that statement is accurate.
Okay. And in regard to the term permanent structures, does that include access roads? Does it include access roads?
Yes, it would include access roads.
They will be 100 feet from the gulch. Okay.
No, they would be permanent infrastructure, and that low impact design technology or mitigation would be implemented for when it is less than 100 feet from the top of the gulch.
Okay, is it correct that the 100-foot setback may not be implemented if there are changes to low impact design strategies called for in the updated community plan?
I'm not too sure what you're asking.
Okay, I'm looking at let's see, this is PDF 33. This is Kahana, your response to the consumer advocate number 19. So I will share my screen again. And I know we're getting close to time, but anyway, so in response to that question about Kahana Solar's responsiveness to community concerns, you wrote, the seller incorporated a design constraint to set back new permanent structures a minimum of 100 feet from the top of the bank of identified gulches unless low impact design strategies are implemented to prevent stormwater runoff in anticipation of the approval of the proposed updates to the West Community Plan. That's a correct statement?
That's correct.
Okay. So does that mean that it's an alternative to do the 100-foot setback? You might not necessarily do it.
No, as detailed in our updated design that we presented to the community at the March 2021 open house, any of the infrastructure within the fenced area, such as the solar arrays, the power conversion stations, the substation, switchyard, that is all set 100 feet from the top of the gulch. The only infrastructure that would be potentially less than that would be the use of existing agricultural roads or slight little jaunts off to connect us up to the 100-foot setback where the fence would be located. And then the AC collector line would then go through the existing or improved access roads and incorporating low impact design.
Okay, and the March 21st, 2021 open house happened before you answered the June 23rd, 2021 IRs, right?
That's correct, and it's consistent.
Okay. I can continue. I know that we're getting on time, but just let me know if I need to stop.
Let's continue.
Okay. If community members had not raised runoff issues into the gulch, would Interject still have implemented these low impact design techniques to prevent runoff?
That is correct. It's a requirement of the Public Works Department of Maui County.
Okay. And you testified that the open house that you held was to provide an opportunity to engage in dialogue about concerns and questions, mitigation measures, and potential community benefits of the proposed project, correct?
That is a requirement of section 29.21 of the PPA, yes.
Okay, and when did Interject or contractors during that open house utilize an online conferencing platform with settings to limit visibility of all attendees to see each other?
We used a WebEx platform.
Did you or your contractors adjust the settings, or you set the settings to limit visibility of all attendees to see each other?
We set a WebEx platform that mimicked an in-person experience. From our experience from hosting in-person open houses, people typically show up and have the option to sign in. It is not a mandatory requirement to sign in, and that information for signing in is typically used if an individual attendee would like to receive additional public information or updates on the project. Then you would proceed to a presentation aspect where it's typically a listening where the project team presents various aspects of the project. At the end of the presentation, you would have a Q&A session in which we did hold and responded to all the questions posed by the community. We've observed in other open house formats in person where the participants are asked to write their questions down and are handed to the moderator to read aloud, which was done at our open house.
I'm going to place an objection on the record and a request for an instruction to the witness to answer my question in a yes or no fashion.
I believe it was all relevant. You asked about the format.
I believe, yes, it was relevant, but it's not responsive to the question about whether or not the settings were set to limit visibility of all attendees. Could they see each other on this WebEx platform?
I'm happy to elaborate, Chair.
Go ahead.
So similarly to an in-person open house, when someone signs in, it's optional. And we do not make that sign-in sheet open to every member of the public to be respectful of individuals attending, their privacy and their comfort. So you could be in a room with someone and not know who they are and not have their name or personal email information shared. So we wanted to provide that same similar comfort and privacy setting as part of our public open house in this virtual open house. Unfortunately,
So your answer is
with
yes,
WebEx
correct?
platforms, you are required to input that information, and we wanted to be respectful of people attending.
So your answer is yes, correct?
Yes, we provided an open house experience that mimicked an in-person
Thank you.
platform.
I'd like to move on.
Sure.
These are all the same in the same vein. Did Interjex or its contractors utilize WebEx, I guess, the settings to limit participant-to-participant chat features?
Again, similarly, in an in-person experience, during the presentation, we would hope that people are listening and engaging in absorbing the information that is being shared so that they can submit questions that would be supportive. And so that is the platform in which we presented the open house to mimic a real life person.
I have to again put an objection on the record that this is non-responsive, and I'll take that. It's non-responsive.
Can you rephrase the question? I mean, she keeps answering the same question.
Did Interjex put the settings on the WebEx to limit participant-to-participant chat features? That's a yes or no question.
Yes, and again, it was to mimic an in-person format where during the presentation, we would hope that people would be listening.
Ms. Manson, we understand. Okay, can we continue?
Okay, is it possible, and this is getting back to your initial testimony about providing opportunities to engage in dialogue about concerns and questions, is it possible that the identity of an attendee may contextualize the meaning of a statement from other attendees for other attendees?
Not necessarily. Not everyone's going to know who everyone is.
Is it possible?
It's possible.
Is it possible that an attendee's question may change where an interlocutor paraphrases the question?
All the questions were read aloud by the moderator.
Were they read aloud verbatim? All of them?
I have to double check, but all the written format questions were provided as part of the proceeding in a response to the consumer advocate. So they are on the record in their original unedited format.
Is Interjex aware the Commission has held online public meetings since the start of the COVID pandemic in which members of the public could see other attendees as well as testify live with their faces seen via video conference?
I would have to trust you. I haven't participated in all the events, but I would note this is not a testifying event. A public open house is not for testimony. It's to have an engagement between the company presenting the project, listening and hoping to engage feedback from them.
Is Interjex willing to commit to a condition in any PPA approval that will prevent its contractors, business partners, lessors, or beneficiaries of its community benefit contribution from violating U.S. work authorization laws?
Chair, I'm going to object to the extent that calls for a legal conclusion.
I can rephrase this.
Please rephrase. Yeah, I mean, it sounds like you're asking her whether they will. I mean, those are laws that they have to follow. So you're asking them to commit to following the law.
Yes. And if I could just ask that question then, will you commit to ensuring that you and your contractors, business partners, lessors, or beneficiaries of your contributions comply with labor laws?
Same objection, Chair.
I mean, we'll allow the question.
Yes, we would of course abide by any laws and rules and regulations put forward. That's part of doing good business.
Are you aware that your prospective landlord has been found in violation of human trafficking laws due to their use of outsourced Thai laborers?
Chair, we'd like the council to explain the relevance of that, just to make sure it's relevant
Please.
and within the scope of the witness's direct testimony.
Correct. Please explain the relevance here to Ms. Mancinelli's testimony on this specific project.
Yes, Ms. Mancinelli has testified both that MLP is their landlord and that local economic benefits, including labor, I believe, this was in her testimony, are considered benefits of the project.
Okay, I don't see the connection between that and the question you asked.
The question
Can you rephrase
goes,
the question?
okay.
We're way outside. I mean, I don't see how this is even near the scope here.
Chair, we would also object that it seems to assume facts not in evidence based on the allegation that was made.
Mrs. Sari, please restate the question.
Okay, I'll move on. Well, yeah, I'll move on. So you testify that Interjex will give preference to local residents and hiring through the development phase.
As well as throughout construction and operations, as my colleague, Mr. Horner, mentioned.
Is local geographically coextensive with West Maui?
Can you, sorry, restate that?
When you say local, are you talking about people who live in West Maui?
That would be a part of it, but also local to Maui and Hawaii, depending on what the nature of the task at hand is.
Will local residents okay, actually, I will go on to gulch impacts. Interjex will improve existing roads and add new access roads within its project area. Is that correct?
That is correct.
And some of your project roads will include gulch crossings, correct?
That is correct.
And those are mapped out in your exhibit, Kahana Solar 211, your stormwater management plan?
They would be, yes.
Okay, and it's correct that minimizing impacts to stream channels is one reason to utilize existing infrastructure as opposed to building new crossings?
That is correct.
Okay, and are any of the existing infrastructures from the plantation detailed in your AIS, the existing infrastructure you would use for your access roads?
So the access roads where they cross the gulches are part of the archaeological inventory survey and is detailed in their project study area survey in some of the initial figures in that report.
Okay, so your testimony is that, okay, interesting, okay. Is it, and has Interjex filed presently, do you already have in motion before the Commission on Water Resource Management any applications for a stream channel alteration permits?
We have filed our Waters of U.S. delineation report with U.S. Army Corps engineers. They have confirmed that none of the streams are jurisdictional. At such time, we also filed the report with CWARM, and they have confirmed that no alteration permit is required for the project.
Okay. And in addition to access road gulch crossings, the project will require underground AC collector lines across the gulches as well, correct?
Yep, within the road right-of-ways, as Mr. Horner testified.
Okay, and so it's not correct that the AC collector lines will be a minimum of 100 feet from the closest gulch, as represented in your tracking table?
They would be incorporated within the road and would be using low-impact design techniques.
Okay. Will Interjex redesign the existing main access road, the one that's closer to Honoa Pi'ilani Highway, to introduce curves to curb water runoff instead of having a straight road from Mauka to Makai?
So you're talking about the portion that's above the airport going up to the where the solar arrays would be? No, so our proposal is to keep the existing road and make improvements in accordance with the watershed management plan, which includes upgrading the roads, capping surface, drainage, and implementation of retention basins in accordance with the watershed management plan.
Is it correct that Interjex is planning to use no water to wash its solar panels and rather rely on ambient rainfall?
That's not correct. In our information, we state that we assume that approximately every 18 months that cleaning may be required. But from our experience in operating our solar projects in other jurisdictions, we have not had to clean our solar panels to date. And that sufficient rainfall often provides enough of that for it to occur naturally.
And is it correct that Interjex does not anticipate irrigation water will be necessary for its vegetation underneath the panels or for the project?
That is correct.
Has Interjex put on record any studies or assessments to support the relationship between irrigation requirements and prospective ambient rainfall?
We have not.
Is Interjex aware of climate change projections and trends for rainfall in West Maui over the next 25 years?
I would have to defer to my other colleagues that do our resource modeling.
Will Interjex commit to reusing water runoff from the project for irrigation?
If required, yes.
Okay. And will that commitment come as an amendment to the PPA or a condition of the approval of the PPA?
Again, I would defer to the commission to however they would want to incorporate that, but that could be something that's simply written into our permit application for our county use permit application.
The county permit application, okay, not the PPA here.
That's correct.
Okay, has Interjex committed to using native plants as ground cover between and underneath the panels as recommended by the cultural impact assessment?
We have committed to using low-lying drought-tolerant species underneath the solar panels and have committed to work with coral to plant various native or indigenous species within select areas of the 100-foot gulch buffer area.
Okay, is it correct that the only native plants Interjex has committed to for the ground cover portion under and around the panels is the introduction of native seeds into otherwise non-native seed mixes for ground cover?
We haven't proposed a seed mix as of yet, but it would include species that would be primarily for stabilization of the soils in response to stormwater management being a major concern from the West Maui community. So we want species that will establish quickly and will then also be respectful of our solar operations and not growing high to prevent solar radiation being received on the panels.
And so has Interjex conducted any research to determine whether native species seeds in a seed mix or in any ground cover use will not be outcompeted by other non-native low-lying cover?
We have not done any specific studies, but we would defer to the various biologists and native nurseries that we work with to come up with the final seed mixture.
And this final seed mixture, this will be an internal document or a document that's not presented to the commission?
It will be developed as part of our construction management plans.
Will that construction management plan come for review by the commission?
If the commission would like it to be submitted, we would be happy to submit it to them at such time that it is available.
If the PUC wants it submitted, not as part of an approval or condition on the PPA approval. Is that correct?
Again, I would defer to them.
Okay. Has Interjex quantified the amount of herbicides it will use per square foot in the project?
No.
Have you quantified the amount of herbicides used in other solar projects that Interjex has in Hawaii?
No, we do not have any operating projects in Hawaii at this time.
Will the amount that Interjex, will the amount of herbicides used be publicized as part of your final vegetation management plan?
It will depend on what species are out there, but we have committed to first using mechanical means and then using biodegradable EPA approved herbicides should at such time that ever be required and would be done so in accordance with the rules and laws of the day.
And you testified an effort, and this is, I can pull up the IR if you like. You testified an effort will be made to minimize herbicides and to use EPA registered organic solutions, quote unquote. Is that correct?
That is correct.
And EPA does not register organic solutions, correct?
I can't say for sure. I'd have to defer to a specialist that is in vegetation management.
Okay, this is on fire. You testified the project will integrate features to prevent and suppress fires, correct?
Fire is within Mr. Horner's testimony, so I'm not too sure what your question is.
Okay, I'm looking at testimony. Let's see. It's case solid testimony 525 at 23. Sorry, shall I share this? It's your testimony T2 at, I guess it was 32. Wait, yeah, it's at 32. So it's right towards the end. Let's see. Okay, oh, I'm sorry, I'm not even sharing my screen. Got it. Okay. So this is T2, this is your testimony, T2, looking at page 32, is this correct? This is your testimony?
I searched this one up, it looks familiar, yes.
Okay, and you stated, did you state, safety features will be integrated to prevent, detect, and suppress fires?
That is correct.
Okay, thank you. That's where I was going with my question. And are these described in your memorandum to the County Fire Department dated April 19th, 2021? And that was in your, that was actually in your IR to WMPA.
So you're referring to the memorandum prepared by G70, doing an assessment of our design of fire code prevention?
Yes, it was G70 that prepared it.
Okay.
Okay. Does fire hazard prevention, is that an identified issue in your tracking table?
I would have to go and cross-reference the tracking table to say for sure.
But fire has been raised by community members, correct?
I believe WMPA has raised that concern, yes.
Does the project include a sprinkler system across its battery storage area? Oh.
No.
Sorry, my video went off for a second. And you're not installing fire hydrants?
No, so battery energy storage systems, and again, I would defer a little bit more to my colleague, Mr. Horner, who's responsible for batteries, but they are intended to self-burn within the steel enclosures and not propagate outside of the steel enclosures. So sprinkler systems wouldn't necessarily be required to support that.
Have there been, are you aware of fires that have occurred in this area without the presence of batteries?
Just general fires in
wildfires.
Yes, I'm
wildfires in. Sorry. Okay, wildfires in the area, in the project area, in these parcel areas.
Yes.
Okay. Moving on to your CIA. You testified that the CIA is available on the project website, correct?
That is correct.
But it's not before the commission.
No.
Okay. And also, you do have in here the draft archaeological inventory survey, right?
That's correct.
And is it correct, based on that AIS, that there's never been an archaeological investigation in this parcel area?
That's not fully true. The Kahaniki water treatment had some AIS survey work that does overlap with our project study area.
Okay, well, I'll take your words for it. We can always use the map later. Is it correct that Intergex or its consultants held over 75, or maybe you said over 100 in-person or virtual meetings?
That's correct. Between the combination of Skog Rasmussen and ourselves, we have held over 100 meetings, over 100 hours of community engagement.
And were all of the persons, at least in the 75 meetings that were referred to in the AIS, were they aware that their consultations would be used to establish compliance with Hawaii administrative rules regarding AIS consultation?
I'm not too sure what you're asking from a legal perspective, but as part of our discussions of community outreach engagement has been to include the results of the archaeological inventory survey. If asked about it, we've presented that at open houses and had brought in our archaeologist, which is represented by Pacific Legacy, to present on that information.
Maybe I'll ask the question in a different way. Did you tell the people that were being consulted that their interviews would be used to establish legal compliance of any kind?
The engagement, again, is more about information that has been shared and received. And that is what is being noted there, that as part of the community outreach engagement, that archaeology considerations were discussed as part of those events.
Okay, and so are you aware that there are consultation requirements for archaeological inventory surveys?
I would have to defer to Pacific Legacy as the registered professional archaeologist for what is constituted by that law.
So is your testimony, tell me if I'm mischaracterizing it, you don't know, or the people were not informed? You're saying you just took in information from them. You did not inform them about this consultation requirement, nor how their interviews would be used.
So I believe if you read the report, it speaks to what specific initiatives that Pacific Legacy led. It also spoke that there was a cultural impact assessment done led by INA Archaeology, which also included engagement. And then it spoke to the engagement we've done through Skog Rasmussen and ourselves at a community level, where this information from the AIS has been shared with community members, and questions that would have been raised would have been incorporated into our approach to the AIS.
So these people gave informed consent, the 75 in-person consulted people, yes or no?
Chair, can I just ask council to clarify the term, what is meant exactly by informed consent?
Sure. Did you tell these people that their consultation would be used to establish compliance with archaeological inventory survey requirements?
So again, there was the 3 different areas denoted in the archaeological inventory survey about what was and how was the outreach was done, specifically by Pacific Legacy, specifically by the cultural impact assessment led by INA, and our efforts. So there are crossovers.
And the AIS methods, so they specifically say, do the AIS methods specifically address whether or not the consulted people were informed of how their consultations would be used to establish compliance? That's your testimony. It's there. It's in the methods.
No, I would defer to how it's specifically written in the AIS report on that wording. We can bring it up on the screen if that would be helpful.
Oh, well, you don't know though, then that would be the answer. So you can't confirm.
Again, I would defer to how it's characterized by Pacific Legacy. As
got it. It's what's in the report is what's in the report. Okay. So back to the CIA. Does the project adopt all the recommendations from the CIA as condition? Would the project, sorry, or Intergex adopt all of the recommendations from the CIA as conditions of project approval from this commission, not the county?
We would have to, again, assess each and every one of those, but many of the recommendations that were put forward, we are actually implementing already and would plan to as part of our construction and operation of the project where feasible.
Will project construction occur only during the dry summer months of the year?
Again, that would have to be something that would be assessed. But typically during storm events or high weather events, you would shut down your construction. But once the weather system has passed, you would then restart construction.
Okay, I'm reading all the recommendations from the CIA because you said you're saying it's a case by case. You're not sure if you adopt all the recommendations from the CIA. Is that correct?
That's correct.
So will you install ground cover concurrently with installing the panels and other infrastructure?
We would be installing ground cover as soon as practical. Obviously, you don't want to be installing it and having it growing while you're driving equipment over top of it. It wouldn't support growth. So you would want to be doing it shortly thereafter.
Did you produce educational materials about the equipment, panel materials, and cleaning products used on the site?
We have prepared in response to the cultural impact assessment soil and water memo, as well as a couple of other memos that were attached to Mr. Horner's testimony in response to concerns and inquiries made as part of the cultural impact assessment process.
Does that include the cleaning products to be used on site?
Yes, that was also included in the CIA about biodegradable and hopefully more innovative techniques as well as the industry progresses.
Okay, and the CIA that's on your website, not in the record. Will you, and this is also from the CIA, plant native plants, specifically Akia, Kilau, Kolokolo, A'ali'i, and Alahe'e?
Again, we would have to assess as part of our construction management plan as we head into operation what the growing height of each of those species are. I'm not a specialist in vegetation management and would defer to the biologist and the nursery that we would work with to come up with the appropriate species.
Has Interjex executed an agreement with the landowner to ensure cultural practitioners have access to Malka and Mackay regions, including the roads? Do you have an agreement?
We don't have an agreement. We have no intent to restrict access. We've made it very clear in our documents that Malka to Mackay access would remain open to cultural practitioners and other users of the landscape.
Have you created an educational program to provide information about traditional, historical, and customary practices that are related to resources within the project footprint, including collecting uhaloa plants, hala leaves, and to ensure rights to access and gathering traditional resources within the project footprint to ensure that they're not infringed upon? Have you created that program?
No, that would be a program that would be created as part of construction and training of personnel. So should we get to that point where we can start construction, we would be creating an educational awareness program that would have both environmental aspects as well as cultural aspects.
Would you be training the personnel or your contractor?
It would be prepared by the various consultants that have been overseeing this information. And we could look to also have a cultural advisor come in as well to supplement the training.
And this would be all at Interjex's discretion, or would you stipulate this as conditions on the PPA approval?
Again, I would defer that to the commission.
Okay, fair enough. Thank you very much. So is it Interjex's position that the commission may approve the PPA without having reviewed the final vegetation management plan, the CIA, the final AIS, your detailed decommissioning plan, and the community benefit distribution plan?
My testimony is that there is a lot of information on the record for the commission to consider when making their decision. And if they require additional information to be provided, we would provide that at their request at the appropriate time. Of course, some things cannot be developed prior to having advancements of a project to a certain stage.
I'm sorry, just to go back a second about the CIA recommendations, you said you'd require your contractors to do cultural training?
We would require our contractor to have an educational training component for their employees. Yes, that's pretty industry practice across our projects.
But you can't require your contractors to pay a prevailing wage?
Again, that was something that was addressed by Mr. Horner.
Can you answer that question?
I cannot. That's out of my scope.
Okay, you cannot answer the question. Okay. Thank you very much. I know we've gone long. That's all.
Thank you.
Okay, thank you. Commission Counsel?
Yeah, I have a few questions, Chair. I just wanted to ask, I know we're over time. I wasn't sure if you wanted to continue, try to finish today, or if you wanted to.
Ms. Mancinelli, how are you doing?
I'm doing great, Chair. Thank you.
Okay, let's keep going.
All right. Thank you, Ms. Mancinelli. I appreciate it. Must be late in Canada right now. Okay, I wanted to ask a few questions. First, I wanted to clarify something that I thought I heard about your earlier testimony about the community benefits package, and maybe I've misheard, so this is just to confirm. Did you, I think in response to a question about the actual quantification of the community benefits package, say that it would be approximately 1% of gross annual revenues? If so, what does that mean?
That would mean based on gross annual revenue, 1%. And so over the 25-year life of the project, it would be just shy of $1 million.
Okay, and would the intent be to distribute this amount on an annual basis, a monthly basis, or some different frequency?
At minimum annually.
Okay, and and it sounds like I think you also said that you finalized the identification of the beneficiaries of the package, but you have not yet finalized the package itself. Is that correct?
That is correct.
And I believe you said that it will be finalized prior to project operation.
That is correct.
Okay, so kind of putting that on the side for a second, just wanted to confirm that I believe in one of the exhibits to your direct testimony, I think it's exhibit Kahana Solar 212, you have a table that identifies a number of other ongoing government proceedings, correct, at federal, state, and county?
In our community outreach engagement plan, yeah.
Okay, so understanding that the community benefits package is not finalized at this time, will the package be reviewed in the context of some later government proceeding? For example, one of the proceedings identified in Kahana Solar 212?
Community benefits would be assessed as part of the county and state use permit processes.
So by that, do you mean that you would be submitting the finalized package as part of those proceedings?
The agreements, no. Again, those would be provided or finalized prior to starting operations.
Okay, so it may come up in other proceedings, but in terms of the finalized plan, Kahana Solar is saying it does not intend to submit it as part of the review by any other government agency review?
That is correct. We would be just putting forward what our proposed organizations are and our approach.
Okay, thank you for clarifying. I guess shifting gears a bit, I'm not sure if you were listening to the cross-examination of Mr. Horner, but I asked him there a question about some of these proceedings, so I believe he deferred to you. So
Sure.
in these other proceedings, again, I'm just referring to the table on Kahana Solar 212, but this applies to any other proceeding, any other government proceedings that Kahana Solar is engaging as part of this project. Is Kahana Solar aware if there are have been other opportunities for members of the community to participate in any of those proceedings?
There will be. We have not yet filed our county use permit and state land use permit application, but those proceedings do provide opportunities for public testimony and participation.
Okay, thank you. Currently, as I understand it, the project modification that's been made in response to community outreach has been the setback from the gulches. Is that correct?
That is one of the examples. That's correct.
Does Kahana Solar contemplate other project designs being done as a result of these other agency proceeding or government proceedings?
Possibly.
And is that the reason why the project final design has not been, or the project design has not been finalized yet?
That's correct. As part of development process, you progress your design as you move through the various permitting processes, as well as advancement of your design with your contractor negotiations. So you typically start out in the early stages with the conceptual design. You do your studies based on that design, your consultation based on that design, and then you go away and update your design to reflect that, which we did in March of this year. And then as you progress through the various kind of higher level permitting processes, such as the state and county use permit process, and then as you go then into the construction level permits, you would then further advance your design and any final refinements.
Mm-hmm. Okay, thank you. And again, turning back to Kahana Solar 212, you have this column here that's the estimated date when approval will be granted. To your knowledge, does that have any of these timelines shifted? It looks like most of them are Q4 of 2022, just to clarify.
That is correct.
Okay. Are there any other proceedings besides those listed in Kahana Solar 212 that you believe Kahana Solar will have to undertake as part of this project before it can begin operation?
Sorry, no, I'm not aware of any other permitting proceedings outside of that at this time.
Okay. And I think earlier you indicated that some of the studies that Kahana Solar has submitted in this proceeding are also to be used and or further finalized as part of these other government proceedings. Is that correct?
That is correct.
And which may ultimately result in subsequent or additional project redesigns.
Potentially, yes.
Which you have said if they do occur, you will be communicated to the public and solicited for feedback from the community?
That is correct.
Okay. I believe Kahana Solar has previously testified that it intends to continually engage with the community throughout the project development. Is that correct?
That is correct.
To that end, has Kahana Solar scheduled any additional open houses or other outreach events at this time?
Not at this time, but over this spring and summer, we have launched our newsletter, which is a medium in which we are providing updates to the community on all of our projects across the state, as well as advancements occur with the project. We issue project-specific update notices.
Mm-hmm. What would be, or does Kahana Solar have any processes or sort of triggers for when another kind of larger event would occur? I think, as I understand it, you've indicated Kahana Solar kind of has a multi-pronged approach to community outreach. There's informative things like passive information, such as your website and your newsletter, but I'm just curious, what is its processes for determining when more interactive types of community engagement will occur? Do you have, after certain milestones, for example, you would schedule an open house or every so many quarters or anything like that?
Yeah, so it could be a combination of either of those. So to date, it's been kind of when we've completed the studies and wanted to share the results, then going and moving forward, making updated to the design. A next logical one would be similar to if, as part of the progression of agencies discussions, any other additional material changes might occur, we would share that, or prior to going to construction to share any information that would be pertinent to that.
But that decision is unilaterally made in Kahana Solar's discretion in terms of when to schedule the meeting like that.
Also, but with feedback from the community. So if people would like us to have smaller group meetings or anything, we're always receptive to that. And we often present at different community organization events and updates.
Okay, is there a particular criteria or threshold for that? Is it just one person asked, or 10 people have asked, or a certain group has asked, or?
We're open and willing always to meet either one-on-one, small group, or in large format if requested.
Okay, thank you. Has Kahana Solar followed up with the various organizations, individuals who have previously expressed concerns or requests about the project to check if all of their concerns have been addressed or mitigated?
So between Skog Rasmussen and ourselves, we have continued to provide updates to those that have participated and have requested to be updated, whether it be follow-up emails or invites to, for example, our open houses, where we have addressed a lot of the combination of feedback that we've received.
And based on your Kahana Solar's experiences, have those individuals who you have followed up with indicated they're satisfied with the follow-up or with the response they've received?
Yes.
And is this documented in any of the studies or IR responses you've provided? Can you point me to a specific document, or is this something that you were saying has happened subsequent to these filings that you're relating?
Yeah, so one example would be after our March open house, where we presented the updated design and our approach to stormwater management. We received an email from the Ridge to Reef thanking us for listening to the feedback from the community and taking the time to incorporate the recommendations that have been put forward over the last year. That was appended to one of our IR responses.
Okay, so that's a specific example, and I appreciate that, but I guess maybe this is a more difficult answer to ask of you, but I guess in general there seems to be a variety of comments, and maybe not everyone is satisfied. And are you still continuing to engage with those people who may still have outstanding concerns? I guess maybe I should have phrased it that way.
Yes, for sure. If anyone feels as though they have not gotten their answer, we would hope that from the information that we have shared, again, either by the open houses or small group meetings or through subsequent distribution of updates, if they have not felt that their answer was adequately addressed, we would hope that they would feel as though they can ask that question of us.
All right, thank you, Ms. Mancinelli. I have no further questions from this witness, Chair.
Thank you.
Thank you, Mr. Kayatsu. Commissioner Sunstein?
Thank you, Chair. I just have a couple of questions. Around the community benefits package, Sally, I'm going to assume that Interjex has had similar types of packages in different projects.
That is correct.
Or in the portfolio of the company.
That is correct.
And they seem to be pretty much the same way. I mean, as far as what goes into it, right? Does it tie in with the corporate values and all of that, and what the community wants as well?
That is correct.
Okay. And then I'm going to switch a little bit on the decommissioning plan. You mentioned that it's really the landowner that requires it.
No, the landowner is the one that requires the decommissioning bond.
Okay, the decommissioning bond. And then the plan you guys will do, right, 5 years out from the approval of the PPA, but you also said, and when you get the notice to proceed with construction. So is that the NTP from HECO, or is it when you finally get all your permits done? When, I'm just trying to get a sense of when that actually happens, or when we might be expected to get commissioning plan.
Sure. I don't know if I specifically said the LNTP, but ideally you would want to know what your final design is and the equipment that you would be using and the methodology for installation to then inform your decommissioning plan so that you're using what you would be actually putting onto the ground, so that that's what's being discussed as being what is specifically being removed. So within 5 years of executing the PPA, should it be, or of the approval, sorry, we would have already selected a contractor by then. and would have known the equipment, and so we'd be able to make a very informed decommissioning plan at that time.
Okay, and then and your contractor that you're gonna hire, right, to operate and the like would have to implement that decommissioning plan at some point in time.
Yes, or
Or-
Interjex itself, yeah.
Okay, all right, thank you. Thank you, Chair. That's all I have.
Thank you, Commissioner. Commissioner Potter.
Hi, thank you so much for being with us. I'm sorry it's getting so late.
Not a worry.
I just have a couple of questions for you. One is around fire. I know we just briefly talked about it, but it's very, very dry up there. And I'm sure you're aware of that. So
Yes.
I'm curious about the plans for, preventing wildfires to the solar facility. Can you discuss those?
Yeah, for sure. So as part of our project development approach, we engage the services of G70 to prepare a fire code analysis of our project design and also our approach to vegetation management. So some of the key mitigation measures in there, for example, is around the power conversion stations, which includes the batteries. There would be a gravel 10-foot buffer where there is no combustible fuel to, again, help with any reduction of propagation. Also, there is a requirement to have a 30-foot setback from the solar array to the edge of the project that must be maintained, and ideally where you also put your access roads, which are graveled. So again, another defensible space. Also, as part of that is the vegetation management plan, where we've worked with the Maui Fire Department to set criteria for the height of vegetation, that maximum height that it would grow, as well as the height that it cannot go from electrical equipment, providing that buffer as well. And so between these measures that we've been working with G70 and the Maui Fire Department on, they have provided their letter saying that they are in principle supportive of the approach that has been put forward.
Thank you very much. I want to follow up on the vegetation management plan too. I just wanted to touch on it. Is that complete yet?
No, it is a draft plan that has been put forward for comment and would be updated again as part of operations. So it would be determined based on what type of vegetation would be used to grow. We would have to see how often the vegetation, or how quickly the vegetation grows, and the management approach to that. And so it's an adaptive management approach where you have incorporate monthly inspections and then quarterly inspections as well, and then implement the vegetation management based on real life observances of the vegetation growing.
Excellent. So I'm going to follow up on that. Is the vegetation that you're talking about, is that just under the solar panels, or are you actually thinking about a wider space outside of, the perimeter of the fence? Is there, in order to just, basically manage forest fires, or is there anything? Did you contemplate that? Sorry.
Yeah, no worries. So from our discussions with the fire department, it is that 30-foot buffer around the edge of the solar panels, which would include up to the fence. It could go a little bit further than the fence, depending on the final area, but we would have to, at minimum, have that 30-foot buffer.
Thank you. That helps. So I think that's all I have. Thanks so much for sticking with us today.
No worries.
Thank you, Chair.
Thank you, Ms. Menciano. I just have a couple of questions as well. And it's a follow-up to a response from your colleague, Mr. Horner. He said that Kahana Solar had extended dialogue with WMPA and that you were, I think, the one to better characterize that. So can you expand on what that's been? And I think he said he would talk about the specific terms and why there still seems to be such a divide here.
Yeah, for sure. So when we first were put on the final award list, we reached out to the vice president of WAMPA, who's also one of the chair members of the West Maui Community Plan. We engaged with her early to solicit her feedback on the project and discuss what her recommendations were for other people to speak out with. She was invited to the open house. Unfortunately, she wasn't able to attend, but would let us know if there was any other concerns. At that time, we hadn't heard from her as the project progressed. It wasn't until September of last year where Wampa's attorneys reached out to Skog Rasmussen to request a meeting between those parties. At that, it's my understanding that Skog Rasmussen offered to meet with and arrange a meeting with Wampa's board and any participants to engage in further discussion. We did not hear back any dates, and the next thing we received was the motion to participate, intervene on the contested case filing, which was a little shocking after the offer to meet with them in person afterwards. Nevertheless, through October to January, there's extensive correspondence between Wampa and ourselves, which is included as an exhibit to my testimony, where Wampa detailed some of their concerns. Our response to date has primarily been trying to tease out clarifications on the specific information in terms that they are not pleased with the project. As so far it's just been generalities. And so there was a meeting between the parties in February to try to tease out and better understand some of those specific information or terms that may potentially address Wampa's concerns. But unfortunately at that meeting, no specific information or terms were provided for us to consider from a technical perspective or best management practice, or just anything in general. And so they've subsequently participated in our March open house where they asked questions and they were responded to during that meeting. Follow-up emails were sent to folks afterwards asking if there was any further questions or comments, and we have not received any further clarification expressing in more detail how we can potentially resolve their concerns. And that is where we're at today.
Have there been explicit requests to try and reach settlement?
At this time, Chair, with not understanding what their specific concerns are with each aspect, it would be hard to come to any type of form of settlement when we don't actually fully understand what their specific information or terms would be.
Okay, so I take that as a no.
Correct.
Okay. And that's your main basis. Your view is that you haven't been provided enough specifics on the concerns and the possible measures you could take to address them.
Yeah, and even it doesn't need to be proposing the measures. We're happy to propose measures, but we need to understand what the specifics of their concerns are so that we can then potentially put forward technically and commercially reasonable options to potentially mitigate those concerns.
And just so I'm crystal clear, there have been multiple requests to provide that level of specificity?
That is correct.
Is that ongoing, or is that when was the last time when was the last ask?
In February when we met in person, and then as part of, again, the open house in March, if there was any additional clarifying questions that they be provided post that, and we have not received any of that.
But in the 6 months since, you haven't reached out again?
We have sent, again, project updates as part of our newsletters, always encouraging people to reach out. They have not responded and have seemed to be wanting to engage as part of the contested case proceeding as their main approach.
But you haven't made a specific ask or since the March meeting?
No.
Okay. No further questions. Thank you, Ms. Mantinelli, and thanks everyone here. We'll go into recess until tomorrow morning. Same time, we'll start promptly at 9 o'clock. The WebEx will open at 8:30. We'll continue with the third phase, consumer advocates, witnesses, then West Maui Preservation Association, and then we'll have the closing statements, closing arguments, as we said in our prior order. Those should not exceed 5 minutes each for each party participant. So that's our agenda tomorrow. Thank you all again for your patience and perseverance as we've gone over an hour. And I hope you all have a good evening. With
Sorry,
that,
Chair. May I ask a procedural question? With respect to our witnesses who've already testified and been excused, are they free to go, or does the commission want them to call into the WebEx tomorrow just in case the commission has follow-up questions?
I think we need to hold on to the latter for now.
Okay, understood. Thank you.
Thank you. With that, we're going to go into recess.